A week time may be granted for office objection.
ಈ ಪೆರಂಪ್ಟರಿ ಆರ್ಡರ್ ಇದೆ ವಕೀಲ
1 week time.
ವಜಾ ಆಗುತ್ತೆ. ಇಲ್ಲ ವಜಾ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಕಾಸ್ಟ್ ಮೇಲೆ 1 week.
ಕಾಸ್ಟ್ ಗೀಸ್ಟ್ ಏನು ಬೇಡ ನಮಗೆ, ಕಂಪ್ಲೈ ಮಾಡಿ ಇವತ್ತು ಮಾಡಿ, ಇಲ್ಲ ವಜಾ ಆಗುತ್ತೆ. ಎಸ್, but now you have time till the evening ಮಾಡಿ.
25 ಸುಜೋಗ್ ಇರ್ಲಿ.
ಇದು ಅಷ್ಟೇ ಪೆರಂಪ್ಟರಿ
138 proceedings are 138 proceedings from the last come in December.
ಪೆರಂಪ್ಟರಿ ಆರ್ಡರ್ ಇದೆ, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂತ.
Please madam,
ಇವತ್ತು ಮಾಡದೇ ಇದ್ರೆ ವಜಾ ಆಗುತ್ತೆ. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತಾ ಇದ್ದೇನೆ.
I'll have in course of the day, please.
ಮಾಡಿ. ಎಸ್,
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕ್ಬೇಕು. ಅಪ್ಡೇಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. 26 ಚೇತನ್ ಡಿಟಿ.
Appear for petitioner minutes, minus for compliance 2 weeks time may be granted minutes. There's some certified copies is applied.
ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್
ಅಲ್ಲ ಮೇಡಮ್ 26.
26.
ಒಂದ್ ನಿಮಿಷ. ಈಗ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಯಾವ್ದು? 25 ಅಲ್ಲ 25 ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ಇದಕ್ಕೇನಾಗಿದೆ? ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಇದು ಪೆರಂಪ್ಟರಿ ಆರ್ಡರ್ ಇದೆ. It will be dismissed. Okay.
Minutes 2 weeks. Final certified copy is applied.
It will be dismissed today. After you get the certified copy, you get it restored.
Kindly pass over, my lord. Get the instruction.
Next,
Kindly pass over.
27 ಪ್ರಸನ್ನ ಕುಮಾರ್.
Non-amendment of cost title ಅಂತಿದೆ. Pass.
Minutes, I'm appearing for petition minutes. Last 18 June ಗೆ amended cost shall file ಮಾಡಿದ್ದೇವೆ ನಾವು.
ಇದು ನೀವು ಇದ್ರಲ್ಲಿ ಮಾಡ್ಬಿಡಿ.
ನಮ್ಮ ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಬೇಕು, ಅದನ್ನ ಮಾಡಿ.
ಸಿನೋಸಿಸ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ, ಅದನ್ನ ಒರಿಜಿನಲ್ ಇದ್ರಲ್ಲಿ ಮಾಡಿ.
ಇವಾಗ
ನಾವು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಮಾಡಿ.
ಮಾಡಿ ಇವತ್ತು ಮಾಡಿ ಪಾಸ್.
28 ಅನೀಫ್ ಎಚ್, ಅನೀಫ್ MH.
withdraw memo.
Learned counsel for petition filed seeking permission to withdraw the petition.
Trial court will be.
As the matter has become infructuous, in the light of the same, petition is dismissed as withdrawn for having become infructuous. Yes.
30 Mahadeva RK.
No representation as the last sentence, a week's time granted to comply, to do the needful, full stop. If needful is done, issue notice to respondent number 8, returnable by 6/8. Full stop. If needful is not done, so if steps are not taken, list on 8/7 for passing necessary orders as against respondent number 8. Yes.
Small submission.
ನಡುವೆ ಮಾತಾಡೋ ಹೋಗಿಲ್ಲ. ಆಮೇಲೆ ನಾನು ಕಾಲಿಂಗ್ ಆದ್ಮೇಲೆ ಹೇಳಿ.
ವರದರಾಜನ.
Yes.
But 29 ಅದೊಂದು ಮಿಸ್ ಆಯ್ತು. 29 ವರದರಾಜು.
ಈಗ 29 ಅಲ್ವಾ? 28 ಮೆಮೊ ಹಾಕಿದ್ರು ಅಲ್ವಾ? ಆಯ್ತು. 29 ಅಲ್ಲಿ ಒಂದು ವಾರ ಕೊಟ್ಟೆ, 6-8 ಅಂತ ಹೇಳಿದೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 8 ಅಂತ ಆಯ್ತು ಇದರಲ್ಲಿ.
ಈಗ ಮೆಮೊ ಆಫ್ ವಿಡ್ರಾವಲ್ ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ರು?
28
ಆಯ್ತಾ? 29 ಕಾಲ್ ಮಾಡಿದ್ರಲ್ಲಿ, ಇವಾಗ 30 ಮಾಡಿದ್ರಿ. ಮತ್ತ ಅದ ಹೇಳ್ಬೇಕಲ್ಲ ನನಗೆ. ಈಗ ಹೇಳಿದ್ದು 13 ಅಲ್ಲಮ್ಮ. ಓಕೆ, ಈಗ ಹೇಳಿ 29 ಕಾಲ್ ಮಾಡಿ. ಎಸ್, ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು ಗೊತ್ತಾ? ಪಾಸಿಂಗ್ ನೆಸೆಸರಿ ಆರ್ಡರ್ಸ್ ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 8 ಅಂದ ನೋಡಿ, ಅದ್ರ ಬದಲು 2 ಆಗುತ್ತೆ. ಎಸ್, ಈಗ 29. ಈಗ ಅದನ್ನ ಸೇಮೇ ತಗೊಳ್ಳಿ. ಈಗ ಅದ್ರಲ್ಲೂ ಕೂಡ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು. ಸೇಮ್ 6/8 ರಿಟರ್ನಬಲ್ ಬೈ, 8/7 ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಆಸ್ ಅಗೇನ್ಸ್ಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 8 ಆಗುತ್ತೆ. ಇಂಟ್ರಿ ಮಾಡ್ರೆ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಎಸ್, ಕರೆಕ್ಟಾ? ಸರಿ.
31
ಯಾವ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರುತ್ತೆ ಅದ್ ಮಾತ್ರ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ನೀವು ನಿಮ್ ಕಡೆಯಿಂದ ಒಂದು ಕೊಡ್ಬೇಡಿ.
31
Appearing for the respondent number 2 in this respondent, my lord. The respondent is seeking for release of amount.
Heard ಏನಿದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ರಿಲೀಸ್
It
ಆಫ್
was disposed on 2019, my lord. The order was challenged by the petitioner before this honorable court, my lord. Which was dismissed for non-prosecution, my lord.
Criminal
But as the some amounts was deposited by the petitioner, my lord. That has to be goes to the respondent, my lord.
ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ ನನಗೆ.
The petitioner was deposited the some amount, my lord, in this.
Was dismissed for non-prosecution, right?
Yes, my lord.
Okay, ಯಾರು ದುಡ್ಡು
Some
ಕಟ್ಟಿದ್ದಾರೆ?
amount has been deposited by the petitioner.
ಪೆಟಿಷನರ್ ಕಟ್ಟಿದ್ ನಿಮ್ಗೆ ಯಾಕೆ ಕೊಡ್ಬೇಕು?
That is maintenance order, my lord. That was challenged before this honorable court.
ಆಯ್ತಾಯ್ತು, ಅವ್ರು ಬರ್ಲಿ, ಅದ ಸೈಡ್ ಬರ್ಲಿ. ಎಸ್, ಪಾಸ್ವರ್ಡ್.
And there are no objections also there.
ಸಂತೋಷ ಅವ್ರಿಗೆ. If they don't have any objection, I am also having no objection. ಕೊಡ್ತೇನೆ. Let him be present. ನೋಡೋಣ ಸೆಕೆಂಡ್ ರೌಂಡ್ ಅಲ್ಲಿ ಬರ್ಲಿ.
ಅವ್ರು ಬರ್ತಾ ಇರಲ್ಲ ಅಂತ ಹೇಳಿನೇ ಅವ್ರು ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತಾನೆ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಏನಾದ್ರು ಮಾಡಿದ್ರೆ
ಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳಿದ್ದಾರೆ.
ಕೊಡಿ, ತೋರಿಸಿ ಅದನ್ನ.
ಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Heard on I1 of 25. This application is filed by respondent with a prayer to release the amount in deposit to stop learned counsel for
Lordship, and same may be transferred to the respondent account, my lord.
ಯಾವಾಗ್ಲೂ ನಮ್ಮಲ್ಲಿ ಇವಾಗ ಅಕೌಂಟಿಗೆ ಹೋಗುತ್ತೆ.
ಅದು ಆರ್ಡರ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಮತ್ತೆ ಆರ್ಡರ್ ಮಾಡಿಸಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅವ್ರು ನಿಮ್ಗೆ ರಿಲೀಸ್ ಆಫ್ ಮನಿ ಅಂತಂದಾಗ ದೇ ವಾಂಟ್ ಯು ಟು ಪ್ರೊಡ್ಯೂಸ್ ಆಲ್ ದ ಡೀಟೇಲ್ಸ್ ಆಫ್ ದಿ ಅಕೌಂಟ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಕೇಳ್ತಾರೆ ನಿಮ್ಗೆ.
Yes, my lord. I have
ಫರ್ನಿಶ್
produced
ಮಾಡಿದ್ರೆ ಮಾತ್ರ ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ. ಇನ್ ಮಂತ್ in deposit which is made by petitioner as per order dated so and so ಅಂತ ಹಾಕೊಳ್ಳಿ ನೋಡಿ. Yes. ಆಮೇಲೆ the learned counsel for petitioner has made an endorsement on the presentation form that he has no objections to release the amount, said amount. This petition was filed by the husband,
Yes, my lord.
a petitioner by the petitioner husband. ಯಾವ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಿ ಇವರು? Please to set aside the order dated, challenging the order dated 11/9/2017 in criminal miss 393 of 2015 on the file of CJM Bangalore Rural District, Bangalore. ಎಲ್ಲಿದ್ದು ಡೇಟ್ ಆರ್ಡರ್ ತೆಗಿರಿ? 11/9/2017. ಆರ್ಡರ್ ತೆಗಿಯಪ್ಪ ಇಲ್ಲಿ. ನೀನ್ ಹೇಳಮ್ಮ, ಡೇಟ್ ಹೇಳಮ್ಮ. 11/9/17. $393 of 15 ಅಲ್ಲಿ. $11/9/17. The certified copy. ಕ್ಲೋಸ್ ಮಾಡಿದ್ರು ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಏನ್ ಮಾಡಿದ್ದಾರೆ? FLW ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. Issuing FLW through SP Bangalore Rural District, Bangalore for recovery of the maintenance amount due system. while granting interim order, comma, ಕೊಡಿ. The petitioner was directed to deposit IA ತಗೊಳ್ಳಿ.
ಐದು ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿ ಐದರಲ್ಲೂ ಆರ್ಡರ್ ಆಗಿದೆ ಸೇಮ್.
ಇದು one of the petition.
One of the petitioner.
Okay. On 22/7/19, as per order dated 22/9/2017. Since the respondent is the wife and the subject matter of the dispute is maintenance, comma, IA 1 of 25 is allowed. The respondent is permitted to withdraw the amount in deposit as per order dated so and so. Yes. ಇದು ಇನ್ನೊಂದು ಏನಿತ್ತು ರಿಲೀಸ್ ಆಫ್ ಇಷ್ಟ ಅಲ್ಲ ಇದು. ಓಕೆ, ಅದು ಇನ್ನೊಂದು ಬೇರೆ. ಎಸ್, ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ, ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದೀರಾ ಯಾವ್ಯಾವ ಡೇಟ್ದು ಡೆಪಾಸಿಟ್ ಬೇಕು ನಿಮ್ಗೆ ಅಂತ?
That I have not stated, my lord, because of NOC wakalat before the legal aid committee. Therefore, I filed this application.
ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಯು ಗೋ ಥ್ರೂ ದಿ ಅಪ್ಲಿಕೇಶನ್,
Please.
ಆಮೇಲೆ ನಮ್ಮ ಫೈಲ್ ನೋಡಿ ಯಾವಾಗ ಯಾವ ಡೇಟ್ ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು,
ಅರೆ ನಮ್ಮ
ಅಂದ್ರೆ ಇನ್ನೊಂದು ಫರ್ದರ್ ಡೀಟೇಲ್ಸ್ ಅನ್ನ ಹಾಕುವಂತೆ.
ವೈಫ್ ಬಂದು ಲೀಗಲ್ ಏಡ್ ಸರ್ವಿಸ್ ಕಮಿಟಿನ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ರು. ದೆನ್ ವಿ ಫೈಲ್ಡ್ ದ ಅಪ್ಲಿಕೇಶನ್.
ಅವ್ರು ಯಾರೇ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು ಆ ಫೈಲ್ ಅನ್ನು ನೋಡ್ಕೊಳ್ಳಿ ನೀವು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ. ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ,
ಇದೊಂದು ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ಅಷ್ಟೇ.
ಯಾರು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಇದನ್ನ ಪಾಸ್ವರ್ಡ್ ಮಾಡಪ್ಪ, ನೀವು ನೋಡ್ಕೊಳ್ಳಿ.
Please.
ನಮ್ಮ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಅವ್ರು ಕರೆದ್ಬಿಟ್ಟು ಇದ್ರಲ್ಲಿ ಎಷ್ಟು ಡೆಪಾಸಿಟ್ಸ್ ಆಗಿದೆ, ಎಷ್ಟನ್ನ ರಿಲೀಸ್ ಆಗಿದೆ, ಒಂದ್ ಸ್ವಲ್ಪ ಒಂದು ಕಂಪ್ಯಾರಿಟಿವ್ ಟೇಬಲ್ ತರ ಹಾಕೊಡ. ಎಸ್, ಪಾಸ್ವರ್ಡ್ ಇಲ್ರಿ, ಯಾವಾಗ್ಲೂ ಏನೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು ಫಸ್ಟ್ ನೀವು ಫೈಲ್ ಅನ್ನ ನೋಡ್ಕೋಬೇಕು. ಯು ಶುಡ್ ಹ್ಯಾವ್ ಆಲ್ ದ ಇನ್ಫಾರ್ಮೇಶನ್ ಅಂಡ್ ದೆನ್ ಯು ಶುಡ್ ಮೇಕ್ ಅ ಸಬ್ಮಿಷನ್. ನಮಗ್ ಕೆಲಸ ಹಚ್ಚಿ ನೀವು ಸುಮ್ನೆ ನಿಂತ್ಕೊಳ್ಳೋದಲ್ಲ. ಎಸ್, ಪಾಸ್ವರ್ಡ್ ಯಾವ್ದಿದು? 31?
Yes, madam.
32. You just go through the file. ನಮ್ಮ ಇವ್ರಿಗೆ ಕರ್ಸಪ್ಪ ಅದನ್ನ.
Pending. Sachin BS.
So I appear for the petitioner.
My lord, on submission, copy of the IA is not served to me. Without serving copy, a person has filed IA.
Sir, ನಾನು IA ಹಾಕೇನ sir.
Vacating.
Vacating ಯಾರು ಹಾಕ್ತಾರೆ?
My lord,
ನಾನು ಹಾಕಿಲ್ಲ.
state has filed.
ನನಗೆ ಕಾಪಿ ಸರ್ವ್ ಆಗಿಲ್ಲ.
ವಕೀಲ್ರೆ, is the vacating of the order is going against you? ನಿಮ್ಮ ಮೇಲೆ ಇಂಟ್ರಿ ಮಾಡೋದು
ಗೊತ್ತಾಯ್ತು. I was
ವೆಕೇಟ್ ಆದ್ರೆ ಏನಾದ್ರೂ ತೊಂದ್ರೆ ಆಗುತ್ತೆ?
ಇಲ್ಲ. I was under the impression that a person has filed IA.
ಅದಕ್ಕೆ ಪ್ರತ್ಯಕ್ಷ ಕಂಡರು ಪ್ರಮಾಣಿಸಿ ನೋಡು ಅಂತ ಹೇಳೋದು. ಎಸ್.
Lords, the state, my lords, has filed an IA for vacating. Lords, if I can, my lords, a date may be fixed for final hearing. Next week, my lords may fix it. We are ready to go, my lords,
All
with the matter.
the learned counsel for petitioner, respondent number 2, as well as learned SCGP for respondent number 1 present. At the request of learned counsel for petitioner list on the date.
My lord, one submission. Connected case and counter case. Connected case criminal petition 6664/2022 is also pending.
ಕೊಡಪ್ಪ ಒಂದು ಸ್ಲಿಪ್ ಕೊಡಿ. ಹೇಳಿ, ಡೇಟ್ ಹೇಳಿ.
666.
17 when this matter along with ಅಂತ ಹಾಕಿ ಅವ್ರು ಕೊಡೋ ಸ್ಲಿಪ್ ತಗೊಳ್ಳೋಣ.
22 please.
17 ರೆಡಿ ಇದ್ದು ಬಿಡಿ. Correct.
Top of the list matter, serial number 1. Mir,
Penny for petitioner, my lords.
Serial number?
One.
One, my lord.
One.
WP 980023 na?
Yes, my lord.
Okay.
First matter is from accused number 1, accused number 2. Second matter is from accused number 1.
Yes, yes. Yes.
My lord, brief introduction about the parties, my lords. Before this. I am accused number 2 and I am a landlord.
ಇದನ್ನ ಆನ್ ಮಾಡಿ. Okay. Yes.
My lord, I am accused number 2 and I am a landlord and I have a land of 1 acre 1 cent at Manjeshwara Taluk, Kasaragod district, Kerala state. My lord. Accused number 1 is an agent of complainant, my lords. Accused number 2 and 3 are the buyers of the property from me. Accused number 2. Accused number 3 and 4 are the buyers of the property from accused number 2. My lords, FIR is registered on 21st/10/2022, my lords, which is at page number 41, my lords. In the duration,
ನೀವು ಸೆಕೆಂಡ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ
I'm-
ಮಾತಾಡ್ತಿದ್ದೀರಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಪೆಟಿಷನ್ 2116.
2116.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ
I'm for one, my lords. One, serial number 1, 9880.
WP ಕೂಡ. Yes, page
Page number 41, FIR is there, my lord. In column number 3, my lord.
Page 14 ನಲ್ಲಿ FIR.
My lord, column number 3, offense from 30th July 2014, 30 July 2014 to 29 January 2021 ಅಂತ ತೋರಿಸ್ತಾರೆ ಸ್ವಾಮಿ. This is a span of 6 years. My lord, in the 2014, my lords, there is an agreement signed between A1 and A2. A1 signs on behalf of complainant, my lords. A1 signs on behalf of complainant, my lords. My lords, in its own complaint copy, my lords, it is at the page number 34, my lords, complaint copy. Page number 34, in complaint copy 3, page number 3. Right?
Yes.
My lord, paragraph number 6, my lord, last paragraph 6. May permit to read out, my lord.
Yes, please.
That due to personal inconveniences, the complainant was not in position to travel India immediately, and during the discussion over the phone, accused number 1 suggested to the complainant that since accused number 2 is traveling to India on 26/7/2014, it would be better to request accused number 2 enter into an agreement with accused number 1.
Yes.
But this is the admission of complainant itself. Complainant was supposed to fly along with accused number 2 to India and execute the agreement in India. Accused number 2 flies to India from Dubai. Accused number 2 flies to India from Dubai. Complainant stays there itself. He says, accused, you go, I will come back, and he stays. Complainant stays himself, and he says that complainant says that due to the inconvenience of the complainant, he says accused number 1 to execute the agreement on behalf of complainant. That agreement is appended, my lord, in page number 24. This agreement is signed. A1 signs agreement with A2 as per instructions of complainant, my lords. Complaint ಅವರೇ ಹೇಳ್ತಾರೆ ನನ್ನ ಪರವಾಗಿ ನೀ agreement ಮಾಡಿ ಅಂತ. So the agreement is signed, my lords. Agreement is also appended, is there on page number 24, my lords. This is not disputed, my lord. My lord, in page number 26, now there is a paragraph number 3B, my lords. Paragraph number 3B.
Of agreement.
Agreement, my lords. Agreement ಅಲ್ಲಿ.
Yes, 3B.
It may permit to read, my lord. It is agreed that the sale deed is to be executed and registered on or before 30th November 2014. Agreement ಅಲ್ಲಿ A1 and A2 ಮಧ್ಯೆ ಏನ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದೆ ಅದರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಮೆನ್ಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಇಟ್ ಈಸ್ ಅಗ್ರೀಡ್ ದಟ್ ಸೇಲ್ ಡೀಡ್ ಟು ಬಿ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಅಂಡ್ ರಿಜಿಸ್ಟರ್ಡ್ ಆನ್ ಆರ್ ಬಿಫೋರ್ 30th November 2014. My lord, the same condition, next paragraph, my lord, on the same 3R. It's at page number 30, running page number 30 and page number 7 of agreement, my lords. May I permit to read, my lord, that small r.
Yes.
My lord, this is very important point, my lord. Why the FIR to be quashed, my lords? That if a party fails to perform, I am a party, my lords, to the agreement. If a party fails to perform his part of the contract as aforesaid and execute the sale deed, then the B party is free to get executed and registered through the process of the court. This is very clear, my lord. If I am not readiness and willingness to perform my part of the agreement, he has got a power to approach the honorable court at Kasaragod, Manjeshwara and get this property executed. They never did. They didn't made any efforts to get the property registered through the process of the court, my lords. Prima facie, one first ground it comes here, my lords. They did not pay the amount. It's acceptable, my lords. They have paid an amount of advance amount which is acknowledged by the A party in the agreement itself, my lords. It is mentioned in the last, my lord, 25 lakhs. It's since he is signed, since A2 has signed,
Yes.
there is a consideration for this agreement, my lords. 25 lakhs is received. We accept that 25 lakhs is received. There is a consideration, valid consideration, my lords. My lord, further again back to the complaint, my lords. My lords, page number 37, paragraph number 13, my lords. Complaint.
Yes.
May I permit to read, my lord? Thereafter, paragraph number 13, my lords. Either complaint ಹೇಳ್ತಾರೆ, my lords. ಇಲ್ಲಿ by 30th November it went, agreement period has completed. In the year thereafter, 22/1/2015, rupees 10 lakhs was paid to accused number 2 and this amount was paid through accused number 1 from the money kept with him by the complainant. Thus by that time the complainant has already made total payment of 1 crore 45 lakhs. My lord, according to agreement, the total sale consideration was 2 crores 84 lakhs. The complainant was not able to arrange the money to get the property registered. As on date of 22 January 2015, he was able to pay only 1.5 crores against 2.84 crores. So he has failed to arrange the consideration. There is a part of the contract, the complainant has failed.
Yes.
My lord, we accept 25 lakhs as received, and this 1 crore 45 is subject to a matter of a civil jurisdiction, my lords, where the honorable civil judge has to verify and as to consider the evidences, admissible evidences and non-admissible evidences. Because in the same complaint, they says that through WhatsApp I have given, through cash I have given. Through cash are all disputed facts, my lords, which has to be trialed by trial court. Because the FIR is registered under 406, 409 and 420. My lord, next submission, my lords. Again, paragraph number 18, my lords.
Yes.
It is submitted, may I permit to read, ma'am?
Yes, please.
It is submitted that on 29/1/2021, the accused number 2, with the help of accused number 1, fraudulently transferred the property to the accused number 3 and 4 only for sum of 16 lakhs. My lord, here this creates the doubt in the mind of every prudent man, my lords. Why the complainant agreed for the consideration of 2 crores 84 lakhs in the year 2014, and in the year 2021 they sells it only for 16 lakhs. Here there's a cloud, my lords, in the complainant itself. My lord, one more submission is, after this complaint is registered, my lords, again in the 2017 an re-agreement is happens, my lords. Both complainant A1 and A2 they appears, they meet in the Dubai, my lord. 1 second, my lord. So excuse, pardon me, my lord. I just. My lord, paragraph number 16
Of the complaint.
of the complaint is,
Yes.
my lord, paragraph number 16.
Yes.
In order to complete cooperation, permit me, to deal with the hope of getting property registered, the name of complaint further paid so and so amount by depositing the same on date 25/10/2017. Again, my lord, they have not approached the court, my lords, to execute. They start making payments. Finally, they says that according to their complaint, they says that 2 crores 40 lakhs they have paid to the accused number 1 and accused number 2. They says, my lords. My lord, finally, on 15, on this complaint, my lords, 15, paragraph number 15. It is submitted that subsequently during 2017, my lord, first agreement was happened on 2014. There was a 2 conditions. If I am not readiness and to willingness to perform, you have a right to go to approach the court and get it registered. They don't go to the court, they don't get registered, they don't do anything, they don't take any action, my lords, against me. Again, they keep quiet from 2014 to 2017, and 2017 they again all the 3 of us we meet in Dubai. May I read to 15, my lords, paragraph 15. It is submitted that subsequently during 2017, the accused number 2 was in Dubai, and in the last week of on June 2017, the accused number 2 informed the complainant that accused number 2 is ready to meet him. Accordingly, complainant and his wife met the accused at Starbucks Coffee Burjumam Center, Dubai. During the conversation, accused changed his tune. Obviously, accused number 2 will change his tune, my lords. I have agreed to get you registered in 2014. You have not done so. Accused as a prudent man, he has changed his tune. There is nothing wrong as a common man, my lord. And further, he made a demand of 4 crores. Obviously, the land value is got changed, my lord, from 2014 to 2017. 4 crores, he says, to complete and engage. My lord, nearly 1.2 crores. Responding when the complainant responded by saying, when this is important, my lords, when the complainant responded by saying that it is unreasonable and unfair, the accused number 2 left the meeting abruptly without any conclusion. Subsequently, after a few days, accused number 2 agreed to renew the agreement on 30/7/2014. Means the 2014 agreement will be renewed again. Subsequently, after a few days, accused number 2 agreed to renew the agreement. Further dated 5/8/2017, my lords.
Yes.
So now here comes two agreement, my lords. One is 2014 agreement and one is 2017 agreement. My lord, even after renewing the agreement, the complainant does not get the property arranged, does not arrange the consideration amount and get the property registered. He says that he has paid 2 crores 40 lakhs in paragraph number 16, my lords, which is denied and disputed, my lords, because all this has to be tested in civil court, my lords. A2, I am A2. I wait until 2019, my lords. They don't take any action against me to specific performance. They have got an alternate remedy. They don't exercise their alternate remedy available. They keep quiet. I get when I get buyer to the property, I sell them to A3 and A4 because the properties are with me only and legal titles are with me. Merely signing the agreement does not transfer the title to the complainant. My lord, this is by all this, my lords. Here, prima facie, we come to know that this is a civil case where money transactions is involved. Dubai, India, and India. In India, Mangalore and Kerala, my lords. My lord, finally, my lord, complaint FIR. What FIR? Mangalore police takes the FIR and register the FIR, my lord. Short summary, I will read out, my lord. FIR under 406, 409, 420, and 34, my lords.
Page number. Page number.
Page number, my lords. Page number is on 41, my lords. My lord, summary is on 44, my lords. 44. My lord.
Yes.
My lord. My lord, summary. My lord, summary for the convenience of and better understanding, my lords. This summary I have breaked it into 4 parts, my lords. I will explain it in 4 parts, my lord. First 3 parts are in civil in nature. 4th part is in criminal in nature, my lords. So first 3 parts I will explain, then I will come to 4th part, my lord. First part, my lords. ಈ ಪ್ರಕರಣದ ಸಾರಾಂಶವೇನೆಂದರೆ ಫಿರ್ಯಾದಿಯರಾದ ಅಬ್ದುಲ್ ಉದಯಾರ್ ಬೆಳ್ಳಿಯಂಕೆ ಎಂಬುವರು ಮೂಲತಃ ಕೇರಳ ರಾಜ್ಯದ ಕಾಸರಗೋಡಿನ ವಾಸಿಯಾಗಿದ್ದು NRI ಆಗಿರುತ್ತಾರೆ. 1980ನೇ ಇಸ್ವಿಯಿಂದ 2017ರ ತನಕ ದುಬೈನಲ್ಲಿ ವಿವಿಧ ಕಂಪನಿಗಳಲ್ಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಹೆಂಡತಿ ಮಕ್ಕಳೊಂದಿಗೆ ದುಬೈನಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತಾರೆ. 1ನೇ ಆರೋಪಿ ಫಿರ್ಯಾದಿಯ ಸಂಬಂಧಿಯಾಗಿದ್ದು, ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಇಸ್ ಎನ್ ರಿಲೇಟಿವ್ ಆಫ್ ದಿ ಕಂಪ್ಲೇನೆಂಟ್. ಊರಿನಲ್ಲಿ ಫಿರ್ಯಾದಿಗೆ ಪರವಾಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದರಿಂದ ಫಿರ್ಯಾದಿಗೆ ಬಾಪ್ತು ಮಂಗಳೂರಿನಲ್ಲಿ ಪಿಳ್ಳಿಯಾರ್ನಲ್ಲಿರುವ ರಿಟ್ರೀಟ್ ನಂಬರ್ 1003 ಫ್ಲಾಟ್ ನಲ್ಲಿ 1ನೇ ಆರೋಪಿ ತನ್ನ ಹೆಂಡತಿ ಮಕ್ಕಳೊಂದಿಗೆ ವಾಸ ಮಾಡಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದಂತೆ 1ನೇ ಆರೋಪಿ ಫ್ಲಾಟ್ ನಲ್ಲಿ 2012ರಿಂದ 2014ರವರೆಗೂ ವಾಸವಾಗಿದ್ದನು. ಫಸ್ಟ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ FIR it says that
ನನ್ಗೆ ಅರ್ಥ ಆಯ್ತದು.
ಆಯ್ತು.
ಇವರು ದುಬೈನಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದಾರೆ, ದುಡ್ಡು ತಂದು ಇವ್ರಿಗೆ ಕೊಡ್ತಿದ್ದಾರೆ, ಇವರು ಅದನ್ನೆಲ್ಲ ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಮ್ಯಾನೇಜ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಸೇರಿರೋ ಫ್ಲಾಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಮೇಲೆ ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಅಲ್ಲಿ ಫಿರ್ಯಾದಿ 2014ನೇ ಇಸ್ವಿಯಲ್ಲಿ ದುಬೈನಲ್ಲಿರುವ ಸಮಯ 1ನೇ ಆರೋಪಿ ಮೊಹಮ್ಮದ್ ಅಬ್ದುಲ್ ಮುಜೀದ್ ಪಿ ಎಂಬಾತರು ಕಾಸರಗೋಡು ಮತ್ತು ಮಂಗಳೂರಿನಲ್ಲಿ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಏಜೆಂಟ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡಿದ್ದವನಿಗೆ ಫಿರ್ಯಾದಿ ಜಾಗ ಹುಡುಕುತ್ತಿರುವ ವಿಷಯ ತಿಳಿದು ಕೇರಳ ರಾಜ್ಯದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ RA20/8B ನಲ್ಲಿರುವ 1 ಎಕರೆ ಜಾಗವಿರುವುದಾಗಿ ಜಾಗದ ಮಾಲೀಕರು ದುಬೈನಲ್ಲಿರುವುದಾಗಿ ಫಿರ್ಯಾದಿಗೆ ತಿಳಿಸಿ ದುಬೈನಲ್ಲಿ 2ನೇ ಆರೋಪಿ ಪಿ ಮೊಯ್ದೀನ್ ಫರಾದ್ ಚಂಗ್ ಎಂಬಾತನನ್ನು ಫಿರ್ಯಾದಿಗೆ ಬಳಿ ಕಳುಹಿಸಿ ಜಾಗದ ಜೆರಾಕ್ಸ್ ದಾಖಲಾತಿಗಳನ್ನು ಫಿರ್ಯಾದಿಗೆ ತೋರಿಸಿ ನಂಬಿಸಿ 2,84,00,000 ರು ಮೊತ್ತದ 1ನೇ ಆರೋಪಿ ಫಿರ್ಯಾದಿ ನಂಬಿಸಿದಂತೆ ಫಿರ್ಯಾದಿಗೆ ಅಡ್ವಾನ್ಸ್ ಆಗಿ 25 ಲಕ್ಷ ಹಣವನ್ನು AED 1,50,000 ದಿರಮ್ಸ್ ನಲ್ಲಿ 2ನೇ ಆರೋಪಿಗೆ ಚೆಕ್ ಮುಖಾಂತರ ನೀಡಿ ಬಳಿಕ ಫಿರ್ಯಾದಿ ವಿದೇಶದಲ್ಲಿ ಇರುವುದರಿಂದ ಜಾಗದ ಅಗ್ರಿಮೆಂಟ್ ಸಂಬಂಧ ಊರಿಗೆ ಬರಲು ಅಸಾಧ್ಯವಾದ್ದರಿಂದ 1ನೇ ಆರೋಪಿ ತಿಳಿಸಿದಂತೆ ನಂಬಿಕೆ ಮೇರೆಗೆ ಫಿರ್ಯಾದಿ ಪರವಾಗಿ 1 ಮತ್ತು 2 ಆರೋಪಿತ ಜಾಗ ಖರೀದಿಸುವ ಬಗ್ಗೆ 2 ಎಂಬ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಿಕೊಂಡಿರ್ತಾರೆ. This is also civil in nature, my lord. Yes. Signing an agreement is not an offense. Yes. Consideration is fixed by the complainant itself.
Yes. Next.
So 50% of the FIR has gone, my lord, in civil in nature. ನಂತರ ಹಂತವಾಗಿ AED 3,29,000 ದಿರಂ ನಲ್ಲಿ ರು 56,96,000 ಎರಡನೇ ಆರೋಪಿ ಫಿರ್ಯಾದಿ ದುಬೈನಿಂದ ತನ್ನ ಮನೆಯಿಂದ ಹಳ್ಳಿಯವರೆಗೆ ಬಂದು ಮನೆಯಲ್ಲಿ ಎರಡನೇ ಆರೋಪಿ ಜಾಗದ ಬಾಕಿ ಇರುವ 25 ಲಕ್ಷ ನಗದನ್ನು ಹಾಗೂ ಒಂದನೇ ಆರೋಪಿ 1,10,000 ಎರಡನೇ ಆರೋಪಿಗೆ ಪಾವತಿಸಿದರು. This is also money transaction, my lords, civil in nature. Finally, my lord, fourth part of the FIR, where the above three part of the FIR is given a criminal color in this paragraph, my lords. ಒಂದನೇ ಮತ್ತು ಎರಡನೇ ಆರೋಪಿತರು ಫಿರ್ಯಾದಿಯನ್ನು ವಂಚಿಸಿ ದುರ್ಲಾಭವನ್ನು ಅಕ್ರಮವಾಗಿ ಪಡೆಯುವ ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಮಾರಾಟ ಮಾಡಲು ಇಚ್ಛಿಸಿದ ಜಾಗವನ್ನು ಫಿರ್ಯಾದಿ ವಿನಂತಿಸಿದರು. There is no notice served on us, my lord. There is no notice from the complainant side or summons from the court side. ವಿನಂತಿಸಿದರು, ನೋಂದಣಿ ಮಾಡಿ ಕೊಡದೆ ಹಣವನ್ನು ಕೇಳಿದ ಫಿರ್ಯಾದಿಗೆ ಬೆದರಿಸಿ ಹಣವನ್ನು ವಾಪಸ್ ನೀಡದೆ. This is very important, my lord. ಫಿರ್ಯಾದಿಗೆ ಬೆದರಿಸಿ, there is a threat to the complainant without returning the money. ಫಿರ್ಯಾದಿಗೆ ಮಾರಾಟ ಮಾಡುವುದಾಗಿ ತಿಳಿಸಿದ ಜಾಗವನ್ನು ಮೂರನೇ ಆರೋಪಿಗೆ ಮೊಹಮ್ಮದ್ ಶರೀಫ್ ಮತ್ತು ನಾಲ್ಕನೇ ಆರೋಪಿ ಫಾರೂಕ್ ಹುಸೇನ್ ಎಂಬುವರಿಗೆ ಮಾರಾಟ ಮಾಡಿ ಫಿರ್ಯಾದಿ 2,40,00,00,000 ಹಣವನ್ನು ನಷ್ಟವನ್ನುಂಟು ಮಾಡಿರುವುದಾಗಿ ಎಂಬುದಾಗಿದೆ. my lord, ಇದರಲ್ಲಿ ಎಲ್ಲೂ ವಂಚಿಸಿದ್ದಾರೆ ನಮಗೆ ಅಂತ ಹೇಳಿಲ್ಲ, my lords. Criminal breach of trust. This is not even breach of contract, my lords. Criminal breach of trust is on fourth phase, my lord. When there is no readiness and willingness, when there is breach of contract, after that breach of trust comes, my lord. To breach of trust, there are certain essentials, my lords. That essentials are not found in the complaint and FIR, my lords. One is there must be an valuable security, my lords, of complainant legal rights, and complainant has entrusted some property to the accused number 2. There is no essentials, my lord. For essentials, my lord, I'm relying on this. For convenient, I've flagged them.
Yes.
My lords, in this judgment, all the three provisions has been detailedly analyzed and essentials ingredients have been explained, my lords. Page number 140, my lords, in the same judgment, page number 140. Paragraph number 27, my lords. The accused must be entrusted with property. There are, for criminal breach of trust, there are 4 essentials. The complainant has not given me any property, my lords. He has not entrusted any property. Second, 3B, my lords. 3B, or of any legal contracts. Keyword is of any legal contracts, my lords. There is no legal contracts, my lord, because what the contract agreement is there, it has already expired, and it has the validity of agreement has already gone. On the date of FIR, the complainant has to show that there was the existence of a legal contract.
Yes.
That is one of the essentials. So when the complainant fails to show there was a legal contract, this provision, section 405 goes, my lord. When 405 goes, 406 punishment for breach of trust also collapse, my lords.
Yes.
Second is, my lord, 409. 409, I am not an agent, my lord, for complainant. So that provision does not applies to me, my lords, A2. Because 409 reads as, the accused number 1. 409 is, may permit read, my lord. 409 reads as criminal breach of trust by public servant or banker or merchant or agent. I am not an agent. A1 is an agent of complainant.
ಅವ್ರ ಬಗ್ಗೆನೇ ಹೇಳ್ತಿರೋದು.
ಅದೇ ನಮ್ದಿಲ್ಲ ಸರ್.
ನೀವು ಅದ್ರ ಬಗ್ಗೆ ಚಿಂತೆ ಮಾಡಬೇಡಿ.
ಅಲ್ಲ ನಮ್ದು ಅದು ಹೋಯ್ತದು. Next comes 420, my lords. For 420, essentials of 415 has to be fulfilled, my lord. In the same judgment, it's been read out, my lord. Again, there must be dishonest, my lord. From the beginning, I say something, but which I intended not to do that. ನಾನು ಹೇಳ್ತೀನಿ ನನ್ನ ಮನಸ್ಸಲ್ಲಿ, ಬಟ್ ನಾನು ಅದು ಮಾಡಬಾರ್ದು ಅಂತ ಇರುತ್ತೆ. ಅವಾಗ ಅಷ್ಟೇ ಚೀಟಿಂಗ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಐ ಆಮ್ ರೆಡಿ ಟು ಡೂ, ಐ ಆಮ್ ರೆಡಿ ಟು ವಿಲ್ಲಿಂಗ್, ಐ ಅಕ್ಸೆಪ್ಟ್ ದ ಕನ್ಸಿಡರ್, ಐ ಆಮ್ ರೆಡಿ ಟು ವಿಲ್. ಸೊ ಹಂಗಾಗಿ ಆಸ್ ಅಬ್ಸರ್ವ್ ಬೈ ದಿಸ್ ವಿಜಯ ಸಾರಥಿ ಕೇಸಲ್ಲಿ ಅಗೇನ್ ದ essentials is made out, my lord. A person must commit an offense of cheating under 415 ಅಂತ ಹೇಳ್ತಾರೆ my lord. 420 offense ಆಗ್ಬೇಕಂದ್ರೆ 415 ಇರಬೇಕು ಅಂತ. Essential ingredient of cheating is deception of a person, fraudulent or dishonestly inducing the person to deliver any property. To consider that person shall remain, intentionally inducing the person to do or omit to do anything which he would not omit if he so deceived that which act omission causes like to damage, harm, so and so. Fraudulent and dishonest is essential, my lord. ಇಲ್ಲಿ ನಾವು ಯಾರು we are not fraudulent. 2014 ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಟ್ವಿ, ಅವ್ರು ಅರೇಂಜ್ ಮಾಡ್ಕೊಳಕ್ ಆಗ್ಲಿಲ್ಲ. Again 2017 we agreed for re-agreement, again they did not do. Under 405 they did not show the legal agreement. My lord, more above all this, my lords, there is a civil case filed in Kasaragod, my lord, OS 27 of 2021, my lords. My lord, I'm relying on one more judgment, my lord. In this says that a civil case cannot be given a criminal touch. In this case, Paramjit, this is by this is the latest judgment, my lord, our own Chief Justice and 2024 decided matter, my lords. Here, all the cases, primarily Paramjit Batra was the state of Uttarakhand was analyst, my lords. May I read the bold portion, my lords? Flag. A complaint disclosing civil transaction may also have a criminal texture, but the High Court must see whether a dispute which is essentially of civil nature is given a clock of criminal offense. In such situation, if civil remedies is available, is in fact adopted as has happened in this case, the High Court should not hesitate to squash the criminal proceeding to prevent abuse of process of the court. My lord, for them civil remedy is still available, my lords. My lord, we have no objection to condole the delay. If they file the 2017 agreement or 2014 before the Kasaragod court, we commit before this honorable court that we will not object for the condonation of delay. Let them file that. There is an alternate remedy. There is an alternate remedy to recover the money, but not by arm twisting like filing this case, my lord. They have an alternate remedy of civil court. They have not even. My lord, one case is been filed on the same transaction, which is numbered as OS 27, my lords. The outcome of OS 27 of 21 is not known to us, my lords. That complainant has to clarify subsequently. The information what we got is, my lord, even that got dismissed, my lords. So 21 ಅಲ್ಲಿ ಅದು OS 27 21 ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. ಇಮಿಡಿಯೇಟ್ ಪಕ್ಕದ ಜಿಲ್ಲೆಗೆ ಬರ್ತಾರೆ ಸ್ವಾಮಿ, ಕೇರಳದಿಂದ ಪಕ್ಕದ ಜಿಲ್ಲೆಗೆ ಬರ್ತಾರೆ, ಮಂಗಳೂರಿಗೆ ಬಂದು FIR ಫೈಲ್ ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. This I don't want to say as a forum shopping, my lords, but the conduct of complainant seems to look like a forum shopping. What they could not do at Kerala, Honorable Kerala High Court of Kerala jurisdiction, they shift the base to Mangalore to try something before the Honorable High Court of Karnataka.
Yes.
So by this ground, my lords, conclude my. I kindly request to squash the FIR insofar as petitioner A2 is concerned, my lords.
Yes.
Lordship.
Yes.
A1, that's Abdul Majid, your Lordship. Is the husband of the niece of the complainant. Husband of the niece of the complainant. Now, your Lordship, complainant was residing in some Arab country. And A2 was also residing in some Arab country. Both were in Arab countries. That's A2 is the property owner. Complainant was looking out for some properties to invest some properties, Your Lordship. And it was got known to me that the second accused having a property is willing to dispose of his properties situated in Manjeshwara, that is in Kerala state. And both of them from Kerala state. And this first accused was residing in Mangalore. Residing in Mangalore in a flat. Since there was a second accused was willing to sell the property, and the complainant was looking out for purchase the property, this accused intimated to the complainant at Dubai that such and such person, that is accused number 2, is owning a property and he is willing to sell it. You can have the deliberation at Dubai, because both of them staying at Dubai. Now, Your Lordship, I am permitted to read the entire crux of the complaint, Your Lordship. I may be, Your Lordship may take to my petition, Your Lordship. 2116, Your Lordship.
Yes.
ಅದರಲ್ಲಿ internal page, Your Lordship. That is the first page ಅಲ್ಲಿ the complainant and against whom the respondents, that is subsequent purchases, all that have been included. That, Your Lordship, para 2, Your Lordship got it. I'll go through the entire. That the complainant is originally a native of Kasaragod, district of Kerala state, and the accused are all from the same district, and some of them are from Manjeshwara locality and known to the complainant as he hails from Manjeshwara. The first accused, Majid, is the husband of the niece of the sister's daughters of the complainant. So I am the relative to the complainant. He was residing in the flat belonging to the complainant at retreat apartment in Mangalore, and he was a close relative to the complainant, was relying on the first accused person's assistance whenever required. The second accused, Moiddin Farad, is a resident of Manjeshwara. That is your second accused, Manjeshwara, the owner of the property who, and from the native of the village of the complaint. And as he was also working in Ajman, UAE, he too was known to the complainant. The complaint, it is his statement, he was also known to the complainant. The complainant was intending to settle in his village after his retirement and wanted to purchase immovable property in Udyavara village of Manjeshwara Taluk, and the first accused was aware of the said desire of the complainant. That during July 2014, the first accused called the complainant and informed him that, Your Lordship, get it? Second accused is in possession of a property situated in survey number RA number 20/8/B to the extent of 1 acre 1 cents, situated in Udyara village, and he is intending to sell the same. And as the complainant was also aware about the said property, complainant is also aware of the said property, immediately he expressed his desire to meet second accused Moiddin Farad, and accordingly on 24/7/2014, the second accused came to the residence of the complainant at Mankol in Dubai. They met at Dubai only. And after negotiations, the complainant agreed to purchase the above mentioned immovable property, and second accused promised to sell the property to the complainant. During the mutual discussions between the second accused and the complainant, it was agreed that the property is to be sold to the complainant for a total consideration of rupees 2,84,82,000. On that day, the second accused requested the complainant to make an advance payment, as he was in shortage of the funds to get the release of his equipment, as the same was before the customs authority pending clearance, and he was incurring demurrages charges. He promised the complainant that he will be going to India within 2 days and will prepare the agreement for sale. Believing the second accused, the complainant made a portion of the sale consideration of a sum of, Lordship, is it visible, your Lordship?
Yes, yes.
Light ಇಲ್ಲ ಅದಕ್ಕೆ ಕೇಳಿದೆ ನಾನು.
ಒಂಚೂರು ಪರ್ದೆ ತೆಗೆದುಬಿಡಪ್ಪ ಅಲ್ಲಿದು. ಹಾ, ಎಸ್.
ನಮಗೆ ಇಲ್ಲಿ ಇದ್ರದ್ದು ಸ್ಕ್ರೀನ್ ಲೈಟ್ ಕಾಣ್ತಾ ಇದೆ.
Yes.
The portion of the sale consideration of a sum of rupees Arab dinar 1,50,000 equivalent to Indian rupees 25 lakhs through a check drawn on Abu Dhabi Commercial Bank. Your Lordship, note it. The transaction taken place at Dubai. Valid Street branch, Dubai, dated 24/7/2014. The second accused encashed the check the very same day, the copy of which is enclosed for your reference. So the first transaction has taken place between the complainant and the accused number 2 at Dubai only. Then, your Lordship, that the second accused promised the complainant that he will keep ready all the documents pertaining to the title deeds of the said property, and also promised to prepare the sale agreement once he reaches India. And it was agreed between the complainant and the second accused that the balance sale consideration to be paid over the period of 4 months. That due to personal inconvenience, the complainant was not in a position to travel to India. And during the discussions over the phone, accused number 1 suggested to the complainant that since the accused is traveling to India on 26/7/2014, it would be better to request the accused to enter into agreement with the accused number 1 on behalf of the complaint till the execution of the actual sale deed. Since the accused number is a close relative and confident and working as an agent, this suggestions was made to the accused was agreed for the same, and said the suggestion was made by both the accused 1 and 2 with an ulterior motive deceiving the complainant. Then, your Lordship, thereafter, accused number 2, as per the aforesaid suggestion, entered into an agreement in the respect of the aforesaid property with the accused number 1, behalf of the complaint on 30/7/2014. The amount of rupees 25 lakhs, which was already paid by the complaint through the check to Abu Dhabi Commercial Bank, was shown in the said agreement as advance sale consideration. That after the very next day, that's on 31/7/2014, the agreement was entered on 37. On the 31/7, after the aforesaid agreement, the accused number 2 further demanded a sum of rupees 12,000 dinar, equivalent to 2 lakhs, as part of the sale consideration. The complainant paid the 6,000 dinar by depositing into the cash machine and remaining AD 6,000 by transferring from the account of Alif Ahmad Bilikunyi, his eldest son, into the account of the accused number. So, I have not received any amount so far here. Nothing has been taken. So the transaction directly they have made. The Emirate National Bank FM, and after receiving the same, accused number 2 acknowledged. Your Lordship, kindly note this also. The second accused acknowledged the receipt of the said amount from the complainant.
Yes.
The complaint, next paragraph, the complaint submits that during the first week of the August 2014, he came down to India and visited his native place, and on 9/8/2014, the accused number 2 came to Mangalore, your Lordship, came to Mangalore, and met him at his flat at Retreat Apartment in Mangalore, and in the presence of the wife of the complainant, your Lordship will note it, and accused number 1, that I was also present, and one Muhammad Ibrahim, son of MP Ibrahim, the complaint paid a sum of rupees 25 lakhs in cash to the accused number 2 as a part of the sale contract. Again, in Mangalore, your Lordship pays the 25 lakhs in a flat. The complaint stayed in India till September 11th, 2014. As per the agreement, the complaint was supposed to give an amount of 50 lakhs to the accused number 2, subject to condition that the accused number has to hand over a set of documents pertaining to the property in original to him for verification of the title. However, accused number 2 avoided meeting the complainant till complaint returned UAE. ಅಲ್ಲಿ ಕಾಸರಗೋಡಲ್ಲಿ ಇದ್ದಾಗ ನನಗೆ ಮೀಟೇ ಮಾಡಲಿಲ್ಲ ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ನಾನು ಆಮೇಲೆ ಅದನ್ನು UAE ಗೆ ಬಂದೆ. On 11th September 2000, As complainant had returned to UAE to keep up the payment commitment, he handed over the check and cash total amounting to 50 lakhs by withdrawing cash from his as well as his wife's account to the accused number 1, that is to me. Your Lordship, kindly here it is noticed. With the clear instructions to follow the agreement, hand over the money to the accused number 2. So I only just handing over the, according to the accused number 1, paid the said amount to the accused number 2. So I paid the amount what as per his instructions to him. For the accused number 2, I paid the amount as per the instructions of the complainant. And receipt of the said amount is duly acknowledged by the accused number 2 in the agreement. So that amount also, what he wanted to, only one transaction which he wanted to transfer through me, that also paid, it is acknowledged by the.
Yes.
Then, that immediately after his return to Dubai, complainant received a call from accused number 2 requesting an urgent payment of a sum of rupees 15 lakhs in UAE dirhams to meet his some urgent payment commitment. As the complainant was cooperating in every manner, in order to close the deal by finishing the payments commitments, same day he paid a said amount by depositing an amount of 80,980 dirhams equivalent to 15 lakhs in his aforesaid Emirates National Bank of Dubai account, and his payment was also confirmed by the accused number 2.
Yes.
It is also again it is confirmed by the accused number through WhatsApp message. Thereafter, 8/10/2014, the accused 2 through WhatsApp message to the complainant requested him for payment of AED 50,000 and requested that he will immediately need 30,000 and remaining 20,000 by the end of the October 2014. Accordingly, complainant deposited 30,000 equivalent to the 5 lakhs something and to his aforesaid ENBD account, and again on 31/10/2014 deposited remaining 20,000 dinar amounting 3,26,200 in the accused number said ENDB account as requested by him. These payments are duly acknowledged by the accused number through WhatsApp messages. Subsequently, part of the sale consideration, the complainant has further deposited a sum of rupees 35,000 dinar amounting to 6,07,950 on 27/12/2014 and 6,000 dirham amounting to 1,04,000 on 28/12/2014 and 19,000 dirhams amounting to 3,20,218 on 8/10/2015 to the accused number 2 by depositing his aforesaid ENBD account, and accused number 2 acknowledge the receipt of all the said payment through WhatsApp message. Therefore, on 22/1/2015, thereafter on 21/2/2015, rupees 10 lakhs was paid to the accused number 2, and this amount was paid through accused number 1 from the money kept with him by the complainant. Thus, by the time the complainant has already made total payment of rupees 1,45,075 crores, 75 lakhs and 770,000, 5 lakh, out of total sale consideration of rupees 284 up to 82,000, accused number 2 as aforesaid. So total transaction, whatever it has made, your lordship, what is the amount paid by him, it is reached to the accused number 2. That is the text of the complaint, your lordship said the entire amount has reached to the seller, that's accused number 2. And in the text of the, when the complainant visited India in the last week of January 2015, he conveyed to the accused number 2 through the accused number 1 that he is ready to pay remaining balance and get the sale deed registered in his name. But the accused number 2 was not ready to cooperate and willing to execute the sale deed, stating trivial and flimsy reasons. Later, several times, the complainant tried to contact the accused number 2 directly and through accused number 1, but in vain. After waiting for the accused number 2 response and cooperation to complete the formalities and not being able to meet him, complainant traveled to Dubai on 9th February 2015 as he was switched to new employment. Thereafter, several times the complainant tried to contact the accused number 2, but the accused number 2 was avoiding his call, and even the first accused was also not cooperating. With all this stress and tensions, the health of the complainant got deteriorated. Next para, 15 euros. It is submitted that subsequently during 2017, accused number 2 was in Dubai, and in the last week of 2017, the accused number 1 informed the complainant that accused number 2 is ready to meet him. Accused number ready to meet him. Meet one. Accordingly, the complainant and his wife met the accused. Your lordship note here also. The accused, accordingly, complainant and his wife met the accused number 2 at Starbucks coffee shop in Burjman Center, Dubai. Again, they met at Dubai. During the conversation, accused number 2 changed his tune and deviated from the original agreement and unreasonably demanded 4 crores to complete the deal instead of the agreed total amount of rupees 282 lakhs. That is 1 crore 22 lakhs above, more than the agreed sale consideration. When the complainant responded by saying that it is unreasonable and unfair, the accused number left the meeting abruptly without any conclusion. Subsequently, after a few days, accused number 2 agreed to renew the agreement on 30/7/2014. Further agreement dated 5/8/2000 was made on payment of rupees 50 lakhs through accused number 1 out of the money kept in the complaint with the accused number for the purpose of completing the deal.
Yes.
So second again, in order to prove his complete cooperation in the deal and with the hope of getting the property registered his name, the complainant further paid a sum of rupees 70,000 dirhams and 35,000 dirhams and another 35,000 dirhams amount rupees 12,36,000 by depositing the same to the aforesaid Emirates National Bank of Dubai account of the accused number 2. Therefore, thereafter, on urgent demand from the accused number 2, accused number 1, the complainant has paid AED 50,000 dirhams, an amount of equivalent to 8,84,000 to the accused number 2 through a check. The said payment was duly acknowledged by the accused number 2. Thus, the complainant has paid the total consideration of rupees 1 crore 35,000. In total, a sum of rupees 2 crore 16 lakhs 96,000 as per the rate of the exchange between Indian rupees and UAE dirhams on the dates of payment of the dirhams. As per the current rate, the exchange between the Indian rupees, the total payment of 2 crore 40 lakhs. Several times the complaint has requested accused number 1 and accused to receive the balance amount and execute deed in respect of the property in favor. However, even after the payment of said amount and the complaint was ready and willing to get the sale deed registered by paying the balance amount as per the agreement, the accused was not yet cooperating and ready. Instead of accused number 1, whom the complaint believed that trusted as their own man and agent, colluded, they ganged up the accused number 2 and started behaving in a hostile manner towards the complaint, and complaint was unable to understand the such behavior of first accused number. In spite of receiving 78% of the total consideration, the amount, first and second accused was looking for other prospective buyers and openly started canvassing for the sale. When the complainant learned about news, immediately he got issued publication of Karnataka once. It is submitted on 29/1 to the accused number 1 with the help of the accused number fraudulently transferred the property to the accused number 3 and only for 16 lakhs. All 4 accused colluded with each other. This is the crux of the case, Your Lordship. So my stand, Your Lordship, as a agent, Your Lordship, to the complainant and his being a husband of his niece, to facilitate, Your Lordship, only to see that the sale deed has been completed. I have not received any amount. No amount has been received by me, and the amount is transferred either at Dubai or the amount the transferred at India, that has been also accepted and admitted by the complaint itself. That's all the amount has been reached to the accused number 2, the owner of the property. Now, my submission, Your Lordship, the allegation against me that, Your Lordship, that I have deceived, Your Lordship. A agreement was entered, Your Lordship, in terms of, as my learned friend was pointed out, Your Lordship, the agreement was entered between me. In terms of the agreement, Your Lordship, at no stretch of imagination, Lordship, that the complainant has asked or made an effort to register the original suit immediately thereafter for not coming into the terms of the agreement. They continued their transaction at Dubai they continued the transaction at Dubai. The incident was right from the beginning, Your Lordship, as per the FIR, it is starts from 2014 to 21. They start, we very conveniently made their deals at Dubai. And ultimately, Your Lordship, now the second accused, given to understand that second accused has sold the property to the third and fourth respondent accused. Though allegation is made against me, I am not a party to the such sale agreement or sale deed, Your Lordship, which is entered between the accused number 2 and 2, 3, 4.
Yes.
2, 3, 4, Your Lordship. As a prudent man, Your Lordship, I acted as the agent to the complainant.
Yes.
As prudent man, I acted as the agent to him and I entered into an agreement, Your Lordship. That is no doubt, it is unrolled facts. Now, it is now given to understand, Your Lordship, before filing this FIR, the incident which was taken from 2014 to 2021, a FIR was registered, Your Lordship, at Mangalore CN Crime Police. That is a CN, Your Lordship, crime for police, which don't have the jurisdiction. All the transactions, the property is situated at Kasaragod district. And 80% of the transaction has been taken at between the accused and the complainant at Dubai. The agreement which entered at Kasaragod, the agreement entered at Kasaragod, property situated at Kasaragod, and this Mangalore CN police has no jurisdiction to register the complaint. One aspect. And coming to section 419, Your Lordship, against me, which is now, it does not attach for the reason, Your Lordship, and in terms of the complainant, Your Lordship, none of the ingredients applicable to this case against me. Because it is clearly stated by the complaint, it is who he made the payment to him in all respect to the accused directly, and in turn whatever the amount which I am supposed to pay, that is also acknowledged by the accused. And it is not the case of the complaint that I have not transferred any amount which has handed out to be to the accused number 2.
Yes.
And it is directly, it is this case that all the amount has been reached to the accused number 2. And in a prudent manner, I acted upon as one of the agent, Your Lordship, because since there is no, your agreement was not entered upon and agreement to be entered in my name. But nothing has been further instructed to how to go ahead. Unless his instructions, I can't go ahead, Your Lordship.
Yes.
Because he is the investor to that property. And what are all the terms and talks has been taken place in Dubai subsequent to the agreement, I don't know. Other than what is now stated in the complaint.
Yes.
Then, Your Lordship, now it is given to understand, Your Lordship, this complaint was registered on 21/10/2022.
Yes.
In the meanwhile, the very complainant has filed the suit for specific performance against the accused number 2, making me a party as a defendant number 2. Accused number 1 is the first defendant, me as a defendant number 2, and other 2 purchasers, accused number 3 and 4 as the defendant number 3 and 4. And this suit came to be filed on 5/8/2021,
Yes.
prior to filing of this FIR. I may be permitted to hand over this copy of this plaint, Your Lordship.
Yes.
This has been filed before the jurisdiction at Kasaragod, civil judge, subordinate judge, Your Lordship. And apparently it is proves that, Your Lordship, this by virtue of this plaint, the jurisdiction lies in Kasaragod.
Yes.
Jurisdiction lies in Kasaragod. Then, Your Lordship, no doubt I have made an and in this very suit, the evidence of the, it is given to understand that the evidence of the plaintiffs also recorded by way of affidavit.
Yes.
What is it? Evidence of the at Kasaragod. Now, my submission that, Your Lordship, the very case between the complainant and the accused number 2 made me to suffer only for the reason that I have being one of the relative to the accused complainant.
Yes.
And no ingredient of 419 is attracted as per the terms of the complaint against me. And the now my learned friend has produced a memo, Your Lordship, that other accused for a complainant. Your Lordship, ಅವರೊಂದು ಮೆಮೊ ಹಾಕಿ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. I mean permitted.
Memo ಹಾಕಿ documents.
This is on 12/3/2024, Your Lordship, it is.
Additional documents.
Memo ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ, producing perusal of the
Yes.
above matter is got it. ಸಿಕ್ತಾ?
12/3/21.
Yes.
Huh.
Your Lordship, this is the agreement. One first agreement, Your Lordship, that we entered, that in the agreement, Your Lordship, it is as my learned friend pointed out, the registered to the process of the court, Your Lordship, that one conditions in the both the agreements. And Your Lordship, kindly turn to in the said document at page 14, Your Lordship. Non-judicial stamp paper of Kerala, Your Lordship got it. All these agreements and this sale deed, that is a subsequent sale deed, now he has produced. Now he has produced, Your Lordship. All stands from Kerala state.
Yes.
And this agreement, this sale deed, Your Lordship, now which is in Malayalam date is one other 19/7/2021 entered on, in which sale deed I am not a party at any point of time, and nor does I am any witness to the said sale deed, which is executed by the accused number 2 in favor of the 3 and 4. So where is the question of registering the complaint against me, Your Lordship, under Invoke section 419, Your Lordship? If I have to deceive or anything else are predominantly done, I could have been one of the witness or the party to that sale agreement, sale deed.
Yes.
So in total, Your Lordship, it is as could be understood from the case, Your Lordship, a civil litigation given the motion of criminal nature. I may be permitted to place 2 judgments on this point. Lordship, the first judgment, Your Lordship, in Okay. Sarabjit, your lordship has produced it. Sarabjit, this is one judgment, your lordship. Then another judgment, your lordship, page 4, your side, that is Justice Abdul Aziz and J.B. Pardinwala, Justice, Supreme Court, your lordship. 2022 live law SC 1. I just go through only the head notes, your lordship. The complaint alleged that is the signature on the sale deed has been forged. Later filed civil seeking the cancellation of sale deed. High Court refused to quash the complaint. While allowing the appeal, the Supreme Court said a complaint disclosing the civil transaction may also have a criminal texture. But the High Court must see whether the dispute, which is the substance of the civil nature, is given a clock of the criminal offence. In such a situation, if civil remedy is available and in the fact adopted, the High Court should have quashed the criminal proceedings to prevent abuse of process of the court. This order will not come in the way of this the proper proceedings in the future. In this case, your lordship, he has already approached the court of the civil court for proper relief.
Yes.
So under these circumstances, your lordship, no doubt, your lordship, I have applied for a bail application, anticipatory bail, that has been rejected, your lordship. I have thereafter I filed this petition, your lordship, seeking the quashing of the petition directly, because there is a abuse of process of law. The court has the police station which has no jurisdiction. There is a clear abuse process of law, your lordship, registering the complaint when the incident has taken all the place in Kerala. And I plead your lordship kindly to quash the FIR, your lordship, on its entirety against the accused number 1.
Respond number 2. Complainant. Now with regard to the jurisdiction, and the criminal petition number 2116, the complainant is from the Mangalore. His address is mentioned in the house title. He is residing Ivory Towers, SL Matthias Road, Mangalore 575001. So he is a resident of Mangalore, and checks were given in the Mangalore. Though it is treated by them also, it is some of the amounts, most of the amounts were given in UAE, Dubai. But some of the checks, which was because the complaint is having the bank account in Mangalore. So he is a resident of Mangalore, and the meetings was held in also Mangalore, specifically in para number 9. This is with regard to jurisdiction I am pointing out. Para number 9 of the complaint, it was specifically aware in the complaint that complaint submitting that during the first week of August 2014, he came down to India and visited his native place, and on 9/8/2014, accused number 2 came to Mangalore. Accused number 2, it is very, very clearly mentioned in the para number 9. Accused number 2 came to Mangalore and met him at his flat at a rental apartment in Mangalore, and in the presence of the wife of the complainant, accused number 1 and Mr. Muhammad Ibrahim, son of MP Ibrahim, the complainant paid a sum of rupees 25 lakhs in cash to the accused number 2 as a part of the sale consideration at Mangalore. So with regard to jurisdiction point, now the jurisdiction, as admittedly it was, jurisdiction is before the UAE is also there, Mangalore is also there, and Kasaragod is also, admittedly property in the Kasaragod district. There is 3 jurisdictions are there. The complainant is a resident of Mangalore. He has filed a complaint in Mangalore. Whenever he comes down from Dubai to India, he will stay in Mangalore. And the said flat was given to accused number 1. He is a very close relative of the accused. Accused number 1 is a very close relative of the complainant. Accused number 1 was also residing in the same flat. He is also using that flat. No, the complainant, he is an accountant. It's all his savings. He as an accountant, he earned entire money. He wanted to spend his money to build a house. Now he is residing in Mangalore in a flat. He wanted to, for family house, he wanted to build a house in Kasaragod for his family. Entire money was given to the accused number 2, and some of the money was paid from the accused number 1. I am also giving the chart, which is not disputed by them also. So they are also not disputed that amount was paid, because which of the money which is given to the accused number 1, and it is there in the complaint. Just I am giving the chart. Some of the money was paid to the accused number 1. Some of the money was paid from the accused number 2 directly. Most of the money was paid accused number 2 directly. This is the chart I have made. Date wise I made a chart. Now whether the accused number 1 and 2 they are collided with each other in order to defraud the complainant. That has to be considered. Now, para 6 of the complaint. Now what happened from the initial stage also, they accused number 1 and 2, they are collided with each other. He wanted to travel immediately to India, accused number 2. At that time, accused number 1 suggesting the complainant, ಅವ್ನು ಬರ್ತಾ ಇದ್ದಾನೆ ಇಲ್ಲಿಗೆ, ಈಗ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡಬೇಕು, ನೀವು ಅಲ್ಲಿದ್ದೀರಿ, ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಮಾಡಿ ಅಂತ ಸಜೆಸ್ಟ್ ಮಾಡ್ತಾನೆ. Now, for me also going to the civil court, the problem what happened, I with the good faith, because he is my close relative, the husband of my niece. He has entered agreement on my behalf. I paid entire money to the accused number 2. Some of the money was paid from accused number 1. Some of the money was given to accused number 2. But the agreement was with the due faith, with the bona fide intention, he will be with me. I made an agreement. For that, he has made a suggestion. It was very clearly mentioned in the complaint saying that he made a suggestion. ಅವ್ರು ಬರ್ತಾ ಇದಾರೆ, ಈಗ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡೋಣ, ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಮಾಡೋಣ, 25 ಲಕ್ಷ ಈಗಲೇ ಕೊಡೋಣ, ಇಲ್ಲಾಂದ್ರೆ ಪ್ರಾಪರ್ಟಿ ಬೇರೆಯವರಿಗೆ ಹೋಗ್ತದೆ, ಅದು ಒಳ್ಳೆ ಪ್ರಾಪರ್ಟಿ, ಅದು ನಾವು ಇಟ್ಕೋಬೇಕಂತ ಹೇಳಿ he can induce me. Because of his inducement, I made an agreement with the accused in the name of accused number 1, and accused number 2 is the owner of the property. Now, subsequently, in 2014 is the first agreement, and 2017 is the second agreement. That is, I have already produced the copy. In 2017, accused number 2 is only acknowledging 1 crore 80 lakhs only. Remaining amount he is not acknowledging at all, because that shows that accused number 1 has not paid the money to the accused number 2. This has to be unearthed at the time of investigation. The matter is very premature stage. Now the FIR was lodged and the investigation is not completed. And at the time of investigation, they come before this honorable court. Their antecedent bail is they rejected, and they come up before this honorable court with the prayer to grant the release them on anticipatory bail. That was rejected. Suppressing all those facts, they have filed an 482 petition. They obtained an interim order. Now the investigation was stalled. At this preliminary, kindly see the observation of this honorable court during the period of anticipatory bail. And the accused number 1, accused number our ಏನilla ಅಂತ ಹೇಳ್ತಾರೆ, but this one hold that this is a prima facie case. Page number, my compilation, my lord, he is already pointed out my compilation. Non-compilation and additional document. Accused number 1 lawyer pointed out. Page number 37. ಈಗ ಕೊಟ್ರಿ ನೋಡಿ.
ಇಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡಿ, ಈ ಬಂಡಲ್ citation ಯಾವತ್ತು ಹಾಕಿದ್ರೆ ಹೇಳಿ, ಅದು ಡೇಟ್ ಹೇಳಿ.
Date is 23 at the time of argument. ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಇರ್ಲಿಕ್ಕಿಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. At the time of argument, I have produced that copy. ಈಗ ತೋರಿಸಿದಲ್ಲ, ಈಗ ತಾವು ಈಗ ಇವರು accused number 1 advocate ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿದ್ರು ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಿದ್ದು. ಸೊ ಈ only produced ಅಂತ ಹೇಳಿ ತೋರಿಸಿದ್ರು. ಈಗ 23 2024 12/3 ಈಗ ನೋಡಿ.
Dispensation stay of further document.
It is produced in the open court.
ನಂಗೆ ಅದು ಕೊಡಿ, ನೀವು ಇದು ನೋಡಿ. ನೋಡಿದ
Copy back for copy.
One ನಿಮಿಷ. Acknowledgement. Notification. 12/3. ಯಾವ ಡೇಟ್ ಅಂದ್ರೆ 12/3 ನಾ?
12/3.
15.
ಮೆಮೊ ಅಂತ ಹಾಕಿ ಕೊಟ್ಟಿದ್ದೀನಿ. It is submitted above matter, respond number 2 hereby producing the document for kind partial of this one report. Kindly take this memo on
Physical
record.
copy ಅಂತ.
ಅದು ಓಪನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದು.
ಇದೆ ಈಗಲೇ ನೋಡಿದ್ದೇವೆ. ಇದರಲ್ಲಿ ಸೆಸಿದೆ ನೋಡಿ ಇದರಲ್ಲಿ.
ಈಗ ತಾವು ನೋಡಿದ್ರಿ ಅದನ್ನ. ನಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ ಈಗ.
ಕೊಡಿ, ಇಲ್ಲೇ ಇದೆ ಸಿಗುತ್ತೆ.
15 to 23. ಮೆಮೊ ಇದೆಯಾ?
ಅದೇ ಇರಲಿ ನನ್ನ ಕಾಪಿ. In that I have produced the copy of the anticipated order dated 17 January 2023. The accused number 1 approached this honorable court prior to release him on anticipated bail. This honorable court, after hearing both the parties, rejected the anticipated bail of the accused number 1. Page number 38 ಅಲ್ಲಿ, from starting from para 4. The condition of the petitioner is in page number 37. Learning council, may I read?
Page 38.
38. 37 ಅಲ್ಲಿ starting of their condition. Delay ಇದೆ ಮತ್ತೆ civil in nature ಅದೆಲ್ಲ ಈಗ ಅವ್ರು ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು, that is argued before this also before. The time of bail hearing. The per contra, that is in page number 38. The government that pleaded reply opposing the petition submitted that serious allegations are made against the petitioners for having committed the offences. Petitioner, on behalf of the informant, who is the owner of the land, question entered into an agreement for sale with accused number 2. Accused number 1 and 2 have cheated the informant to 2 crores 16 lakhs 96,470 as mentioned in the FIR. In spite of that, both accused number 1 and 2 colluded with each other and sold the land to the accused number 3 and 4 in order to defraud the informant. He further submitted that the petitioner is in the habit of committing the similar offences, as one more case is registered against him with the Consolidation police station for having committed similar offences. Accused number 1 and 2 have received more than rupees 2 crores 16 lakhs from the informant and cheated him. Under circumstances, petitioner is required for custodial interrogation. Looking to the nature of the offence committed by him, therefore he is not entitled for grant of anticipated bail, hence he prays for dismissal of the petition. Let me consider renew of the rival contention that the reasons. The informant filed the information, first information making a specific allegation that he was paid a huge sum of rupees 2 crores 16 lakhs in favor of the accused number 1 and 2. It is also stated that accused number 1 on behalf of the informant entered into an agreement for sale with the accused number 2, and later he cheated the informant and committed a criminal breach of trust, and again he sold the property to accused number 3 and 4. It is stated that one more case is also registered against this petitioner in Consolidation police station. Looking into the nature and seriousness of the offence, I am of the opinion that this is not a case for pre-arrest bail. Accordingly, I answered the above point in the negative and proceeded upon the following criminal petition is dismissed. So his bail petition is dismissed, saying that there is a prima facie material against the petitioner. After dismissal of the bail petition, he approached this one with the prayer to quash the entire proceeding. Meanwhile, he is obtained the stay order also. In his entire petition, he never mentioned that his bail application was rejected. He suppressed that fact and obtained an interim order before this honorable court. Now, in the same compilation, page number 29, then what happened? Complainant then approached accused number 3 and 4. ನೀವು ಅದನ್ನ ಅಷ್ಟೇ ಅಮೌಂಟ್ಗೆ ಯಾಕೆ ತಗೊಂಡ್ರಿ? ದುಡ್ಡು 16 ಲಕ್ಷಕ್ಕೆ 4-5 ಕೋಟಿ ಬೆಳೆ ಇದನ್ನ ಅದಕ್ಕೆ ಯಾಕೆ ತಗೊಂಡ್ರಿ? ನೀವು ನನಗೆ ಮೋಸ ಮಾಡಿಲ್ವಾ ಅಂತ ಇವ್ರು ಕೇಳ್ತಾರೆ. ಅವ್ರ ಜೊತೆ ವಾಟ್ಸ್ಆಪ್ ಕಮ್ಯುನಿಕೇಶನ್ ಆಗುತ್ತೆ. That has to be investigated at the time. Maybe they may dispute this WhatsApp conversation. It has to be investigated at the time of the investigation. Now investigation is pending. Kindly see page number 29. WhatsApp chat between the complainant and accused number 3. Sorry, accused number 4. This is voice chat. I have made a right. Abdul Bhai, listening to your voice message, I did not know what to reply. I am sad. This is the reply from the accused number 4 in Malayalam. And tense listening to your voice message. tension means it is not for small amount of money. He came to Gulf and with so much of hard work and losing such a big money is a big tension to anyone. In this, let me clear my sake. Let me say from my side, you didn't think otherwise. You said about the registration being done. Sharif came and said, I'm buying a property for in Manjeshwar. I have a shortage of funds. Are you joining as an apartment? Sharif andre accused number 3. 3 ಮತ್ತು 4 ಒಟ್ಟಿಗೆ ಅವರು join ತಗೊಳ್ಳೋದು. Manjeshwar, I have a shortage of fund and you are joining as an partner. Get it to for good rate. The running rate is there is a 5 lakhs%, but we are getting it for 3.5 lakhs%. 1.75 crore I will arrange. 1.75 crore you will arrange. That is almost now to 3 crore 50 lakhs alert. Now sale deed I was produced. 16 ಲಕ್ಷಕ್ಕೆ ಮಾರಿದ್ದಾರೆ. 16 ಲಕ್ಷಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ. This amount there is a money laundering. I saw the land, I liked it. Then my cousin Salim said, our cousin ಅವ್ರ ಹತ್ರ ಹೇಳ್ತಾರೆ, there is some issues in that. UB means the complainant. UB has made some advance in that. I have heard your name before. When Sattar was talking about you, then I called Anarcha. You may ask Anarcha. 1 week before the Anarcha's daughter wedding, I asked UB. UB is your brother-in-law? He said, yes. What is the issue? He replied, there is an issue in buying the, Anarcha means that is accused number 1. There is an issue in buying the subject land. He replied saying, it is okay. If my brother-in-law gets his money back, from his side, it will be clear. Then I called Sharif and Majid to my house and told them that there is, he called accused number 1 and 2 his house. Them that there is this issue. Then I said there is no connection to our deal. Then I said that is not the case. If the advance is received for the property, if I'm getting cleared, we can move. Then they said it will be cleared. It is in that right thing. It should be cleared, etc. And both talked very nicely about the rights and wrongs and said we should not take someone's belongings, etc. And both said we will give back the money. Then Majid started saying some stories. I said this is within your family. I don't want to hear you clear issue. Then he said that as soon as you give the money, we will clear it. Advance protection now clear martin. They have not paid any single rupees to the complainant. Then I asked how is the payment? He said that Farah's portion of the payment should be paid immediately. I said then and agreed. I had to give total rupees 1.75 crores. I paid 75 lakhs immediately and gave a check of rupees 1 crore on the registration day. That day itself, one hundi, hawala, guy came and took the cash money from Majid in front of me to send it to Farah to Dubai. So in order to give it to him, I got 1 month time to clear 1 crore check. On 16th day, I went and gave 1 crore check cash. I don't remember exactly if I got 20 days or 1 month time, but I think 1 month. On 26th day, in fact, 4 days before, I went and gave the cash as I was about to go to Saudi. I went to Majid Bhai's flat and gave the cash. Both of them, Majid and Sharif, appreciated me for giving the cash before the agreed date, saying, gentleman's deal. Normally, people ask more time. You gave the money before date and gave a shake hand to me in appreciation. Then I said, why you are, when you are going to give UB's money, UB means complainant money. Then they said that he is in Dubai. As soon as he comes, he will give his money. This is the fact. This is what happened, Abdul Bhai. There is no issue from my side. I have not asked for time, gave cash, cleared everything. This is what happened. This is actually how our deal happened. Your will be cleared. I was told when Niaz Kaka called only, I came to know that yours is not cleared. As soon as Niaz Kaka called, I called Sharif. When I called Majid Bhai, he didn't pick up the phone. Majid Bhai means accused number 1. Today, Majid Bhai called, but I was sleeping. I was listening to election news and slept. I will call him now during Shohor, Ramadan last night meal. I told Sharif that he has come to native place and at any cost he should be paid and cleared. Then he said there is an issue. His daughter is calling by Dawn and Gundas. When that is clear, he'll be paid. Then I told Niaz Kaka that they are a family. You should talk and clear them. Anyway, we are all have to die one day at a family. It will be good if everything is clear. Abdul Bhai, good willing, God willing. Please see, when I hear from you, you look correct. When I heard his story, I was even more sad when he said that his story. He is telling you made him caught by police. His respect is gone, etc. In that case, there is no point in talking about the past. Abdul Bhai, what I'm saying, you both parties sit down. You seem a lot of youngsters are dying due to corona. Talk to each other and become a good. Don't have to be close, but don't keep grudge. God willing, get cleared. So this is the word from the word from the accused number 4. WhatsApp voice messages. This clearly shows that they are colluded with each other. the agreement made in the name of accused number one, that from the beginning, the inception that they wanted to cheat the complainant. And second agreement was also made, and he wanted to clear 78% of the money was paid, and he is insisted for to give the remaining payment. They are not registered the property in the complaint name, and then sold in 2021, sold the property to accused number 3 and 4. Then I lodged the complaint. So that is clear. There is a cognizable offence was made out against the prima facie case was made out against the accused persons. And moreover, now the very premature stage, whether there is in a civil nature, whether it's in the civil case, you given a color of the criminal color or not, that has to be unearthed at the time of investigation. The matter is before the police. They have to investigate the matter. They have to collect the document. They have to examine the witnesses. They have to examine the accused number 3 and 4, whether they have the paid. Now the property worth of more than 4.5 crores, which was sold to the 16 lakhs. This itself clearly shows that they are colluded with each other and defrauded. Now the accused number, in fact, if accused number he is not genuine, would have cooperated with the complainant to execute the sale agreement. He never cooperated. He said that tomorrow. What tomorrow? I paid almost 2 crores 40 lakhs. My hard-earned money, entire my lifelong savings was spent to the property. And 2 times because of this, my lord, he was underwent bypass surgery. The complaint went on bypass surgery. He was suffered. He is under the state of trauma because of he lost his all life savings. Even single penny rupees was repaid by the accused number 1 or 2.
Yes.
They colluded and they sold the property. This is a fit case for investigation, and this also could dismiss the petition filed by the accused number 1 and 2. This is number the petition. That petition is only with regard to that the matter has to be investigated and even.
Yes. Yes.
Concluding submission. May I, my lord? Concluding submission.
Repeat ಮಾಡಬೇಡಿ.
ಇಲ್ಲ, repeat ಇಲ್ಲ. I will read out the illustration.
Citation. It's only with regard to the citation. Have produced the citation.
Yes.
The investigation will be conducted with regard to even if there is a prima facie material.
Yes.
My lord, I'll just read out the illustrations in IPC 405 criminal breach of trust, my lord. Illustration C and D, I will read out, maybe permitted to read out, my lords. A residing in Calcutta is an agent for Z residing in Delhi. There is an express or implied contract between A and Z that all the sum remitted by Z to A shall be invested by the A according to Z directions. Yes, complainant gives the directions to the A1 to invest this so and so amount in so and so project or property. Z remits lakhs of rupees to A with direction to A to invest in the same in the company paper. In the facts of distinguished. A dishonest disobey the directions if A1
Yes.
If A1 disobeys if A1 dishonestly disobeys the direction of the employment and invest the own money, he will be committed for criminal breach of trust. That's what illustration C says. Next, subsequently, my lords, D is very important, my lords. But if A in the last illustrations, not dishonestly, but in good faith, believing that it will be more for Z advantage to hold share in the Bank of Bengal, disobeys Z direction, that is disobey the complainant direction and buy share in Bank of Bengal, Z instead of buying company's paper, here though Z suffer loss, here though complainant suffer loss and should be entitled to bring civil action, my lords. Illustration says if the complainant suffer loss, he is entitled to bring civil action. That is what the statute says and enactment says.
Yes.
He has to bring the civil action. That's what our submission is, my lords. Article 21 also says same thing, my lords. No person shall be deprived of life and liberty except procedure established by law, my lords. This is a procedure established by law is civil action. So complainant is entitled to take civil action, not criminal action by armed resistance, my lords. By this, our petition may be allowed. And
Article 21 says a fair investigation also. Article 21 says a fair
procedure established
investigation.
by law,
Let the investigation go on.
procedure established by civil action.
Investigation
ನಾನು ನೋಡ್ತೇನೆ civil ಬೇಕೋ criminal ಬೇಕೋ ಎರಡು ಬೇಕೋ
good faith ಅಂತ ಹೇಳಿದ್ರೆ ಅವರು ಹೇಳಿದ್ರೆ there is no good faith at number 1, but there is no good faith at all.
Third argument. ಯಾವುದು Okay. Okay. Fourth ಗೆ ಒಂದಿದೆಯಾ? ಹಾ, 4-7. List on 4-7 for dictating order. ಆ documents ಇದೆ. Yes. ಯಾವ್ದಿದಾಗಿದ್ದು?
Serial number 1, madam.
So, ಯಾವ list ಅದು? ಬೇರೆ list. ಹಾ.
Being spoken to ready ಇದ್ದೀರಾ? Serial number 2. Respondents.
For
Lord, I appear for the petitioner, my lord. Lord, this matter was disposed of, and my lord, subsequently it was carried in an appeal before the Supreme Court, my lord.
Okay.
I don't know,
Yes,
my lord, now
I hear you.
memo.
Take my lords to the third paragraph of the order.
ಇದು ಯೂಸ್ ಮಾಡಿದ್ದ ಆರ್ಡರ್ ಇದು
sir,
ಅಲ್ವಾ?
Justice Natarajan Sahib.
Vandana PLBC.
ಏನಾಗ್ಬೇಕು ಕೆಲ್ರೆ?
ಇಲ್ಲ madam, it's like what has happened is like the court hall, there is no court hall 92. 92 would specifically deal with only civil cases. Paragraph number 3, there's a very specific finding by this honorable court which says the matter has to be referred back to court hall number 92. That is where the issue is. In fact, I've also written to the registrar. I've also filed a memo attaching all of those documents.
ಏನ್ ಆಗ್ಬೇಕಿತ್ತು, ಏನಂತ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಏನಂತ ಮಾಡಿದ್ದಾರೆ?
As of
ಈಗ ನಾವು ಹೊಸದಾಗಿ ಕೋರ್ಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ಲಿಕ್ಕಂತ ಆಗಲ್ಲ. ಹಾ.
Instead of 92, any jurisdictional court would be sufficient, because as on that day when the order came to be passed, there was a notification dated 9/7/2021 which said 92 court hall 92 will have jurisdiction to try all KPID matters. Now the position is 93. Court hall 93 will be the appropriate court. They basically say that 92 is handling only civil cases. 93 is constituted anta ಹೇಳ್ತಾರೆ. My only request is let it be any jurisdictional court
ಅಲ್ಲ,
which handles KPID matters.
ಕೋರ್ಟ್ ಹಾಲ್ ನಂಬರ್ 93 ಇದ್ರದ್ದು KPID ಮ್ಯಾಟರ್ಸ್ ಬರುತ್ತಲ್ಲೇ?
ಹೌದು.
KPIDF.
Please. I have in fact memo which I have attached.
You are very sure?
Please, madam. Page number 5 of the memo that I have actually furnished. And this starts functioning of 92nd edition, which is CCH 93 ಅಂತ ಹೇಳ್ತಾರೆ. That's the reason my humble request is let it be a jurisdictional court which handles KPID matters.
ಈಗ 93 ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಲ್ಲ ನೀವು?
Also, that is the as per the communication dated 25/4/2025. ನನ್ನ ಮೆಮೊ ದಯವಿಟ್ಟು ತಗೋಬಹುದು.
ಮೆಮೊ ಇದೆ ನನ್ನಲ್ಲಿ. ಇದೆ ನನ್ನ.
That's a memo of postings. Other memo I in fact
ಅದರ ಜೊತೆಗೆ ಮತ್ತೆ ಇನ್ನೊಂದು ಮೆಮೊ ಹಾಕಿದ್ದೀರಿ.
25th I've furnished the memo. 25/6/2025. ಅದರಲ್ಲಿ page number 5. Page number 5.
ಇದೆ ಒಂದು ನಿಮಿಷ. Page number 5. ಹಾ. Yes.
So this is the response that is issued by the registrar city civil court dated 25/4/2025. I'll read the relevant portion. With reference to the above subject, I am directed to inform you that Honorable High Court of Karnataka, Bangalore, vide its letter bearing number so and so, dated 31/7/2024, has clarified that all criminal cases under KPIDFE Act 2004 and Buds Act 2019 are to be tried by the courts designated for trial of cases filed under the said Act till start functioning of 91st Additional City Civil and Sessions Judge Court, Bangalore, CCH 93, as requested by you. The letter cited at reference. Therefore, my humble request is let it be forwarded to the jurisdictional court, which has jurisdiction over KPIDFE Act.
Heard learned counsel for petitioner.
Non respondent.
New respondent number
1 to 128.
Who filed this petition?
It is filed by us, my lord.
Is contending that Priyanka Srivatsava's judgment was not complied and they had sought for quashing of the proceedings. The court, while setting aside the referral order, in fact, gave me liberty to go approach the jurisdictional court. That is, at that point of time, CCH 92, by complying with the affidavit requirement. They basically reserved liberty for me.
Okay. Respondents are
The home buyers.
accused persons or they are beneficiaries?
They are the people who invested the money.
Oh, victims. They are the
Please,
victims.
they are the victims.
Learned counsel for respondents.
Please, respond.
Regarding the mistake in the operative portion of the order, wherein comma the case pending before principal city civil and session judge is ordered to be transferred to CCH 92. So stop. However, as per the communication received from the registrar, city civil court, the page number
5.
5.
Page number 5.
5, comma, the cases arising out of KPIDFE Act 2004 and BUTS Act 2009 are to be tried by it is to 92 neither.
90.
Our communication 93 and the hater, they said till starts functioning of
92 court
So and so
hall
ಅಂತ.
court 92 ಇದು court hall 93 ಇದು
please
ಇದನ್ನ ಹಾಕೊಳ್ಳಿ ಇದನ್ನ
92nd additional.
92nd additional city civil and session judge court Bengaluru bracket ಅಲ್ಲಿ CCH 93 first offense the word CCH 92 is corrected as CCH 93.
Please. There's still an element of doubt because it would the communication, that is the registrar's letter itself, till starts functioning of anta ಹೇಳ್ತಾರೆ. One request is
One ನಿಮಿಷ. Criminal cases filed under so and so are to be tried by the courts designated for trial of so and so under this said act
please.
till starts functioning. ಏನು ಅರ್ಥ ಇದರ ಅರ್ಥ ಏನು?
Even I am unable to.
I may, my lord. I may say so, my lord.
At
My lord,
present,
there are-
before whom these cases are pending, these type of cases are handled. You should none go through hage principal city civil and session.
Earlier it was CCH
Please,
1.
lords.
There are 5 designated court halls which were there.
There are more than one court.
Yes, yes, certainly.
Okay.
In fact, in the memo itself, I have actually attached Annexure 1. They have classified based on the court halls. They made it into, if my lords were to kindly see page number 10 onwards of the memo which I had earlier provided. Otherly, based on the court halls, they had made the classification. Court hall 1, court hall 4,
ಯಾವ ಪೇಜ್ ಓದ್ತಿದ್ದೀರಾ?
10, my lords.
Page 10.
That would be the list of cases which were transferred, which were actually scheduled for transfer from the respective court halls to a special court that was actually CCH 92. But though CCH 92 was established,
Is yet to establish and start functioning.
please.
Okay.
So 92 is now established, but they do not handle KPID matters. They handle exclusively civil cases.
Okay. ಹೀಗ್ ಮಾಡಿ ಏನ್ ಸೆಂಟೆನ್ಸ್ ಹೆಂಗ್ ಅಂತ ನೋಡಿದ್ರ replaced ಇಲ್ಲ ಬೇಡ by CCH 93 ಬೇಡ. However, the word CCH 92 is replaced by any of the special courts dealing with the
KPID.
matters coming under ಅದನ್ನ ಹಾಕ್ಬಿಡಿ
KPIDFE.
IDEFE Act 2004 and BUTS Act 2019. Yes.
Good.
ಇದನ್ನ ಕೊಡಿ ಆಮೇಲೆ ಹೇಳ್ತೀನಿ. ಕ್ಲೀನ್ ರಿಜಿಸ್ಟ್ರಿ ಟು ಕರೆಕ್ಟ್ ದ ಸೇಮ್ ಅದೆಲ್ಲ ಮಾಡ್ತೇವೆ ನಾವು. ಸೈನು ಗೀನು ಎಲ್ಲ ಕಳಿಸ್ತೇವೆ. ಎಸ್. ಇತ್ತು ಇದೊಂದು ಸ್ಲಿಪ್.
Parted matters, seal number 33. Chandrasekhar.
ಯಾವ್ದಪ್ಪ serial number?
33, madam.
We have addressed our arguments on the previous statement.
33.
33.
ಯಾರ್ ಮಾಡ್ಬೇಕಿತ್ತು ಇವಾಗ?
Fertilizer company, company is not a made party ಅಂತ. They taken
ಇರಿ ನೀವು ನಾನು ಕೇಳಿಸ್ಕೊತಾ ಇದೀನ ನೋಡಿ ಹೇಳ್ಬೇಕು ನೀವು. ಹಾ. HCGP ಇದು ಯಾರ್ದು? ನಂಗೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಇಲ್ಲಿ. ಮೋಸ್ಟ್ಲಿ ಇದು ನಾನು ಅದು ಅಡ್ರೆಸ್ ಹಾಕೊಳ್ಳಿಕ್ಕೆ ಮಾಡಿರ್ಬೇಕು. ಥರ್ಡ್ ಫರ್ದರ್ ಲಿಸ್ಟ್ ಆನ್ ಒನ್ ಡೇಟ್. ಹಾ ಹಾಕೊಳ್ಳಿ. 12 13 14/7 for dictating orders. Yes, ಆಗಿದೆ argument. Yes,
liberty may be given to the
15/7. Yes.
liberty ಕೊಟ್ರೆ company making the company our contention in the company is not made a party ಅಂತ.
Maybe permitted to file fresh petition by making the company party ಅಂತ ಹೇಳಿದಿರಾ ನೋಡ್ತೀನಿ ನಾನು. Yes, yes.
Thirty-four, Tulsi Care.
ನಂಗೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡು. Yes.
The respondent. Complainant. On the other day, a contention is raised that the petitioner hearing is the director, is not the managing director. The signatory of the check is the managing director, and he had resigned after issuance of the check. That was the contention taken. He was no longer a director. But in fact, he was a director. He resigned on 29/3/2022, as per their own document, which is accepted by the managing director on 30 through email on 33. He resigned on 29/3/2022, which according to them was accepted by the MD on 33/2022. No document is produced to show that from the registrar of companies to show that the resignation is accepted. And check is dated now 25/1/2022. 25/2/2022, 25/3/2022, 3 checks.
25?
Resignation is now 25/1/2022. 25/2/2022 and 25/3/2022.
ಒಂದೊಂದು ತಿಂಗಳ ಡಿಫರೆನ್ಸ್ ಅಲ್ಲಿ.
It is not before his resignation. Now, the only contention that is raised by the other side, there are only two directors. One is the managing director and the accused number 3 is the director. Accused number 1 is the company. And let him show all these documents before the trial court to show whether or not he has really resigned before issuance of the check. It's a matter of investigation.
Yes, under ಇದು private complaint ಅಲ್ಲ ಇದು?
Private complaint.
Matter for trial, not investigation.
Not
Yes, yes.
It's a private complaint. Let him not produce all the documents before the trial court.
Yes.
Complaint ಅಲ್ಲಿ
ಅವ್ರು ಮುಗಿಸಿದೆ ಅಂದ್ಮೇಲೆ ನೀವು ಶುರು ಮಾಡಿ. Yes. Done?
So there are only two directors. That's my submission.
Yes.
And the amount of 17 lakhs is due to me. They have not paid even one single penny. And now the
Yes.
only ground taken is that there is no pleading with regard that day-to-day affair is handled by the managing director. Let him produce all those documents before the trial court.
Yes. Yes, right.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 43 ನಲ್ಲಿ ಚೆಕ್ಸ್ ವರ್ ಇಶ್ಯೂಡ್ ಬೈ
agree number 1 signed by number A2 ಚೆಕ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿರೋದು A2 ಸ್ವಾಮಿ. ಈ ಚೆಕ್ಸ್ ಅನ್ನ ಕೊಟ್ಟಿರೋದು ಹ್ಯಾಂಡ್ ಲೋನ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಮತ್ತೆ MOU ನಲ್ಲಿ. MOU ನಲ್ಲಿ ಹ್ಯಾಂಡ್ ಲೋನ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ನಾನ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಆಗಿಲ್ಲ. It is between complainant and accused number 1 is a company and its managing director is A2 ಮತ್ತೆ A1 with ಕಂಪ್ಲೇನೆಂಟ್ ಜೊತೆಲಿ ನಡೆದಿರೋದು ಇದು. ನಾನ್ ರಿಸೈನ್ ಮಾಡಿದ್ದೀನಿ, ನಾನ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿಲ್ಲ. ನಾನೇನಾದ್ರೂ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ರೆ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ನನ್ನ ವಿಟ್ನೆಸ್ ಆಗಿ ಮಾಡ್ತಾ ಇದ್ರು, ನಾನು ಅದ್ರಲ್ಲಿ ಇಲ್ಲ. ನಾನು ರಿಸೈನ್ ಮಾಡಿದ್ದೀನಿ, ಕಂಪನಿ ಡಾಟಾ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ A1 ಹೇಳಿ A2 ಹೇಳಿದ್ದಾರೆ, A3 ರಿಸೈನ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರು ಲಯಬಲ್ ಇಲ್ಲ, ಎಲ್ಲಾ ಲಯಬಿಲಿಟಿನೂ ನಾನು ನಂದೇ ಅಂತಂದು ಸರ್ಟಿಫೈ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ.
Heard arguments of learned counsel for respondent and learned counsel for petition reply. Date ಕೊಡ್ತೀನಿ ನಾನು. List on 16/7 for dictating orders. ಇದು ಯಾವ 33 ನ 30 yes
16/7 dictation.
Yes.
Banu Prakash.
ಶುರು ಆಗಿದೆ.
ಸ್ವಲ್ಪ ನೋಡಿ.
Yes. Affidavit evidence ಕೊಟ್ಟಿರೋದು ನೀವು.
Please, so for the Mondovi Cooperative Bank Limited judgment is valid.
Affidavit ಬರಲ್ಲ. We have to file regular. Petitioner is complainant ಅಲ್ಲ? ಇಲ್ಲಿ ಇಲ್ಲಿ complainant, ನೀವು accused.
Yes.
ಅಲ್ವಾ? Heard learned counsel for respondent, petitions are allowed. Yes. They are remanded to the trial court. The party shall appear before the trial court on ಒಂದು 15 ದಿವಸ ಬಿಟ್ಟು ಡೇಟ್.
21ನೇ ತಾರೀಕು 21/7.
Yes. Regular evidence, individual ಆಗಿ evidence ಕೊಡ್ಬೇಕು. Yes.
36.
ಅಪೀಲಿಂಗ್ ಫಾರ್ ಪಿಟಿಷನರ್ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲಿ ಪಾರ್ಟೀಸ್ ನ ಪ್ರೆಸೆಂಟ್ ಹಿಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಅಪಾಲಜೈಸ್ ಮಾಡೋದಕ್ಕೆ ಎಸ್ ಮಾಡೋಣ. ಅದು ಸೆಕ್ಷನ್ 504, 509 ಮತ್ತೆ 354A IPC ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಇದ್ ಮಾಡಿದ್ರಿ. ಆ ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಹಿಯರಿಂಗ್ ಇತ್ತು. ಹಿಯರಿಂಗ್ ನಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ಮೇಲೆ ಸೊ ಪಾರ್ಟೀಸ್ ನ ಕರೆಸಿ ಅಪಾಲಜೈಸ್ ಮಾಡ್ಲಿ, ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ರು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ.
ನಾಟಕ ಬೇಡ ನಮ್ಗೆ. ಪಾರ್ಟಿ ನೀವು ಇದ್ದೀರಾ, ಪಾರ್ಟಿ
ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ, ಕಂಪಿಟಿಷನರ್ ಇದ್ದಾರೆ, ಅವ್ರ ಪಾರ್ಟಿನೂ ಬಂದಿದ್ದಾರೆ. ಸೊ ಅಪಾಲಜೈಸ್ ಕೇಳಕ್ಕೆ ನಮ್ಮವ್ರು ರೆಡಿ ಇದ್ದಾರೆ, ಇಲ್ಲೇ ಇದೆ ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ.
ಕೋರ್ಟ್ ಹೊರಗಡೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಮಾಡಿಬಿಟ್ಟು ಮೆಮೊ ಹಾಕಿ, ನಾನು ಅದನ್ನ ಇದ್ ಮಾಡ್ತೀನಿ. ಮುಂದೆ ಬೇಡ, ನಾನು ಇವ್ರು ಅಪಾಲಜಿ ಕೊಟ್ರು ಅವ್ರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ ಅವೆಲ್ಲ ನಾನ್ ಬರೀತಾ ಕೂತ್ಕೊಳ್ಳೋ.
ಅವ್ರದ್ದು ಮೆಂಟಲ್ ಕಂಡೀಷನ್, ಹೆಲ್ತ್ 2.5 years ಬೇಬಿ ಇಂದನೂ ಅವ್ರಿಗೆ ಫಿಟ್ಸ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಜೊತೆಗೆ ಟೆನ್ಷನ್ ಇದೆ.
ನೀವು ಸಂತೋಷವಾಗಿ ನೀವು ಅವ್ರು ಅಪಾಲಜಿ ಕೇಳಿದ್ರು, ಇವ್ರು ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರು ಅಂತಂದ್ರೆ ನಮಗೆ ಇದನ್ನ ಸೆಟ್ಲ್ ಆಗಿದೆ, ಇದನ್ನ ವಜಾ ಮಾಡಿ ಅಂತಂದ್ರೆ ನಾನು ಮಾಡ್ತೇನೆ. ನಾನು ಮಾನಿಟರ್ ಆಗಿ ನಿಂತ್ಕೊಂಡು ಅಥವಾ ರೆಫರಿ ಆಗಿ ನಿಂತ್ಕೊಂಡು ನೀನ್ ಕೇಳದ್ಯಾ, ನೀನ್ ಹೇಳಿದ್ಯಾ ಅವೆಲ್ಲ ಮಾಡಲ್ಲ. do it. ನಾನು ಪಾಸ್
ಎಸ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಮನೋರ್
ಮಾಡ್ತೇನೆ.
ಎಸ್ ಮನೋರ್ ಒಂದ್ಸಲ ಕೇಳಿ ಅಂತ
ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು. ನೀವು ನಾನ್ ನಿಮಗೆ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದು ನೀವು ಅವ್ರಿಗೆ ಎಕ್ಸ್ಕ್ಯೂಸ್ ಕೇಳ್ಕೊಂಡು ಮಾಡ್ಕೊಂಡ್ರೆ ಮುಗಿಸ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ದು. ನಾನು
ಒಂದ್ಸಲ ಮಾತಾಡ್ ನೋಡ್ಲಿ
ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಎಸ್ ಎಸ್. Next.
37. Sudesh Kumar Acharya.
Your Lordship.
ಈಗ 53 ಆಯ್ತು.
Your Lordship, I'd like to make a humble submission.
ಒಂದ್ ನಿಮಿಷ, ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ? ಓಕೆ ಓಕೆ ಓಕೆ. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ಪೆಟಿಷನರ್, ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಎಷ್ಟು ಜನ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದರಲ್ಲಿ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ನ ಇವರು? ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಪ್ರೆಸೆಂಟ್. ಹಾ, ಏನಾಗ್ಬೇಕು ವಕೀಲರು ಇದರಲ್ಲಿ?
Your Lordship, this criminal petition was filed here in this honorable court on August 5, 2021. A stay was obtained August 10, 2021. Thereafter, the petitioner has taken no efforts to hear the matter. And I have moved memo 5 times. January 20, 2022, June 13, January 28, 2025, March 21st, 2025.
ಆಯ್ತು, ಇದನ್ನು ಪಾಸ್ ಓವರ್ ಮಾಡಿ. Let us see if they come in the afternoon, well and good. Or else I will grant you a small adjournment with a conditional order that you people are coming from outside or
From Devanahalli, Bangalore.
Okay, okay. ಕೆಲಸ ಮಾಡಿ.
If this matter the stay need to be vacated.
For petitioner, learned counsel for ಅದು ಬಂತಲ್ಲಪ್ಪ. Okay, sorry. ಇದನ್ನ learned counsel for respondent number 2 submits that on account of stay, whether investigation is stalled.
No, the trial is stalled for 7 years.
Stalled. First stop. ಇವ್ರು ಯಾರು ಕೌನ್ಸಿಲ್? ಸುದೇಶ್ ಕುಮಾರ್ ಆಚಾರ್ಯ.
Sudesh Kumar Acharya.
As a last chance, list this matter next week ಕೊಡಪ್ಪ, ಒಂದು ವಾರ ಕೊಡಿ. List this matter on
7th ಬೇಕಾ?
ನೋಡಿ ಕೇಳಿ ಅವ್ರಿಗೆ ಯಾವ್ದು ಬೇಕು ಕೇಳಿ.
7th
7 full stop. It is made clear that on the next date of hearing, if the learned counsel for petitioner fails to proceed with the matter, interim order would not be extended.
Lord, I am for the petition.
ಇದೀರಿ?
Yes, Lord.
ಹಾ, ಆಯ್ತು, ಮಾಡಿ arrangement ಮಾಡಿ.
Well, I pray for 2 weeks, Lord. 2 weeks, Lord.
2 weeks ಅಲ್ಲ, ನಾವು 7 ಕೊಡ್ತಾ ಇದ್ದೀವಿ. Later, learned counsel for petitioner also present. ಇದು
Well, you lost my head on the Lord.
ಇರಿ ಒಂದು ನಿಮಿಷ. It is made clear that interim order would not be extended. ಆಯ್ತಾ? As a last chance, interim order extended till the next date.
Please.
At this stage, learned counsel for petitioner present. Yes, list on 7.
You lost my head on 14. 14, Lord. Lord, the reason, Lord, kindly, Lord, reason is this, Lord. Reason is this, Lord. Mother's monthly ceremony. I lost my mother recently, Lord. Mother's monthly ceremony would 14th. 14.
We can take
weekend ನಾನು ಇರುವುದಿಲ್ಲ. ಅಲ್ಲ, ನಾನು weekend ಇರುವುದಿಲ್ಲ.
This Thursday we can take.
You lost my habit on 14th, Lord.
13th, 3rd.
Or any Thursday, Lord, after 12th, Lord.
This Thursday.
This Thursday, Lord, you lost my kindly appreciate, Lord. I am not mentally ready, Lord. ನಾನು ತಮ್ಮ ಮುಂದೆ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡದೇ ಇದ್ದವಲ್ಲ ನಾನು. Well, it's an old matter, I know, I will argue the matter. I am requesting for accommodation till that date, Lord. Second week ಅಲ್ಲಿ ಯಾವ ತಾರೀಕು ಹಾಕಿ ನಾನು ಮಾಡ್ತೀವಿ ಎಲ್ಲ ಮೇಕ್ ಕೇಳಿದ್ರೆ I will argue on that day. Either by VC or by personally.
14/7 ನೋಡಿ ವಕೀಲರೇ.
Any Monday or
14/7 ನಿಮಗೆ
ಅಥವಾ ಅವರಿಗೆ ತರ್ಸ್ದೇನೆ ಬೇಕು ಅಂತಿದ್ರೆ ಜುಲೈ ಯಾವ್ದೋ ತರ್ಸ್ದೆ.
14/7
ಬಗ್ಗೆ ಚಿಂತೆ ಮಾಡಬೇಡಿ, ನಿಮ್ಮ ಬಗ್ಗೆ ಚಿಂತೆ ಮಾಡಿ. ಹೌದಾ?
14/7.
Please.
ಆಯ್ತು.
Please, Mel, oblige.
Oblige.
14/7 ಮಾಡಿ. Yes.
Submission serial number 35 serious matter.
35 ನಲ್ಲಿ ಅವ್ರು ಕನ್ಸಿಡ್ ಮಾಡಿದ್ದಾರೆ. ಹೌದು, ಅಫಿಡವಿಟ್ ಹಾಕಬೇಕು ಅಂತ ಹೇಳಿ. ಅದೇ ಅಲ್ವಾ ಸೀರೀಸ್
ಎಸ್ ಕರೆಕ್ಟ್.
ಅದಕ್ಕೆ ಅಲೋ ಮಾಡಿದ್ದೇನೆ. ಮಾಡಿಬಿಟ್ಟು ಇಟ್ ಇಸ್ ಪೋಸ್ಟೆಡ್ ದಿ ಪಾರ್ಟೀಸ್ ಆರ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಅಪಿಯರ್ ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆನ್ 21/7 ಅಂಡ್ ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಅಲ್ಲ ರೆಗ್ಯುಲರ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಬೇಕು ಅಕ್ಯೂಸ್ಗಳು ಅಂತ. ಎಸ್
38 ಶ್ರೀನಿವಾಸ್ CH.
ಇದನ್ನ ಮಧ್ಯಾಹ್ನ ತಗೋಣ.
ಸರಿ ಸರ್,
ನಮ್ಮ
ಪ್ಲೀಸ್.
1:15 ನಾವು ಅಲ್ಲಿ
ಅದೇ 1 o'clock ಏನೋ.
ಅದಕ್ಕೆ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ಟೇಕನ್ ಇನ್ ದಿ ಆಫ್ಟರ್ನೂನ್.
2:30 ಪ್ಲೀಸ್.
ಎಸ್
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಂಗೆ ಇರಲಿಲ್ಲ ಅವ್ರು. ಎನಿವೆ ಮಧ್ಯಾಹ್ನ ನಾವು ಹೇಳ್ಬಿಡ್ತೀವಿ.
ಎಸ್
One submission with respect to serial number 4, my lord. The interim order to be extended in that. My last time also, upon submission also it was not extended.
ಅವ್ರಿಗೆ ಹೇಳಪ್ಪ ನಮ್ಮಲ್ಲಿ ಏನ್ ಮಾಡ್ತೀವಿ, ಯೂಶುವಲಿ ಏನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಈಗ ಆಗಲ್ಲ. ಎಸ್ ನೋಡ್ರಿ, ಮಧ್ಯಾಹ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ.
Submission.
ಎಸ್
4.
ಲಾಸ್ಟ್ ಟೈಮ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ, ನಾವು ಇಲ್ಲಿ ಲ್ಯಾಪ್ಸ್ ಆಗಿದೆ. ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ ಹೇಳ
ಸರ್. ಅಡ್ಜರ್ನ್ಮೆಂಟ್
ಮೇಡಮ್ ಕೊಡ್ತಾರೆ, ನಾವು ಕೊಡಲ್ಲ. 2:15 ಬನ್ನಿ. ಮೆನ್ಷನ್ಗೆ ಏನಿದ್ರು 2:15 ಬನ್ನಿ. ಯಾವ ಡೇಟ್?
ಫ್ರೈಡೆ. ಈ ಫ್ರೈಡೆ
ಇಲ್ಲ, ಯಾವ್ದು ಸೀರಿಯಲ್? ಇಲ್ಲ, ನಾನ್ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ಮೇಡಮ್ ಕೊಡೋದು. ನಮ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ, ನಮ್ಗೆ ಅಸೈನ್ ಮಾಡಿಲ್ಲ ಮೇಡಮ್. ಅವ್ರು ಇದ್ದಲ್ಲ ಏನು ಓಕಾ ಸಾಹೇಬ್ರು ಬಂದವ್ರಂತೆ. ಯಾವ್ದು ಅಡ್ಜನ್? ಯಾವ ಸೀರಿಯಲ್? 50 ಇದೆ. 14 40 40 ಇದೆ. 52 52 ಅವ್ರು 14% ಅವ್ರ ಬಿಸ್ನೆಸ್ ಅಲ್ಲೇ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು. ಮೇಡಮ್ ಇದುವರೆಗೂ ಅಲ್ಲ, ಸೀರಿಯಲ್ ಕರ್ದಾಗ ಇಲ್ದಿದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ತಾರಷ್ಟೇ. ಹಾಗೆ ಔಟ್ ಆಫ್ ಟರ್ನ್ ತಗೊಂಡೆ ಅವ್ರು ಕರೆಯಕ್ಕಾಗಲ್ಲ. ಸೀರಿಯಲ್ ಕರ್ದಾಗ ಇರ್ಬೇಕಷ್ಟೇ ನೀವು. $25 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಂದ್ರ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ? ಅವ್ರ ಫೈಲ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಅಪ್ಲಿಕೇಶನ್ ತರಕ್ ಕೇಳ್ಬೇಕು. ಸ್ವಲ್ಪ ಹೇಳ್ಬಿಡ್ತೀರಾ? ಪೆಂಡಿಂಗ್ ಸ್ಕೂಟ್ನಿ ಅವರು. ಸ್ಕೂಟ್ನಿ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು.
ಸೀರಿಯಲ್ ನಂಬರ್ 41 ಸರ್.
ಸ್ಕೂಟ್ನಿಯಿಂದ ತಂದು ಪುಟಪ್ ಮಾಡ್ಬೇಕಿದು. ಹೋಗ್ಲಿ, ಇನ್ನೊಂದಿನ ಪುಟಪ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ. ಈಗ ಅದನ್ನ ನಿಮ್ ಕಾಪಿ ಕೊಡಿ, ಮೇಡಮ್ಗೆ ಹೇಳ್ತೀನಿ. ಅಲ್ಲಿ ಬಂದಾಗ ಕೊಡಿ. ಅಷ್ಟು ಬೇಗ ಬರಲ್ಲ ಅವ್ರು, ಅಲ್ಲಿ ತಂದು ಕೊಟ್ಟು ಲೇಟ್ ಆಗ್ಬಿಡುತ್ತೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 41 ಅಡ್ಮಿಷನ್
41 ಇನ್ನ ಕಾಲ್ ಔಟ್ ಆಗಿಲ್ಲಪ್ಪ.
ಓಕೆ, ಮಧ್ಯಾಹ್ನ ಕರೀತಾರೆ.
ಏನೋ ಮೀಟಿಂಗ್ ಇದೆ ಅಂತ ಹೋದ್ರು ಮೇಡಮ್. 2:15 ಬನ್ನಿ. ಪಾಸ್ಡ್ ಅವರೆಲ್ಲ 2:30ಗೆ.
Court officer? Court officer? Court officer?
ಹೇಳಿ ಸರ್.
ಸರ್, ಈಗ ನಾವು ಇದು ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ಮಾತಾಡ್ತಾ ಇರೋದು ಸರ್. ಇಲ್ಲಿ ನಾವು ಲಾಗಿನ್ ಆಗ್ಬೇಕಂತ ಅಂದ್ರೆ ಅಪಿಯರ್ ಆಗ್ಬೇಕಂದ್ರೆ ಏನು ಸರ್? ಆಪ್ಷನ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ.
ಧಾರವಾಡ ಬೆಂಚಾ?
ಹೌದು ಸರ್.
ಹೇಳಿ, 2:30 ಕರಿತೀವಿ.
ಓಕೆ ಓಕೆ, ಸರಿ ಸರ್.
ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಬಂದವ್ರೆ?
ಯಾರು ಗೊತ್ತಿಲ್ಲ ಸರ್. ಗಿರಿಜಾ, ಐ ಥಿಂಕ್ ಗಿರಿಜಾ ಹೆರಿಮೆಟ್ ಸರ್.
ನಿಮ್ದು ಯಾವ ಸೀರಿಯಲ್? ಫಸ್ಟ್ 1ನೇ ಸೀರಿಯಲ್?
1 and 2 ಸರ್.
ಓಕೆ ಓಕೆ, ಕರಿತೀವಿ, ವೇಟ್ ಮಾಡಿ, 2:30 ಕರಿತೀವಿ.
ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
2:30 ಬರ್ತಾರೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
First Dharwad, Karbulgi, second Islamic countries.
ಮಾಡಿಲ್ಲ ಇದು. For dictating orders.
Petition allowed. Yes.
54 RS Rajesh.
Huh. Huh. ಕೊಡಿ ಕೊಡಿ. Petition rejected. ಕೊಡಿ ಅದನ್ನು ಸೇರಿಸ್ತಾರೆ. Yes. ಹಾ. ಅದು ಫೈಲ್ಗೆ ಹಾಕಿಬಿಡೋಣ. Yes. ಅದೊಂದು ಆಡ್.
Dharwad bench matters. Serial number 1 for admission.
Please, my
Kumar
lord.
Reddy.
Please, my lord. I am appearing for petitioner, my lord. The 482 petition, my lord.
ನನ್ಗೆ ಬರ್ತದೆ ಹಿಂದೆ ನಾರ್ಮಲ್ ಹಾಕಿದ್ಯಾ? ಹಾ ಹಾ ಹಾ.
My lord, the
For respondent, madam.
I am appearing for a petitioner, my lord.
ಹಾ ಹಾ ಹಾ.
482 petition, my lord. The petitioner is accused number 2, my lord.
ಸ್ವಲ್ಪ ಧ್ವನಿ ಸರಿಯಾಗಿ ಮಾಡಿದ್ರೆ.
ಸ್ವಲ್ಪ ಮೈಕ್ ಹತ್ರ ಇಟ್ಕೊಂಡು ಮಾತಾಡಿ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Please, my lord. The petitioner is accused number 2, my lord. My lord, please, I am audible, my lord. My lord, the offences are, my lord, 384, 458, 504, 506, read with section 34 of IPC, my lord. The allegation is of extortion and blackmailing, my lord. The complaint is at page number 13, my lord. Except a single line allegation, my lord, there are no allegation against the petitioner, my lord. The police have filed
Yes,
B report. My lord, the police have filed B report, my lord. After B report, my lord, protest petition was filed. The trial court, my lord, instead of recording the sole statement, my lord, recorded the chief examination of witnesses, my lord. Thereafter, without satisfying the prima facie case, my lord, the trial court took the cognizance and issued notice to the petitioner, my lord. Your lordship may kindly see the page number 14, para 5 of the complaint, my lord. A single line allegation, except that allegation, my lord, there are no allegation against the petitioner. May I read, my lord?
ಹಾ ಹೇಳಿ ವಕೀಲ್ರೆ.
My lord, in para 5 of the complaint, my lord, that is at page number 14, my lord.
ಇಲ್ಲಿ there are two petitions. ಹೌದಾ?
No,
SCGP
only-
ಅವರೇ. Please, your lordship. Earlier it was the complainant who is accused in the other case.
Other case, please.
Correct ಅಲ್ಲ?
ಹೌದು. The very same
ಯಾವ
case.
ಕೇಸಲ್ಲಿ ಅಕ್ಯೂಸ್ ಇವರು?
My lord, the petition number.
ಕ್ರೈಮ್ ನಂಬರ್ ಹೇಳಿ ವಕೀಲ್ರೆ.
Please, my lord.
Crime number 105 of 22, your lordship.
ಹಾ. Yes.
105 22.
ಅಂದ್ರೆ ಯಾರು ಅದ್ರಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರು?
Complainant, my lord.
ಲೇಡಿನಾ?
ಹೌದು.
Rajkumar D. Takale.
Okay, okay.
The petitioner is, my lord, Tilak Raj, my lord.
Who accompanied that lady?
The petitioner is accused number 2, my lord.
ವಕೀಲ್ರೆ ನೀವು ಮಾತಾಡೋದು ಸರಿಯಾಗಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ನನಗೆ.
My lord. Now, my lord, now I am. My lord, now am I audible, my lord?
ಹಾ ಎಸ್ ಹೇಳಿ. ಎಸ್. ನಾನೇ ಓದ್ಕೋತೀನಿ. ಎಸ್ ಹೇಳಿ.
My lord, the complaint is at page number 13, my lord, annexure B.
Yes.
In para 14, my lord. Page number 14 at para number 5, my lord. In the last week of December 2021, that is 24th December 2021 at evening, around 7:30, when I was at my home at plot number 53, opposite KEB Vidyanagar, Belagavi, I received the call of the said Miss Navesri R. Rao, along with her best friend Tilak Raj, DT, Chanpatan, started threatening me through calls, stating that they have videographed some intimate moments between myself and Miss Navesri Rao, and further demanded me to give them rupees 50 lakhs. Except this allegation, my lord, there are no allegations against the petitioner, my lord.
Yes.
After full investigation, my lord, the police have filed B report, my lord. On the B report, my lord, they have filed protest petition. And the trial court, my lord,
Yes, ಹೇಳಿ.
the trial court, my lord, without satisfying the prima facie case against the petitioner, my lord, took the cognizance against the petitioner, my lord. Your lordship may kindly see the page number 93, annexure F, my lord.
Page number?
93. 93.
96 93 na?
93, my lord. 93, my lord.
93.
Yes, my lord.
Yes.
After protest petition, my lord, the trial court, instead of recording the sworn statement, my lord, recorded the chief examination of the complainant, my lord. That vitiates the entire proceedings, my lord. That is not at all permissible. Your lordship may kindly see ಪ್ರಮಾಣ ವಚನ ಬೋಧಿಸಲಾಯಿತು ಫಿರ್ಯಾದಿಯ ಮುಖ್ಯ ವಿಚಾರಣೆ ಅಲ್ಲಿ ಸ್ವಪ್ರತಿಜ್ಞೆ ಹೇಳಿಕೆ ಅಂತ ಬರಬೇಕಾಗಿತ್ತು. Instead of recording the sworn statement, my lord, the trial court recorded the chief examination, my lord.
Yes.
So it vitiates the entire proceedings. And even in the absence of prima facie case against the petitioner, my lord, the trial court in mechanical manner took the cognizance and issued the process, my lord.
Yes.
Except that single line allegation which I have shown in the complaint, my lord, there are no materials. Thereafter, in the sworn statement, they have made some improvements, but that is those are without any proof, my lord.
Yes.
And therefore, my lord, the proceedings cannot be maintainable against the petitioner, my lord.
Yes.
That is all, my lord. Only that, except that allegation, my lord, there are no allegations, my lord. Whatever allegations are there, they are against the accused number 1, not against the accused number 2.
Yes. Yes, ಅಷ್ಟೇನಾ?
Yes,
Please, Your Lordship. As first time matters, Your Lordship, I'll take notice, and the notice has to go for respond number 2, Your Lordship.
ಅವ್ರದ್ದು ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಫಸ್ಟ್ ಟೈಮ್, Your Lordship.
ಮತ್ತೆ ಮೊದಲೇ ಹೇಳ್ಬೇಕು ಬೇಡ, ನೀವು ಇಷ್ಟೆಲ್ಲ ಕೇಳಿದ್ವಲ್ಲ ನಾವು, ಅದು ಬೇರೆ ಸರಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
My lord, the appearance is on 21/7, my lord.
Respondent number 1, issue notice to respondent number 2, returnable by ಹೇಳಪ್ಪ. 28/7.
My lord, next date of appearance is on 21/7, my lord. I pray for interim order, my lord. Next date is on 21/7, my lord. 21/7. Next date is on 21/7, my lord.
ಯಾವ ನೆಕ್ಸ್ಟ್ ಡೇಟ್?
ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ, ಬಿಫೋರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್, my lord.
ಏನಾಗುತ್ತೆ ಅದ್ರಲ್ಲಿ? ಒಂದು ಎಕ್ಸಾಮ್ಷನ್ ತಗೊಳ್ಳಿ.
There is no prima facie case, my lord.
ಒಂದು ಎಕ್ಸಾಮ್ಷನ್ ತಗೊಳ್ಳಿ, ಏನಾಗಲ್ಲ, ಸರ್ವಿಸ್ ಆಗ್ಲಿ ಅವ್ರಿಗೆ. ಎಸ್.
Serial number 2, J City.
Yes.
lord.
ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ ಅಲ್ಲ, ನೋಟಿಸ್ ಯಾರಿಗೆ ಹೋಗ್ಬೇಕು? SCGP takes notice
State
ಒಬ್ರೇನಾ?
Yes, my lord.
State ಒಬ್ರೇ ಅಲ್ಲ?
State is the only party.
SCGP takes notice for respondent.
Yes, my lord. My lord, it's petition, section 482 of CRPC, my lord. Offense against the petitioner herein is on section 379 of IPC, my lord. And present petitioner is accused number 2, my lord. As per complaint, my lord, petitioner and other accused persons with the intention to sell the land, sand, my lord, they extracted sand from Tungabhadra river, my lord, and without a permission, they stored in the one land, which is
ಇವರು ಯಾರು ಎಷ್ಟನೇ ಪೆಟಿಷನರ್, ಎಷ್ಟನೇ ಅಕ್ಯೂಸ್ ಇವರು ವಕೀಲ್ರೆ?
accused number 2, my lord. There is no specific allegation against the accused number 2, my lord, petitioner, my lord, and also nothing has been inserted in charge sheet also, my lord. And also, my lord, accused number 5 in this case, my lord, he has filed a criminal petition before your lordship, my lord, and it came to be allowed, my lord, and may kindly be considered the same, my lord, to proceed this case. Sorry, to allow this petition, my lord.
Yes.
May kindly be seen accused annexure number F, my lord.
ಯಾವ ಅಕ್ಯೂಸ್ ಅಲ್ಲ ಆಗಿದೆ?
Accused number 5, my lord.
5 ಅಲ್ಲ?
Yes, I produced a copy also, my lord. Page number 48 may kindly be seen, my lord.
ಅಲ್ಲಲ್ಲ, whether he is also standing on the same footing.
Yes, my lord. Please, my lord. There is no specific allegation against the petitioner herein, my lord.
SCGP ಅವರೇ ನೋಡಿದ್ದೀರಾ ಇದನ್ನ?
Please, your lordship, ನೋಡಿದ್ದೀನಿ.
Whether he is also, petition is also standing on the same footing?
In fact, he is running a business, my lord.
ನೀವು ಹೇಳಿ, petition ನೀವು ಹೇಳಿ, ನಾನು ನೋಡೋಣ. Yes, ಹೇಳಿ.
Yes, my lord. Petitioner, he is running a electric business, my lord, and he has not at all involved in the alleged offense, my lord. And also nothing has been initiated in charge sheet also, my lord. And there is no iota evidence against the petitioner herein, my lord. ಯಾರು ಇದನ್ನ ಮಾಹಿತಿ ಕೊಟ್ಟರು ಅಂತಕ್ಕಂಥದ್ದು ಇದು ಎಲ್ಲೋ ರೆಕಾರ್ಡ್ ಇಲ್ಲ, my lord.
Yes.
And there is no eyewitness also, my lord.
Yes. Heard learned counsel for petitioner ಒಂದೆರಡು ದಿವಸ ಬಿಟ್ಟು ಹಾಕಪ್ಪ ಒಂದು ಟು ಹಿಯರ್ learned SCGP ಅಂತ ಹೇಳಿ ನನಗೆ ಮನೆಗೆ ಹಾಕಿದೆ, ನಾನು ಸ್ವಲ್ಪ ನೋಡ್ತೀನಿ.
My lord, seeking for interim order, my lord.
ಎಲ್ಲಿ interim order?
My lord, he has not at all involved in the alleged offense, my lord. Kindly be given.
ಹಿಂಗೆ ಅದು ಮನೆಗೆ. Yes.
Seeking for interim order, my lord.
No interim order, ವಕೀಲ್ರೆ. Yes.
First our cases, list number 1, serial number 3, Mohan BK.
List number 1 ಅಲ್ಲಿ 1 ಮುಗೀತಾ?
1 ಆಯ್ತು.
ಆಗಿದೆಯಾ? ಏನ್ ಮಾಡಿದ್ವಿ? ಇದ್ರದಲ್ವಾ? ಎಸ್ ಎಸ್ ಎಸ್, ಕರೆಕ್ಟ್. 2 ಏನಿದು? ಅದು ಆಯ್ತಲ್ಲ, being spoken to. ಎಸ್.
Number 3, Mohan BK.
ಏನಿದೆ ಇದು? ಡಿಸ್ಮಿಸ್ ಅಲ್ಲ? No representation for petition even in the afternoon session. By order dated ಹಾಕೊಳ್ಳಿ 19/6 conditional order ಆಗಿತ್ತು. Despite the same, office objections are not complied with. It appears petition is not interested in prosecuting the petition, hence petition is dismissed for default. Yes.
Serial number 6, M. Shashidhar.
ಇವತ್ತು ವಜಾ ಮಾಡ್ತೀವಿ ಅಂತ ಇಟ್ಟಿದ್ದ, ಏನಿದು? ಕಾಪಿ ನೋಟ್ಸ್ ಅಲ್ಲ? ಯಾಕೆ ಶಾರ್ಟ್ ಅಕೊಮಡೇಷನ್ ಯಾಕೆ? ಏನ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್? ಬೆಳಿಗ್ಗೆ ಏನು ಹೇಳಿದೆ ನೋಡಿ, ಕಾಪಿ ಸರ್ವ್ಡ್ ಅಂತ ಏನೋ ಬಂತು ನೋಡಿ, ಅದಾಗಿರ್ಬೇಕಲ್ಲ. ಯಾರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ದು? Learned counsel for respondent number 2 serves copy of statement of objections to learned counsel for HCGP na. Okay. At the request of learned counsel for petitioner, list on ಒಂದು ಸಣ್ಣ ಡೇಟ್ ಕೊಡಿ ಇದರಲ್ಲಿ. ಇದೆ ಒಂದು ರೀಸನಬಲ್ ಡೇಟ್ ಕೊಡ್ತೇನೆ, ಆಸ್ ಅ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಎಂಟ್ರಿ ಮಾಡೋ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೇನೆ. ಅವತ್ತು ಮಾಡದೇ ಇದ್ರೆ ವೇಕೇಟ್ ಮಾಡ್ಬಿಡ್ತೇನೆ.
21st ಅಲ್ಲ ಸಾರಿ 7th 7
as a last chance entry model extended till the next date. Yes.
Seal number 7.
Malad sir, appear for the petitioner.
Please, Malad.
Malad sir, led by senior counsel in this matter. Malad sir, request to be.
ಇದೇನಾಯ್ತು ಇದು?
ಅಲ್ಲ Malad, I'll just point out one aspect. ಇದರಲ್ಲಿ
ಒಂದು ನಿಮಿಷ.
Please.
Compliance of office ಇದು ಪ್ರತಿ ಸಲ ಮತ್ತೆ ಬರ್ತಾ ಇರುತ್ತೆ, ಅದು ಆಯ್ತು ಅಂದ್ರೆ ಮುಗಿಸೋಣ.
that Malad, that may be overruled because they're saying that affidavit has to be attached with the objections. Objections all affidavit ಇಲ್ಲಿ ಬರುತ್ತೆ Malad.
ಕೊಡಿ ಇಲ್ಲಿ.
That may be overruled. I filed my objections to this.
ಎಲ್ಲಿ statement of objections ಕೊಡಿ. ಎಲ್ಲಿ ರೂಲ್ಸ್ ಹೇಳುತ್ತಾ?
ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ಅಲ್ಲಿ
ಇದೆಯಾ?
Objections again. If that is the case, my lord, I'll do that. I have no problem in doing that. But here, my lord, with regard to extension of the interim order, last occasion could I have not taken liberty to move it in the vacation bench for the simple reason that revision petition, iday same petition, revision petition pending, allu stay ತಗೊಂಡಿದ್ದಾರೆ on the same petition.
ನೀವು ಇದನ್ನ ಕಂಪ್ಲೈ ಮಾಡಿ ಹಿಯರ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ನಿಮ್ಮನ್ನ.
My lord, illi extension also becomes a problem. I'll just take my lords only to one thing. An affidavit ಹಾಕ್ತೀನಿ. I have no problem in filing the affidavit.
Do that.
My lord, if that was a requirement, then I would have done it during the course of the day also, if that's the case. But my lord, with regard to extension of the interim order.
ಉತ್ತರ ಹೇಳಿ, ಯಾವಾಗ affidavit ಹಾಕ್ತೀರಿ?
My lord, tomorrow itself I can do it.
ಹೌದಾ? Learned counsel for petitioner submits that he would comply with the office objections on statement of objections by filing affidavit by tomorrow. First off.
Please.
If first the affidavit is filed, list immediately on the next day. Yes. As a last chance entry order extended till the next date. ಇಲ್ಲೊಂದು ಡೇಟ್ ಹೇಳ್ಕೊಟ್ಬಿಡಪ್ಪ. ಇದು ನಾವು ಹೇಳೋ ಡೇಟ್ಗೆ ಬಂದ್ಬಿಡಿ ವಕೀಲ್ರೆ.
10ನೇ ತಾರೀಕು
ಕೊಡಪ್ಪ.
ನನಗೆ ವೆಡ್ನೆಸ್ಡೇ ನೇ ಪರವಾಗಿಲ್ಲ ಮರ, because tomorrow if I'm complaining, but not Wednesday itself may be listed.
10/7. Yes, as a last chance entry order extended.
Please.
Senior ಬರ್ದೇ ಇದ್ರು ನೀವೇ ಮಾಡಿ, ಗೊತ್ತಾಯ್ತಾ? Yes.
Obliged.
Next.
Seal number 9. Lakshya Kalappa.
ಎಲ್ಲ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಪ್ಲೈ ಮಾಡಿದ್ರು.
ಇದು IA 1/24 is dispensation of typed copy of annexure B na. ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
Seal number 9.
Oh, sorry. ನಾನು ಯಾವ್ದೋ ಬೇರೆ ನೋಡ್ತಾ ಇದ್ದೆ. Yes. 9 compliance of office objections ಮಾಡಿದ್ರಿ? Learned counsel for petitions ಮಾಡಿದಾರಾ? Submits that office objections are complied with the office to verify and proceed. Yes.
But 10 Latif B.
ಇದರಲ್ಲಿ ಏನು ನೋಟಿಸ್ ಏನೋ ಹೋಗೋದಿತ್ತಾ?
No, first compliance.
ಆಯ್ತು ನೋಡಿ. Yes.
But 10 Latif B. ಬಂದಿಲ್ಲ.
ಬೆಳಗ್ಗೆನೂ ಬಂದಿಲ್ಲಲ್ಲ? No representation for petition even in the afternoon session. ಅದು ಹಾಕೊಡಮ್ಮ. Wide order dated ಏನು ಅಂತಿದೆ ನೋಡಿ. Conditional order was passed. It appears petition is not interested in so and so. Dismissed for default. Yes.
Seal number 11. Vivek here. ಇದು ಬಂದಿಲ್ಲ ಮೇಡಮ್.
ಇದು ಅಷ್ಟೇ ಸೇಮ್ ಮೇಲೆ ಆಯ್ತಲ್ಲ 10th. Yes.
Seal number 12.
ಎಷ್ಟು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಪ್ಪ? 2 ಇದೆ. ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಮೇಲೆ ಯಾವ್ದಿದೆ? ಏನಂತೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಕೊಡಿ. The council submissions on office objections are accepted. Yes.
If this could, if the matter could be tagged along with another matter that has been filed by the other accused, my lords, it's a family dispute. It's been.
Give the number, give the number. Put up. List this matter along with so and so ಅಂತ ಹೇಳ್ಬಿಡಿ.
The date could be.
ಬರುತ್ತೆ. Yes. Next.
Number 15. ವಿಶ್ವನಾಥ್ ಶಿವಪ್ಪ. ಇದು ಪ್ರೇಮ್ ಟ್ರೇಡ್.
ಇದು ಬೆಳಿಗ್ಗೆ ಬಂದಿಲ್ಲ. ಈಗಲೂ ಅಷ್ಟೇ 10-11 ಮಾಡಿದ್ದಲ್ಲಮ್ಮ ಸೇಮ್ ಡಿಸ್ಮಿಸ್ ಪಾರ್ಟ್. ಎಸ್.
Number 20. PM Mohan Kumar.
Regarding this matter, I filed NOC Wakala. And subsequently, I was not able to complete the office objection. I thought that this is by virtue of this preemptive order.
No. ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ಲಿ ಹೇಳ್ತಿದ್ದೀರಿ? 20 ನಲ್ಲಿ matter is settled before the mediation.
Yes, Your Honor. The matter is settled before the mediation.
I am appearing for the petition.
Matter is settled, yes. It's for 8 lakhs.
Both learned counsel for petitioner and respondent.
Then number 2
present. First of the could as per order dated idu kodi refer agitalla mediation ge illi order sheet alli this matter was referred to mediation and it is settled before the mediation. First of the terms of the settlement reads as follows ಅಂತ ಹಾಕೋಣ. ಏನಾಗಬೇಕು ಇದರಲ್ಲಿ? This petition is to be allowed or dismissed. ಏನಾಗಿದೆ? ಎಲ್ಲಿ ಬಂದಿದೆ ಅದು? ಏನ್ petition ಇದು? Criminal petition? What is this petition for?
Start for washing of the case registered in crime number 121 of 21.
ಅದನ್ನ withdraw ಮಾಡ್ತೀವಿ ಅಂತೆಲ್ಲ ಇದೆಯಾ? They have no ಯಾವ serial ಇದು ಹೇಳಿ? Serial number ಎಷ್ಟದು?
20.
Petitioner agreed to so and so.
It's 21. Free housing.
They'll submit the report.
Director.
The matter was referred to the mediation. In the mediation, both the de facto complaint and the petitioner have settled the matter for some amount. By virtue of this, the matter in CC number 67, 15 or 23 is to be quashed in view of the mediation report. Offences are 420 and 406.
There was an amount of 8,50,000. 50,000 has been paid. 25,000 has been accepted today. We got a receipt of 25,000. On receipt of that, we have the petition may be allowed.
You do one thing. You are appearing for respond number 2, right?
2, yes, sir.
You file a memo stating that it is settled. The contents only state regarding the amount to be paid and all.
Okay. Yes.
You say that in the light of this this settlement, the petition may be allowed. I will allow it and quash it.
Yes.
And you are reporting receipt of
payment of rupees 25,000.
Sentence as follows. Learned counsel for respondent number 2 reports receipt of
payment of rupees 25,000.
25,000.
Receipt.
Total 8.
Today.
ಇವತ್ತು receive
ಇವತ್ತು ಮಾತ್ರ.
Different payments are to be made on different dates.
Different dates, yes.
Okay. He also files a memo to dismiss, to allow this petition by quashing the criminal proceedings, right?
Yes, I will file a memo.
In the light of the settlement entered into between the parties. In view of the same, petition is allowed. Yes. ಇದರಲ್ಲಿ ಅವರು ಕೋರ್ಟ್ ಆಫೀಸ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಅವರ ಅಮೌಂಟ್ ರಿಸೀವ್ ಮಾಡೋದಕ್ಕೆ ಸೈನ್ ಅವ್ರ ಹತ್ರ ಮೆಮೊ. ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 20 ಅದು ಆಮೇಲೆ
ಅಮೌಂಟ್ ರಿಸೀವ್ ಮಾಡಿದ್ರು.
ಎಸ್.
21 ಕೆ ಶಶಿಕಾಂತ್ ಪ್ರಸಾದ್.
ಅವರು ಮೆಮೊ ಬರ್ಕೊಟ್ಟು ಹೋಗಿ ವಕೀಲ. Yes.
This is the matter where I entered appearance based on NOC given by the earlier counsel. I filed the Wakalatan.
ಯಾವ್ದ್ರಲ್ಲಿ?
Next month.
21.
Criminal petition 1190.
You have filed wakalat for whom?
20th August 2024.
ಯಾರಿಗೆ?
Petitioners.
ಹೌದಾ? ಶಶಿಕಾಂತ್ ಪ್ರಸಾದ್ ಅವರ
ಅವರು
ಹಳಬ್ರು ಅವರು. ಓಕೆ. ಶ್ರೀ, ನಿಮ್ಮ ಹೆಸರು ಹೇಳಿ.
BM ಮೋಹನ್ ಕುಮಾರ್.
BM ಮೋಹನ್ ಕುಮಾರ್. Learned counsel submits that ಯಾವತ್ತು ಹಾಕಿದಿರಿ ವಕಾಲತ್ತು?
20th August 2024.
On 28 ಯಾವ ವರ್ಷ? 24. He has filed NOC ವಕಾಲತ್ for petitioner. ಹೌದಾ? Okay. Whether any office whether office objections are complied with?
Subsequently, the matter was listed before this court for non-compliance of office objections. There was a peremptory order. I was not able to complete because so many office objections. So I filed a fresh petition, thinking that this petition is already dismissed because there is an earlier peremptory order. So it may be dismissed as withdrawn.
Okay. He further submits that thinking that this petition is dismissed, he has filed a fresh petition, and therefore this petition may be dismissed as not pressed. How that? In the light of the submission, this petition is dismissed as not pressed. Yes.
ಮೋಹನ್ ಕುಮಾರ್ ಅಷ್ಟೇ ಯೂನಿವರ್ಸಿಟಿ ವಕಾಲತ್ ಇದೆ.
ಅವ್ರದ್ದು ವಕಾಲತ್ತಲ್ಲಿ ಏನ್ ಹೆಸರು ಇದೆ ನೋಡ್ಕೊಳ್ಳಿ. Yes.
24 ನೀವು ಮಾಡ್ತಾ ಇದ್ದೀರಾ? 24 ಮಾಡ್ತಾ
ಆಯ್ತು, ಮಾಡ್ಲಿ ಮಾಡೋದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ.
25 ಸುಯೋ ಹೇರ್ಲೆ
dispensation of a certified copy members. Name of the petitioner has to be mentioned before the wakalat.
ಇದು ಎಷ್ಟು ಇದಿದೆ? 2 ಇದೆಯಾ? ಯಾವ್ದಕ್ಕೆ ಏನೇನಿದೆ?
Certified copy of the impugned order members. For that I have filed dispensation.
ಎಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಿ?
ಇವತ್ತು ಹಾಕಿದ್ದೀನಿ.
ಕೊಡಿ. ಯಾವಾಗ ಹಾಕಿ? ಎಲ್ಲಿ? Learned counsel for petition submits that learned counsel for petition filed IA ಅದ್ ನೋಡ್ಕೊಂಬಿಡಿ ಅದನ್ನ. ಬಾರ್ so and so to dispense with the production of certified copy of ಅದೇನು ಹಾಕೊಳ್ಳಿ ಅದನ್ನ. In the light of the same, the production of certified copy is dispensed with for a period of 1 month. 1 month ಒಳಗಡೆ ಹಾಕಿ ಅದನ್ನ. Yes.
Their office objection is
ಒಂದೇ ಇದೆ ಅಂತ. Yes. Next.
26 ಚೇತನ್.
Petitioner madam. Objection to complaint. Because one certified copy ಬೇಕಾಗಿತ್ತು. 2 days 3 days time.
ಎಷ್ಟು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರಪ್ಪ? ಎಷ್ಟಿದೆ ಟೋಟಲ್?
ಅದೊಂದು 2 ಆಗ್ತದೆ.
ಯಾವ್ದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ?
ಪಿನ್ ಕೋಡ್ ಆಮೇಲೆ ಇದನ್ನ
ಉಳಿದದ್ದು ಎಷ್ಟಿದೆ? ಹೌದಾ? Learned counsel for petition submits that he has complied with office objection at serial number 1 and 2 and prays for a week's time to comply with the remaining office objections. Total 6 ಇದೆಯಲ್ಲಪ್ಪ ಇದೆ.
ಅಲ್ಲ ಮೇಡಮ್, ಅದು ಮಿಕ್ಕಿದ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಿಗೆ ನಾವು ಒಂದು ಕೆಲಸ ಮಾಡೋಣ. Learned counsel for petitioner has complied with the office objections except at serial number 5 and 6. ಈಗ ಮಾಡಿಲ್ದೇ ಇರೋದು ಯಾವುದು?
1 and 2 ಮಾಡಿದ್ದಾರೆ.
5 and 6 ಅಂತ ಹೇಳಿ ಅಲ್ಲಿಗೆ. And prays for a week's time to comply with the same. As the last chance, a week's time granted to comply with the office objections, failing which petition would be dismissed for non-prosecution. Yes. ಒಂದು ವಾರದಲ್ಲಿ ಮಾಡ್ಬೇಕು ಹೋಗಿದ್ರೆ. Yes.
27 ಪ್ರಸನ್ನ ಕುಮಾರ್ ಎಸ್ ಅಮೆಂಡ್ಮೆಂಟ್
ಮಾಡಿದ್ದೀರಾ? It is submitted that the cost title is amended and already amended cost title is filed. Alva? Office to verify and proceed. Yes.
But 31 ದಿಲ್ರಾಜ್ ರೋಹಿತ್ ಸಿಕ್ವೇರಿ.
ಇದೇನೋ ಅಮೌಂಟ್ ಇದು ಲಿಸ್ಟ್ ಹಾಕಿ ಅನ್ನೋದು. ಹೌದಾ? Okay. Already entire thing is withdrawn now. No question of again paying. ಯಾವ್ದು serial number?
31.
ಇದು ಮಾಡಿ. Learned counsel for petition has filed IA 1/25 to release the amount in deposit. However, the office note revealed that already the entire amount in deposit is withdrawn. In view of the same, IA 1/25 is rejected. Yes.
Number 36, Madhu Malati.
ಇದೇನಿದು
ಕೌನ್ಸಿಲ್ ಮಾಡಿ ಟೈಮ್ ಕೇಳಿದ್ರು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
It may be taken up on 11th of this month. We will report it.
ಇದಲ್ವಾ ಕಾಂಪ್ರಮೈಸ್ ಇದು ಅಪಾಲಜಿ ಕೇಳ್ತಾರೆ
Some talking is
ಓಕೆ
going.
ಓಕೆ both learned counsel for petition respond number 2 present ಅವ್ರದ್ದು SCGP ಇದು ಹಾಕ್ತಾ ಬನ್ನಿ. At the request of both counsel, list this matter
11th of this.
On 11/7. Yes,
Please.
for further hearing. Yes. ಅವ್ರವ್ರದೇ ಅಲ್ಲೇ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರು ಬಂದು ಒಂದು ಮೆಮೊ ಹಾಕಿ ನೀವು ಅಲೋ ಮಾಡಿ ಪೆಟಿಷನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಮುಗಿಸೋಣ. ಹಂಗೆ ನಮ್ಮ ಮುಂದೆ ಬಂದು ಇದು ಬೇಡ. ಎಸ್, ಲೆಟ್ ಅಸ್ ನಾಟ್ ಬಿ ವಿಟ್ನೆಸಸ್ ಟು ಯುವರ್ ಇದು ಡ್ರಾಮಾ. ಎಸ್, ಅವ್ರ ಹತ್ರ ಯಾರಿಗ್ ಬೈದಿದಿರೋ ಯಾರಿಗ್ ಇದ್ ಮಾಡಿ ಅವ್ರ ಹತ್ರ ಇದ್ ಮಾಡಿ. ಎಸ್.
38, Srinivas CH.
38 more represent ಇದಾವ. Oh, sorry. ಹಾ. 056922.
Petition is both the matters.
Who is petitioner? Petitioner is accused number?
Accused number 1 and 4 in this case.
ಬರೀ 4 ಎರಡು ಪೆಟಿಷನ್ ಇದೆಯಾ? ಓಕೆ ಓಕೆ. ಅಂಡ್ 8951/22. ಓಕೆ. ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 4, ಎರಡನೇ ಕೇಸಲ್ಲಿ
number 1.
10569 ಅಲ್ಲಿ.
Yes.
Petition is accused number 4. In another petition is accused number 1.
Yes. ಹೇಳಿ.
The petition along with the other two accused persons, namely Mubina and Samuela Megashu, were charged for the offence punishable under section 506, 504, 34 IPC, read with section 32 VA of SC/ST. Respondent number 2 is the complainant. Respondent number 2 claiming to be the employee of CWA, Mr. Tulsi Ram, has lodged his FIR in this case. Kindly see the page number 27. 27 is the complaint. Typed copy is at page number 29.
ಸ್ವಲ್ಪ ಫ್ಯಾನ್ ಜೋರ್ ಮಾಡ್ಸಪ್ಪ ಒಂದೇ ಒಂದು. ಎಸ್.
The claim of the respondent number 2 is that Megashu belongs to the scheduled persons. ವಿಷಯ ಆರ್.ಕೆ. ರಮೇಶ್, ಸಮೀವುಲ್ಲಾ, ಮುಬೀನಾ, ಕೇಶವ ರೆಡ್ಡಿ ಮತ್ತು ಇತರರು ವಿರುದ್ಧ ದೂರು ನೀಡುವ ಬಗ್ಗೆ ನಾನು ಮೇಲ್ಕಂಡ ಸರ್ವೆ ನಂಬರ್ 69 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 154ರಲ್ಲಿ ಕಳೆದ 30 ವರ್ಷಗಳಿಂದ ನನ್ನ ಹೆಂಡತಿ ರಾಜಮ್ಮನವರ ಜೊತೆ ವಾಸ ಮಾಡಿರುತ್ತೇನೆ. ಜಿ ತುಳಸಿರಾಮ್ ಅಂದ್ರೆ CW8 ತುಳಸಿರಾಮ್ ಮತ್ತು ಅವರ ಕುಟುಂಬದವರು ಈ ಮೇಲ್ಕಂಡ ಜಮೀನಿನ ಮಾಲೀಕರಾಗಿದ್ದು ನನ್ನನ್ನು ಜಮೀನನ್ನು ನೋಡಿಕೊಳ್ಳಲು ಕೆಲಸಕ್ಕೆ ಇಟ್ಟುಕೊಂಡಿದ್ದರು. ದಿನಾಂಕ 13/9/2020 ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 7 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಆರ್.ಕೆ. ರಮೇಶ್ ಮತ್ತು ಸಮೀವುಲ್ಲಾ, ಮುಬೀನಾ, ಕೇಶವ ರೆಡ್ಡಿ ಮತ್ತು ಇತರರು ಸೇರಿಕೊಂಡು ಮೇಲ್ಕಂಡ ಜಮೀನಿಗೆ ಅಕ್ರಮವಾಗಿ ಪ್ರವೇಶಿಸಿ ಗಲಾಟೆ ಮಾಡಿದರು. ಆಗ ನಾನು ಅವರನ್ನು ತಪ್ಪಿಸಲು ಹೋದಾಗ ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಯನ್ನು ರಸ್ತೆಗೆ ಎಳೆದುಕೊಂಡು ಬಂದು ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ನೀವು ಕೀಳುಜಾತಿಗೆ ಸೇರಿದವರು, ನಮ್ಮನ್ನು ಕರೆಯುತ್ತೀರಾ, ಕೊಲೆಯ ಬೋಡಿ ಮಕ್ಕಳ ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಯನ್ನು ಕಮ್ಮಿ ಜಾತಿ ನನ್ನ ಮಕ್ಕಳ ಎಂದು ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಬಾಯಿಗೆ ಬಂದಂತೆ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಯನ್ನು ಬೀದಿಗೆ ತಳ್ಳಿದರು. ನಂತರ ನನ್ನನ್ನು ಹೊಡೆಯಲು ಪ್ರಯತ್ನಿಸಿದರು. ನಿಮ್ಮನ್ನು ಸಾಯಿಸಿ ಬಿಡುತ್ತೇವೆ ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ನಮಗೆ ನಮ್ಮ ಮಾಲೀಕರಾದ ಜಿ ತುಳಸಿರಾಮ್ CW8 ಮತ್ತು ಕುಟುಂಬದವರು ವಾಸವಾಗಿರಲು ಮನೆಯನ್ನು ಕಟ್ಟಿದ್ದು ಅದರ ಒಂದು ಭಾಗವನ್ನು ಹೊಡೆದು ಹಾಕಿ ಅಲ್ಲಿದ್ದ ಮನೆಯ ಸಾಮಾನುಗಳನ್ನು ಮತ್ತು ನನ್ನ ಹಣ ಮತ್ತು ಆಭರಣಗಳನ್ನು ಹೊರಗಡೆ ಬಿಸಾಡಿ ಅದರಿಂದ ಸದರಿ ಮೇಲ್ಕಂಡ ಆರ್.ಕೆ. ರಮೇಶ್, ಸಮೀವುಲ್ಲಾ, ಕೇಶವ ರೆಡ್ಡಿ ಮತ್ತು ಮುಬೀನಾ ಇತರರ ವಿರುದ್ಧ ಕರೆದುಕೊಂಡು ಬಂದು ಅವರ ವಿರುದ್ಧ ಸೂಕ್ತ ಕ್ರಮ ಜರುಗಿಸಲು ತಮ್ಮನ್ನು ನಿಲ್ಲಿಸಿದರು. Based on this allegation, my lordship, initially the FIR was registered for the offence conferred under section 447, 427, 506, reduced section 149 IPC, reduced section 3, subsection 1, Roman letter V11, 10, 11 of SCST Act. Thereafter, my lordship, the investigation was put into the motion, my lordship, the charge sheet was filed with the state. Can you see the charge sheet? The gist of the allegation made in the charge sheet is at page number 37, column number 7. Yes. ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯ ಕಾಲಂ ನಂಬರ್ 6ರಲ್ಲಿ ನಮೂದಿಸಿದ ಸಾಕ್ಷಿ ಮತ್ತು 1 ಮತ್ತು 2ರವರು ಪರಿಶಿಷ್ಟ ಜಾತಿಯ ಆದಿ ದ್ರಾವಿಡ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿದ್ದು, ಕಾಲಂ 4ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A1 ಮತ್ತು A4
ಒಂದು ನಿಮಿಷ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಂ ನಂಬರ್ ದೋಷಾರೋಪಣ ಪತ್ರ ಕಾಲಂ ನಂಬರ್ 5. ಎಸ್.
ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯ ಕಾಲಂ ನಂಬರ್ 6ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರು ಪರಿಶಿಷ್ಟ ಜಾತಿಯ ಆದಿ ದ್ರಾವಿಡ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿದ್ದು, ಕಾಲಂ 4ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A1 ಮತ್ತು A4 ಆರೋಪಿಗಳು ರೆಡ್ಡಿ ಜಾತಿಗೆ, A2 ಮತ್ತು A3 ಆರೋಪಿಗಳು ಮುಸ್ಲಿಂ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿರುತ್ತಾರೆ. ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿ ಪೊಲೀಸ್ ಠಾಣಾ ವ್ಯಾಪ್ತಿಯ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿ 1ನೇ ಹಂತ ವಿಪ್ರೋ ಗೇಟ್ ನಂಬರ್ 7ರ ಮುಂಭಾಗದಲ್ಲಿರುವ ದೊಡ್ಡ ತೋಗೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 69/1 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 154ರಲ್ಲಿನ ಸ್ವತ್ತು ನಮಗೆ ಸೇರಿದ್ದೆಂದು, A1ರಿಂದ A4ರವರೆಗಿನ ಆರೋಪಿಗಳು ನಮಗೆ ಸೇರಿದ್ದೆಂದು ಮತ್ತು ಸದರಿ ಸ್ವತ್ತು ಸಾಕ್ಷಿ 8ರವರು ನಮ್ಮ ಕುಟುಂಬದವರಿಗೆ ಸೇರಿದ್ದೆಂದು ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳನ್ನು ಸಾಧಿಸುತ್ತಿದ್ದು, ಸದರಿ ಸ್ವತ್ತನ್ನು ಹಲವಾರು ವರ್ಷಗಳಿಂದ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರು ನೋಡಿಕೊಂಡು ಜಮೀನಿನಲ್ಲಿಯೇ ನಿರ್ಮಾಣ ಮಾಡಿದ್ದ ಶೆಡ್ಡಿನಲ್ಲಿ ವಾಸ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಹೀಗಿರುವಲ್ಲಿ ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯ ಕಾಲಂ 4ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A1ರಿಂದ A4ರವರೆಗಿನ ಆರೋಪಿಗಳೆಲ್ಲರೂ ದಿನಾಂಕ 13/9/2020ರಂದು ಬೆಳಗ್ಗೆ 7 ಗಂಟೆಗೆ ಸುಮಾರಿನಲ್ಲಿ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿ ಪೊಲೀಸ್ ಠಾಣಾ ವ್ಯಾಪ್ತಿಯ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಸಿಟಿ 1ನೇ ಹಂತ ವಿಪ್ರೋ ಗೇಟ್ ನಂಬರ್ 7ರ ಮುಂಭಾಗದಲ್ಲಿರುವ ದೊಡ್ಡ ತೋಗೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 69/1 ಹೊಸ ನಂಬರ್ 154ರಲ್ಲಿನ ಜಮೀನಿನ ಒಳಗಡೆ ಪ್ರವೇಶ ಮಾಡಿ, ಜಮೀನಿನಲ್ಲಿ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರು ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದ ಶೆಡ್ನ ಮುಂಭಾಗದಲ್ಲಿನ ಸ್ಥಳವನ್ನು ಜೆಸಿಬಿ ವಾಹನದಿಂದ ಮಟ್ಟ ಮಾಡಿಸಲು ಹೋದಾಗ ಇದನ್ನು ಕಂಡ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರು ಅವರು ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದ ಶೆಡ್ನಿಂದ ಹೊರಗಡೆ ಬಂದು A1ರಿಂದ A4ರವರೆಗಿನ ಆರೋಪಿಗಳಿಗೆ ಈ ಜಮೀನು ಸಾಕ್ಷಿ 8ರವರೆಗೆ ಸೇರಿದ್ದು, ನೀವು ಯಾರು, ಇಲ್ಲಿ ಯಾಕೆ ಕೆಲಸ ಮಾಡಲು ಬಂದಿರುತ್ತೀರಾ ಎಂದು ಕೇಳಿದಾಗ A1 ಮತ್ತು A4ರವರೆಗಿನ ಆರೋಪಿಗಳೆಲ್ಲರೂ ಸಾಕ್ಷಿ 1 ಮತ್ತು 2ರವರೆಗೆ ಈ ಜಾಗ ಏನು ನಿಮ್ಮ ಅಪ್ಪನದ ಬೋಳಿ ಮಕ್ಕಳ, ಮೊದಲು ಇಲ್ಲಿಂದ ಖಾಲಿ ಮಾಡಿಕೊಂಡು ಹೋಗಿ, ಇಲ್ಲವಾದಲ್ಲಿ ನಿಮ್ಮನ್ನು ಸುಮ್ಮನೆ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಬೈದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿರುವುದು ಇಲ್ಲಿಯವರೆಗಿನ ತನಿಖೆಯಲ್ಲಿ ದೃಢಪಟ್ಟಿದೆ. Based on this investigation report, my lordship,
yes.
So charge sheet for offence punishable under section 504, 506, reduced 34 IPC and section 32VA of SCST Act. Can you see at the bottom of the charge sheet in this ನಿವೇದನೆ ಸಾಕ್ಷಿ 8 ಮತ್ತು A1ರಿಂದ A4ರವರೆಗಿನ ಆರೋಪಿಗಳು ಸ್ವತ್ತಿನ ಸಂಬಂಧಿಸಿದಂತೆ ಹಕ್ಕು ಬಾಧ್ಯತೆ, ಅಂದ್ರೆ ಸಾಕ್ಷಿ 8 ಮತ್ತು A1ರಿಂದ A4ರವರೆಗಿನ ಆರೋಪಿಗಳು ಸ್ವತ್ತಿನ ಸಂಬಂಧಿಸಿದಂತೆ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳನ್ನು ಸಾಧಿಸುತ್ತಿದ್ದು, ಸ್ವತ್ತಿನ ವಿಚಾರದಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಪ್ರಕರಣಗಳು ಬಾಕಿ ಇರುವುದರಿಂದ ಪ್ರಕರಣದಲ್ಲಿ ಕಲಂ 447 ಮತ್ತು 427 IPC ಆರೋಪಗಳ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಲಭ್ಯವಾಗದ ಕಾರಣ ಹಾಗೂ ಆರೋಪಿಗಳು 3 subsection 1 subsection 5 3 1 10 3 subsection 1 subsection 10 11 of SCST Act ಅಪರಾಧ ಎಸಗುವ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಲಭ್ಯವಾಗದ ಕಾರಣ ಸದರಿ ಕಾಲಂಗಳನ್ನು ದೋಷಾರೋಪಣ ಪಟ್ಟಿಯನ್ನು ಕೈಬಿಟ್ಟಿರುತ್ತದೆ. From the gist of this investigation report, it is clear that my lordship, there is a civil dispute between the CW8 and the accused person. And further, it is also clear from the gist of this investigation report that my lordship, this complaint CW1 and CW2 are totally stranger to the accused person in this case. You see, my lordship, section 3 of the CST Act is not a substantial offense in this case. When you see the section, what the section 3 says in this case.
ಒಂದ್ ನಿಮಿಷ, ನೀವು ಇದನ್ನ ಕೈ ಬಿಡಲಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ದು ಎಲ್ಲಿದೆ?
ಕೆಳಗಡೆ ನಿವೇದನೆ ಕೆಳಗಡೆ
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ ನಂಗೆ.
ಪೇಜ್ ನಂಬರ್ 38, 37, 38 ಒಳಗೆ ಲಾಸ್ಟ್ one.
ಒಂದ್ ನಿಮಿಷ.
The bottom of the
37, 38 ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಬರ್ತಾ ಇದೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ my lordship, the allegation of trespassing and
ಇಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ 52 ನಲ್ಲಿ ಕಾಣ್ತಿದೆ ನನಗೆ. ಹೌದಾ?
52 ಅಲ್ಲ.
ಸಾಕ್ಷಿ 8 ಮತ್ತು A1 ರಿಂದ 4
ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸ ಅಂದ್ರೆ ಸರ್ವೆ ನಂಬರ್ 154 ಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ. Admitted fact my lordship. There is a dispute with respect to this land between this CW8 and this accused person.
ಹಾಗೂ ಆರೋಪಿಗಳು ಕಲಂ 315, 310 ಮತ್ತು 11 ಎಸಗಿರೋ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಲಭ್ಯವಾಗದ ಕಾರಣ ಸದರಿ ಕಲಂಗಳನ್ನು ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯಲ್ಲಿ ಕೈ ಬಿಟ್ಟಿರುತ್ತದೆ.
ಅಂದ್ರೆ the allegation
32VA ಇದೆ. ಓಕೆ, 3255A ಇದೆ. ಎಸ್ ಇವನ್ನಷ್ಟೇ ಕೊಟ್ಟಿದೆ.
As per the investigation report my lordship, the 447 and 427 has been dropped from the charge sheet in this case. I think my lordship, the criminal trespassing question ಬರೋದಿಲ್ಲ ಇದು. But 427 says about the my lordship the mischief causing damage to damage up to ₹50,000 and 50 rupees.
Yes.
Whatever the allegation made in the complaint my lordship, as per the investigation, it clearly shows that false allegation has been made in the complaint in this case. My lordship, if you kindly see the draft, the way in which the complaint was drafted, my lordship, clearly shows that my lordship some mastermind has been worked behind this complaint in this case. My lordship, CWA is a businessman, industrialist and businessman in this case. He is the person, my lordship, he is the root cause for all the disputes in this case.
Yes.
Kindly see, my lordship, prima facie, in order to invoke the provisions under section SC/ST Act, my lordship, the prosecution has to prove that the complaint is complaint belongs to the scheduled caste in this case. Further, the prosecution has to prove that my lord, in order to invoke section 32VA, my lordship, the prosecution has to establish that this accused person had a knowledge about the cost of this complaint in this case. I will read the provision of section 32VA in this case. Very much clear in this case.
ಇಲ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್
First, the prosecution has to establish
SC/ST Act.
Prima facie, my lordship, the prosecution has to establish the cost of the complaint in this. Next, my lordship, knowledge of the accused person with respect to the cost of this complaint in this. The both aspects has to be proved as per the section 32VA in this case. Section 3 says, my lordship, punishment for offences of atrocities. Subsection 2 says, whoever not being a member of scheduled caste or scheduled tribe, whoever not being a member of scheduled caste or scheduled tribe commits any offence specified in the schedule against a person or property, knowing is the important in this case. This is the ingredient of this section. Knowing that such person is member of a scheduled caste or a scheduled tribe, or such property belongs to such member, shall be punishable with such imprisonment as specified under the Indian Penal Code for such offences, and shall also liable to be fined. Well, lordship, the 32VA ಆಗ್ಬೇಕಾದ್ರೆ ಏನೇನು ಅಫೆನ್ಸ್ ಬರಬೇಕು ಅಂತ it has been mentioned in the schedule of this SC/ST Act. Schedule is at ಇದರ ಲಾಸ್ಟ್ ಕೊಟ್ಟಿದೆ, schedule ಇದೆ ಸರ್ ಮೇಲ್ಗಡೆ. ಇದರೊಳಗೆ as per the charge sheet offense, my lordship, the 5 or 6 ಒಂದೇ ಬರುತ್ತೆ ಇದರೊಳಗೆ to invoke the provision of this.
ನಿಮ್ ಪ್ರಕಾರ ಯಾವ್ದು ಶೆಡ್ಯೂಲ್ ಆಫೆನ್ಸ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ?
506 ಒಂದೇ ಬರುತ್ತೆ ಅಷ್ಟೇ. 504 ಬರೋದಿಲ್ಲ ಅದಕ್ಕೆ. 506 ಇದೆ ಅದು. ಅಲ್ಲಪ್ಪ ರೆಫರೆನ್ಸ್ ಐತಿ ಅಷ್ಟೇ. Lordship, kindly see page number 62 in this case. In order to prove that my Lordship, this complaint belongs to the scheduled caste, the requisition was the investigating officer has made a requisition.
Page number?
Page number 62 in this case.
62. Page 62 ನಲ್ಲಿ ಇದು ಟೈಪ್ಡ್ ಕಾಪಿ ಆಫ್ annexure C1 ಅಂತಿದೆ ನೋಡಿ. ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ಸ್ ಆಮೇಲೆ ಚೇಂಜ್ ಆಗಿದೆ ಅದು. ನೋಡಪ್ಪ ಯಾವ ಪೇಜ್ ಹೇಳ್ತಿದೆ ನೋಡಿ.
ಒಂದು ಲೆಟರ್ ರಿಕ್ವಿಷನ್ ಲೆಟರ್ ಬರೀತಾರೆ. ನುಡಿಪುರ ಜಾತಿ ಪ್ರಮಾಣದ ಪತ್ರ
ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಪೇಜ್ ನಂಬರ್ 62 annexure G1.
62 na
Requisition to be
annexure C1 na G1
annexure ಎಷ್ಟದು?
G1 ಅಂತ.
G1.
ಪೇಜ್ ನಂಬರ್ 78 ಅಂತ.
ನೀವು ಹೇಳೋ ಪೇಜ್ಗೂ ಇದಕ್ಕೂ ಟ್ಯಾಲಿ ಆಗ್ತಿಲ್ಲ ಅದು. ಆಯ್ತು. ಪ್ರಕರಣದ ತನಿಖೆ ಸಲುವಾಗಿ ಫಿರ್ಯಾದಿ ವೆಂಕಟಾಚಲಂ ಬಿನ್ ಕುಪ್ಪಂ
70 ವರ್ಷ ಎಂಬುವರ ಜಾತಿಯ ಬಗ್ಗೆ ದೃಢೀಕರಣ
ನೀಡಲು ಕೋರಿಕೆ.
14/9/2020 ಗೆ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಸರ್. Thereafter may have several requests was made to the Tahsildar to give the certified copy of his caste certificate. Later my lordship, kindly see the page number. In response to this requisition, my lordship, the Tahsildar ಒಂದು report ಕೊಡ್ತಾರೆ. Annexure H1.
Annexure G
ಅಲ್ಲ ಸೆಕೆಂಡ್ ಪೀರಿಯಡ್ ಎರಡು ಅದು ಸೇಮ್ ಆಗಿದೆ ಒಂದೇ ಆಗಿದೆ.
H1 ಅಂತಿದೆ ನೋಡಿ ಅದಾ?
H1 ಹೌದು ಸರ್. ಅದೇ ತಹಸೀಲ್ದಾರ್ ಬಂದಿದೆ ರಿಪೋರ್ಟ್. ತಹಸೀಲ್ದಾರ್ ಗ್ರೇಡ್ 2 ಒಂದು ಲೆಟರ್ ಇದರಲ್ಲಿ ಆ ರಿಕ್ವೆಷನ್ ಗೆ ಇವರು ರಿಪ್ಲೈ ಕೊಡ್ತಾರೆ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಶ್ರೀ ವೆಂಕಟಾಚಲಂ ಬಿನ್ ಕುಪ್ಪನ್ 70 ವರ್ಷ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸ್ ಅಡ್ರೆಸ್ ಇವರ ಜಾತಿ ದೃಢೀಕರಣ ಪತ್ರ ನೀಡಲು ಕೋರಿರುತ್ತೀರಿ. ಅಂದ್ರೆ ವೆಂಕಟಾಚಲಂದು ಜಾತಿ ದೃಢೀಕರಣ ಕೋರಿರುತ್ತೀರಿ. ಈ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ಸಂಬಂಧಪಟ್ಟ ಉಪತಹಸೀಲ್ದಾರ್ ಮತ್ತು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರಿಂದ ವರದಿ ಪಡೆಯಲಾಗಿದ್ದು ಸದರಿಯವರ ವರದಿಯಂತೆ ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಎಷ್ಟು ಈ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3 ಸಂಬಂಧಪಟ್ಟ ಉಪತಹಸೀಲ್ದಾರ್ ಮತ್ತು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಫಿರ್ಯಾದುದಾರರಿಂದ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರದ ಜೆರಾಕ್ಸ್ ಪ್ರತಿಯನ್ನು ಪಡೆದಿರುತ್ತಾರೆ. ಸದರಿ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರದ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ತಮಿಳು ಭಾಷೆಯಲ್ಲಿ ಇರುವುದರಿಂದ ಸದರಿಯರ ಜಾತಿ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ಮಾಡಲು ಸಾಧ್ಯವಾಗುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸುತ್ತಾ ಸದರಿ ದಾಖಲಾತಿಯನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಟ್ಟು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಕಳುಹಿಸಿದೆ. ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಇನ್ ದಿಸ್ ಕೇಸ್ ಕಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ಇದೆ.
ಒಂದು ನಿಮಿಷ. ಈ ಪೇಜ್ 87 ನಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ? ತಹಸೀಲ್ದಾರ್ ಗ್ರೇಡ್ 2 ಈ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3ರಂತೆ ಸಂಬಂಧಪಟ್ಟ ಉಪ ತಹಸೀಲ್ದಾರ್ ಮತ್ತು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರಿಂದ ವರದಿ ಪಡೆಯಲಾಗಿದ್ದು ಸದರಿಯವರ ವರದಿಯಂತೆ ಸದರಿಯವರು ನೀಡಿದ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರದ ನಕಲು ತಮಿಳು ಭಾಷೆಯಲ್ಲಿದ್ದು ಕನ್ನಡಕ್ಕೆ ಭಾಷಾಂತರ ಮಾಡಲಾಗಿದ್ದು ಅದರಂತೆ ಫಿರ್ಯಾದಿಯು ಆದಿ ದ್ರಾವಿಡ ಜಾತಿಗೆ ಸೇರಿರುವುದಾಗಿ ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
ಹೌದು, ಅದು ನೆಕ್ಸ್ಟ್ ಪಾಯಿಂಟ್ ಸಿ ನೆಕ್ಸ್ಟ್ ಅದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ ಬಗ್ಗೆ ಹೇಳ್ತಾರೆ. ಅದನ್ನ ನೆಕ್ಸ್ಟ್ ಕಾಪಿ ಇದ್ರೊಳಗೆ ಫಸ್ಟ್ ಲೆಟರ್ 24/6 ಗೆ ಕೊಡೋದಕ್ಕೆ ಈ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 2 ಮತ್ತು 3ರಂತೆ ಅಂದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಅಬ್ಲಿಯರ್ ರಿಕ್ವಿಷನ್ ಸಂಬಂಧಪಟ್ಟ ಉಪ ತಹಸೀಲ್ದಾರ್ ಮತ್ತು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಫಿರ್ಯಾದುದಾರರಿಂದ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರದ ಜೆರಾಕ್ಸ್ ಪ್ರತಿಯನ್ನು ಪಡೆದಿರುತ್ತಾರೆ. ಅದೇ ಜಾತಿ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ಪಡೆದಾದ್ಮೇಲೆ ಅದನ್ನು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡ್ತಾರೆ, ತಮಿಳು ಭಾಷೆಯಲ್ಲಿ ಇರುತ್ತೆ. ಸದರಿ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರದ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ತಮಿಳು ಭಾಷೆಯಲ್ಲಿ ಇರುವುದರಿಂದ ಸದರಿಯವರ ಜಾತಿ ಬಗ್ಗೆ ಪರಿಶೀಲನೆ ಮಾಡಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲವೆಂದು ತಿಳಿಸುತ್ತಾ ಸದರಿ ದಾಖಲಾತಿಯನ್ನು ಈ ಪತ್ರದಿಂದ ಲಗತ್ತಿಟ್ಟು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಕಳುಹಿಸಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ Next page is cash certificate.
ಈಗ ಅದೇ ಡೇಟಿನ ಒಂದು ಲೆಟರ್ ಅಲ್ಲಿ ನಾವು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡಿದ್ದೇವೆ, ಅದ್ರ ಪ್ರಕಾರ he belongs to ಆದಿ ದ್ರಾವಿಡ ಅಂತ ಹೇಳ್ತಾರೆ, ಹೌದಾ?
ಈಗ ನಂದು grievance ಏನು ಅಂತ ಹೇಳಿದ್ರೆ
ಹಾ, ನೆಕ್ಸ್ಟ್ ಲೆಟರ್ ಅಲ್ಲಿ ನಮಗೆ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಇನ್ನೊಂದು, ಈಗ ನೀವು ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಅವ್ರು, ನೀವು ಇನ್ನೊಂದು ಸ್ಟೇಟಿನ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ, ನಮ್ ಭಾಷೆ ಕನ್ನಡ, ನಾವು ಅದು ಟ್ರಾನ್ಸ್ಲೇಷನ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳಿ ಸುಮ್ಮನೆ ಇರ್ಲಿಕ್ಕೆ ಆಗತ್ತಾ? When some offense is committed.
Some offense has been committed in this case. ಅದ್ರೊಳಗೆ ಏನ್ ಹೇಳ್ತಾರೆ, ಅವ್ರು ತಹಸೀಲ್ದಾರ್ ಹೇಳ್ತಾರೆ ತಮಿಳ್ ಭಾಷೆಯಲ್ಲಿ, ಅಂದ್ರೆ ಅದನ್ನ ಹೋಗಿ, ಯಾಕೆಂದ್ರೆ ತಮಿಳ್ ಭಾಷೆಯಲ್ಲಿ ಇರೋದನ್ನ ಬೇಸಿಕಲಿ ಕಂಪ್ಲೇಂಟ್ ಇದು ಅವರು ತಮಿಳ್ನಾಡು
ಇರ್ಲಿ, ಎಲ್ಲಿ ಅವರಾದ್ರೂ ಇರ್ಲಿ, ಅಲ್ಲಿ ರೀಜನಲ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. It becomes the responsibility of the investigating officer to get it translated.
ಮಾಡ್ತಾರೆ, ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡ್ತಾರೆ ಅದನ್ನ ಅವರೇ ತಹಸೀಲ್ದಾರೇ ಮಾಡಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಕಾಪಿ ಕಳಿಸ್ಕೊಡ್ತಾರೆ ಇದ್ರ ಜೊತೆ. ಇದ್ರೊಳಗೆ ಅದ್ರೊಳಗೆ ಕೇಳಿರೋದು ಯಾರು ಕೇಳಿರೋದು, CW1 ಕೇಳಿರೋದು ಕಂಪ್ಲೇಂಟ್ ವೆಂಕಟಾಚಲಂದು ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೇಳಿರೋದು. ಈ ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್ ಒಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ, ಬಟ್ ದಿಸ್ ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್ ಡಸ್ ನಾಟ್ ಬಿಲಾಂಗ್ ಟು ದಿಸ್ ವೆಂಕಟಾಚಲಂ ಇನ್ ದಿಸ್ ಕೇಸ್, ದಿಸ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ CW2 in this case. Kindly see my lordship, who is the issuing authority? This cash certificate is in Tamil, my lordship, which clearly shows that basically she is this CW1 and 2 from Tamil Nadu.
ಆಯ್ತು, ಅವ್ರು ಎಲ್ಲಿಯವರೇ ಆಗ್ಲಿ,
ಎಲ್ಲರಿಗೆ ಆಗಿದೆ, ನಂದು ಅದಲ್ಲ. Even this certificate was issued by the Tahsildar Vaniyamapadi, Vellore district. 2008 ಅಲ್ಲಿ ಇಶ್ಯೂ ಆಗಿರುವಂತ ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ. ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ಡ್ಯೂಟಿ ಆಫ್ ದ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಟು ಕಲೆಕ್ಟ್ ದಿಸ್ ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್ ಫ್ರಮ್ ದಿ ಕನ್ಸರ್ನ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಪರ್ಸನಲ್ ತಗೊಂಡು ಮಾಡಿಸ್ಕೋಬೇಕು ಅದನ್ನ. ಯು ಕೆನಾಟ್ ರಿಲೇ ಅಪಾನ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಬೈ ದಿಸ್ ಕಂಪ್ಲೇಂಟ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ತಹಸೀಲ್ದಾರ್ ಡೈರೆಕ್ಷನ್ಸ್ ಏನು ಕೊಟ್ಟಿದ್ರು, ನೀವು ಇದನ್ನ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಇವ್ರು ಜಾತಿ ಪ್ರಮಾಣ ಇವ್ರ ಹತ್ರ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ದೇ ಶುಡ್ ಹ್ಯಾವ್ ಗಿವನ್ ಎ ಎಂಡರ್ಸ್ಮೆಂಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ದಿಸ್ ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ನಾಟ್ ರೆಸಿಡಿಂಗ್ ಇನ್ ಇಸ್ ನಾಟ್ ರೆಸಿಡೆಂಟ್ ಆಫ್ ಕರ್ನಾಟಕ, ಇವ್ರು ಮೂಲ ತಮಿಳುನಾಡು ಅವ್ರದ್ದು, ಹಂಗಾಗಿ ಟು ರಿಕ್ವೆಷನ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸೆಂಟ್ ಟು ಕನ್ಸರ್ನ್ ಅಥಾರಿಟಿ ಇನ್ ತಮಿಳುನಾಡು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. ಬಟ್ ಅದನ್ನ ಮಾಡಿ ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ. ವಾಟ್ ದೇ ತಹಸೀಲ್ದಾರ್ ಹ್ಯಾಸ್ ಡಿಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್ ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದನ್ನ ಒಂದು ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ಕೊಟ್ಟಿರ್ತಲ್ಲ, ಒರಿಜಿನಲ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬಿನ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್. ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಸೆಕೆಂಡರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಅನ್ ಅಡ್ಮಿಸಿಬಲ್ ಡಾಕ್ಯುಮೆಂಟ್. Now it's not an admissibility or relevance is not a question here in this case. Whatever it may be, their secondary document na ಕೊಡ್ತಾರೆ, ಅದನ್ನ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಕೊಡ್ತಾರೆ. ವೇರ್ ಇಸ್ ದಿ ಒರಿಜಿನಲ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಒರಿಜಿನಲ್ ಸಿಕ್ಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಆ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಹ್ಯಾಸ್ ಟು ಇಶ್ಯೂ ಮತ್ತೆ ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಕೊಟ್ಟಾಗ ತಹಸೀಲ್ದಾರ್ ವೆಲ್ಲೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಗೆ ಇಶ್ಯೂಡ್ ಆಫ್ ಇಶ್ಯೂಡ್ ಅನ್ನು ರಿಕ್ವೆಸ್ಟ್ ಲೆಟರ್ ಕೊಡಬೇಕಿತ್ತು, ರಿಕ್ವೆಷನ್ ಲೆಟರ್ ಕೊಡಬೇಕಿತ್ತು. ಯಾಕಂದ್ರೆ ಈಸ್ ದಿ ಇಶ್ಯೂಯಿಂಗ್ ಅಥಾರಿಟಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಇವ್ರ ಕಡೆಯಿಂದ ಅದನ್ನ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾ ಬೇಕಿತ್ತು. ದಿ ತಹಸೀಲ್ದಾರ್ ವಾಟ್ ಎವರ್ ದಿ ಕ್ಯಾಶ್ ಸರ್ಟಿಫಿಕೇಟ್
ಆಯ್ತು ಹೇಳಿ
ಮಾಡಿ ಅದನ್ನ ಮಾಡಿದ ಸಮೇತ ದೇರ್ ಇಸ್ ಅನ್ ಲ್ಯಾಕ್ ಇನ್ ದಿಸ್ ಪಾರ್ಟ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಸೊ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ದಿ cost of this CW1 and CW2 has not been proved by the prosecution. First of all, in this case. Second, my lordship, for an admitted sake, for argument's sake, my lordship, we admit that my lordship, this CW1 and 2 are belong to the schedule caste ಅಂತ ಬಂದ್ರು. ಇದರೊಳಗೆ ಮತ್ತೆ ಇನ್ನೊಂದು kindly see my lordship, ವೆಂಕಟಚಲಂ CW ಇದನ್ನ ಕಂಪ್ಲೀಟ್ ದಿ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ ಇದೆ. ಈ ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇರೋದೇ ಯಾರು, ರುಕ್ಕುಮಾಲ್ ಅಂತ. ಅಂದ್ರೆ ಈ ರುಕ್ಕುಮಾಲ್ ಇದೇ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ರುಕ್ಕುಮಾಲ್ ಅನ್ನೋದು there is no document in this case. ಇದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಈಗ ರುಕ್ಕುಮಾಲ್ ಕೊಟ್ಟಿಲ್ಲ, ವೆಂಕಟಾಚಲಂ ಕೊಟ್ಟಿಲ್ಲ, ರುಕ್ಕುಮಾಲ್ CW2 ಕ್ಯಾಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಆಬ್ಜೆಕ್ಟ್ಲಿ there is no document to show that CW1 is the schedule belongs to schedule caste ಅಂತ ಹೇಳ್ತಾರೆ. Second point, my lordship, as per section 32 VA, my lordship, knowledge of the accused person regarding the cost of this complaint should be adu prove ಮಾಡಬೇಕು. The prosecution has to prove that my lordship, as on the date of commission of offense, he had the knowledge that my lordship this complaint was belong to the scheduled caste and scheduled tribe. Knowing is very important. Absolutely, there is no document to show that in this case, because as per the gist of the investigation report, it has been clearly mentioned that ಒಳಗೆ ಬರ್ತಿದ್ದಂಗೆ ನೀವ್ ಯಾರು, ಯಾಕೆ ಬಂದಿದ್ದೀರಾ ಅಂತ ಕೇಳಿದಾಗ it clearly shows that my lordship, this complaint and this accused person are strangers in this case. My lordship, ನನಗೆ ನಾಲೆಡ್ಜೇ ಬದಲ ಅಂತ ಹೇಳಿದಾಗ, ಅವ್ರ ಕಾಸ್ಟ್ ಬಗ್ಗೆ ನಾಲೆಡ್ಜೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ, then where is the question of involving this provision in this case? My lordship, abruptly, my lordship, this without application of mine, my lordship, this investigating officer has invoked this section 32 VA in this case. Further, my lordship, the only two offences are remaining. In order to prove the alleged offences, my lordship, the 16 witnesses, there are investigating officer has quoted 16 witnesses in this case, and he has produced several documents with respect to the when you see, my lordship, the CW3 to CW8 are listed the eyewitnesses in this case. When you see, my lordship, the further, my lordship, what the prosecution case is that this complaint has been residing in survey number 154 and absolutely there is no document to show that my lordship, this complaint was residing in that said address. When you see, as per the complaint allegation, my lordship, it has been stated that since 30 years she has been residing in that property and there is one document in this case. When you see, my lordship, the election card, The election card was issued in the year 2005. ಇದ್ರೊಳಗೆ. And ಈ ಅಡ್ರೆಸ್ ಇರೋದು ಆನೇಕಲ್ಲು, ಬೆಂಗಳೂರು, ಶಿಕಾರಿಪೇಟೆ, ಬನ್ನೇರುಘಟ್ಟ ಸರ್ಕಲ್ ಅಂತ. It is that annexure. Page number 54 also. Election ಆಯೋಗದ ಇದ್ರೊಳಗೆ.
Annexure number ಹೇಳಿ. Annexure.
Annexure C3. ಅದು ಐಡೆಂಟಿಟಿ ಇದು ಎಲ್ಲದೂ ಸೇರಿ C1 to C4 ಅಂತಾನೆ ಮಾಡಿದ್ದೀವಿ.
G1 to G4. C1. C.
50, page number 54.
ಯಾವಾಗ್ಲೂ ನಿಮ್ಮ ಫೈಲ್ ಪೇಜ್ ನಂಬರು ನಮ್ದು ಇದಾಗ್ಬೇಕು. ಟ್ಯಾಲಿ ಆಗ್ಬೇಕು ಅದು. C1 to C4 ಆರ್ ಇದೇನು ಒಂದು ಇದಿದೆ, ಪಂಚನಾಮೆ ಇದೆ, ಆಮೇಲೆ ಫೋಟೋಸ್ ಇದೆ.
ಫೋಟೋಸ್ ಆದ್ಮೇಲೆ ಇದೆ.
ಫೋಟೋಸ್
ಫೋಟೋಸ್ ಆಗಿ 2 ಪೇಜ್ ಆದ್ಮೇಲೆ ಇದೆ.
ಓಕೆ. ಐಡಿ ಕಾರ್ಡ್ಗಳು, ಎಲೆಕ್ಷನ್ ಐಡಿ ಕಾರ್ಡ್. ಓಕೆ. ಓಕೆ. ಪೇಜ್ 70.
ಶಿಕಾರಿಪೇಟೆ, ಬನ್ನೇರುಘಟ್ಟ ಸರ್ಕಲ್. ಇದ್ರೊಳಗೆ 2005 ನಲ್ಲಿ ಇಶ್ಯೂ ಆಗಿರೋದು. ಅಂದ್ರೆ ಲಾಸ್ಟ್ 30 years ಇಂದ ಅವ್ರ ಪ್ಲೇಸ್ ಅಲ್ಲಿ ವಾಸ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದಾಗ 2005 ನಲ್ಲಿ ಈ ಅಡ್ರೆಸ್ ಯಾಕೆ ಬಂತು ಅಂತ. ಅದೇ ಅಡ್ರೆಸ್ ಒಟ್ಟುಗೂರು ಅಡ್ರೆಸ್ ಇರಬೇಕಿತ್ತು. ಮೋರೋವರ್ ಇನ್ ದಿಸ್ ಕೇಸ್ ಯು ಕೈಂಡ್ಲಿ ಸಿ ಮೈ ಕೇಸ್ ಆಫ್ ದಿಸ್ ಕಂಪ್ಲೇಂಟ್ ಇತ್ತು. ಇದರೊಳಗೆ ನಾನು ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಆಗಿ ನನಗೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದು CW8 ಅಂತ ಹೇಳ್ತಾರೆ. ಕೈಂಡ್ಲಿ ಸಿ ದಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಇಸ್ ದೇರ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಸೇಲ್ ಡೇಟ್ ಬಟ್ CW8 ಗೆ ಆ ಸರ್ವೆ ನಂಬರ್ ಮೇಲೆ ಆಸ್ ಪರ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಲೆ ಅಷ್ಟೇ 2008 ಅಲ್ಲಿ ನಾನು ರೈಟ್ಸ್ ಅಂತ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ. ಆಸ್ ಪರ್ ದಿ ಸೇಲ್ ಡೀಡ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಸೇಲ್ ಡೀಡ್ ಡೇಟೆಡ್. Page number 92 in this case. 92.
ಏನಂತ ಅನ್ನೆಕ್ಷರ್ ಸೇಲ್ ಡೀಡ್ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ಒಂದು ನಿಮಿಷ. 125 ಅಲ್ಲಿ ಇದೆಯಾ? ಅಗ್ರಿಮೆಂಟ್ ಸೆಲ್ ಅಂತ ಒಂದಿದೆ. ಹಿಂದಿರೋ ಡಾಕ್ಯುಮೆಂಟ್. ಓ, ಇದು ಮ್ಯೂಟೇಶನ್ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್. ಒಂದೇನೋ ಇಲ್ಲಿದೆ ಇದೆ. ಒಂದು ನಿಮಿಷ. ಸೇಲ್ ಡೀಡ್
14/2/2008.
108 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ಸೇಲ್ ಡೀಡ್ ಡೇಟೆಡ್
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಬಂದ್ರೆ ಅದೇ ಪೇಜ್, ಅದೇ ಡಾಕ್ಯುಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್
14/2/2008.
ಅದೇ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಒಳಗೆ ಜಿ ತುಳಸಿರಾಮ್ ಸೇರಿನ ಆಫ್ಟರ್ ರೆಫರ್ ಟು ಆಸ್ ಪರ್ಚೇಸರ್ ಚೆಸ್ಟ್ ಇದರಲ್ಲಿ ಪರ್ಚೇಸರ್ ತುಳಸಿರಾಮ್. ದಿಸ್ ಇಸ್ ದಿ ತುಳಸಿರಾಮ್ ಮೈಲಾಶಿ CW8 ಮೈಲಾಶಿ. ಮೈಲಾಶಿ ದಿ ಅಕ್ವೈರ್ ಆಸ್ ಪರ್ ಹಿಮ್ ಮೈಲಾಶಿ ದಿ ಅಕ್ವೈರ್ಡ್ ದ ರೈಟ್ಸ್ ಓವರ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪೀಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಇನ್ ದಿ ಇಯರ್ 2008 in this case.
ತುಳಸಿರಾಮ್ ಎಲ್ಲಿದೆ ಇದು?
CW8
ಡೈನಾಸ್ಟಿ ಡೆವಲಪರ್ಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್, ಬೃಂದಾವನ್ ಬ್ರಿವರೇಜ್, ಕೃಷ್ಣಚಂದ್
ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್. He is the owner of this company.
ಮೋಹನ್ ಲಾಲ್ ವಾಧ್ವಾ ಇನ್ ಫೇವರ್ ಆಫ್ ಲಹರಿ ಟೆಕ್ನಾಲಜೀಸ್. ಆಮೇಲೆ ಇಲ್ಲಿ ಆಥರೈಸ್ ಸಿಗ್ನೇಟರಿ ಜಿ ತುಳಸಿರಾಮ್ ರೆಫರ್ ಟು ಆಸ್ ದಿ ಪರ್ಚೇಸರ್.
ಅಂದ್ರೆ as per this document my lordship, this Tulsiram has acquired the rights over this particular piece of land in the year 2008 in this case. ಅವ್ರು ಮತ್ತೆ 30 years ಇಂದ ಇದರ ಜಾಗದಲ್ಲಿ ವಾಸವಾಗಿದ್ದೀರಾ ಅಂತ ಹೇಳಿದ್ರೆ it clearly shows that my lordship at the 30 years back ಅವರಿಗೆ ರೈಟ್ಸ್ ಇರಲಿಲ್ಲ particular piece of land ಮೇಲೆ.
Yes.
My lordship, kindly see my lordship. Admittedly there is a civil dispute with respect to this land. Originally this 2 acres of land in survey number 154 my lordship belongs to the accused number 2 and 3 in this case. The originally this 2 acres of land was belong to Mr. Karusab in this case.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಅದು?
ಸರ್ವೆ ನಂಬರ್ ಅದೇ ಈ ಲ್ಯಾಂಡ್ ಒಳಗೆ ಏನು ವಾಸವಾಗಿದ್ದೀರಿ ಅಂತ ಹೇಳಿ ಸರ್ವೆ ನಂಬರ್.
Yes. 2 acres.
2 acres ಅಷ್ಟೇ 2 acres ಅಷ್ಟೇ.
Belong
Old
to.
survey number 69/1, new survey number 154 in this case. Dottuguru village. ಈ particular piece land ಏನಿದೆ ಸರ್, ಒಂದು Mr. Parasab was the owner in this case. He died long back, my lordship, leaving behind this accused number 2 and 3 and other family members to succeed to this property in this case. What has happened in this case with respect to this land, my lordship? In the year, when Mr. Usna Bai, claiming to be the second wife of this Parasab, had made an sale transaction over this particular 2 acres of land in favor of Hussain Saab. In turn, my lordship, Hussain Saab sold this scheduled property, this 2 acres of land, in favor of Saraswati and this CW8 in this case. This fact came to the knowledge of this accused number 2 and 3 in the year 2000 in this case. After coming to know this about the sale transaction, my lordship, they filed a suit in this case. Before the invoice number. I could be the judgment calculator. Invoice number 16751 of 2002 in this case for declaration and permanent injunction in this case. Declaration is that, my lordship, whatever the sale deed executed by the second wife, Parasab, second wife ಅಂತ ಏನು ಸೇಲ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರು ಏನು ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿಕೊಟ್ಟಿರೋ ಆ ಸೇಲ್ ಡೀಡ್ ಇಸ್ ನಾಟ್ ಬೈಂಡಿಂಗ್ ಆನ್ ಅವರ್ ರೈಟ್ಸ್ and also this is for a suit permanent injunction to restrain these defendants from disturbing their possession of the scheduled property and everything. After the full-fledged trial, my lordship, the judgment was pronounced in this case. Suit was allowed in this case. The entire sale transaction in the name of the CW8 and Saraswati was cancelled in this case. And there was a specified and also passing a decree restraining this defendant from disturbing the possession of this accused number 2 and 3 over this 2 acres of land in this case. When you see the judgment decree is the last part of it. The matter was fully contested by the CW8 in this case. Complete contest matter. Contest madi, he failed to establish his possession over this 2 acres of land in this case. Thereafter, my lordship, the decree was passed in favor of this accused number 2 and 3 in this case. Kindly see, my lordship, it is also declared that sale deed dated 23/4/2004 and 16/2/2008. Again, now notice stands in the name of this Tulsiram in favor of defendant number 6 and 7. So, defendant number 7, Tulsiram was the defendant number 7 in the suit in this case. Are also not binding upon the plaintiff, as the same are hit by the principles of despondency. The defendants or anybody on their behalf are hereby restrained by permanent injunction from interfering with the plaintiff's peaceful possession and enjoyment of the scheduled property. Scheduled property is the 2 acres of land in this case. Thus, my lordship, as per the judgment and decree of this honorable court, my lordship, the accused number 2 and 3 were in the peaceful possession of the 2 acres of land in this case. When they, as per this judgment, my lordship, accused number 2 and 3 are in the peaceful possession of the property and tell that when there is the question of this question, my lordship, the complaint was residing in the scheduled property in this 2 acres of land. As per this judgment, my lordship, the entire contention of the prosecution that, my lordship, this complaint was residing in the 2 acres of land is falsified in this case. Thereafter, after this judgment, my lordship, the accused number 2 and 3 sold the property in favor of this accused number 1 in this case by delivering its possession in this case. My lordship, the petitioner, the accused number 1, who is one on petition in this petition, has purchased this property for more than 8 crores in this case. Ever since the date of purchase, my lordship, he has been in the possession of the property. Now, my lordship, after passing of the judgment, this property was sold in this case. Thereafter, my lordship, the RFA has been filed in this case. RFA has been filed challenging this judgment and decree in this case. My lordship, the only reason behind there is an civil dispute, they try to give a color of criminal nature color production. The purpose is that, my lordship, to show their possession in this case. ಅವ್ರಿಗೆ ಬೇಕಾಗಿದ್ದು ನಮ್ಮ ಪೊಸೆಷನ್ ತೋರಿಸ್ಕೋಬೇಕಿತ್ತು, ಪೊಸೆಷನ್ ತೋರಿಸ್ಕೊಳ್ಳೋದಕ್ಕೆ they filed this false complaint in this case. ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಮೋರ್ in this case 447 criminal trespass has been dropped from the charge sheet in this case. Allegation ಇದ್ರೊಳಗೆ criminal trespass ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಮತ್ತೆ ಅವ್ರ ಕ್ವಶನ್ ನಂದ್ರೆ that means, my lordship, I am in the legitimate ಇದ್ರೊಳಗೆ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಬಂದಿದ್ದೀನಿ ಅಂತ First of all, my lordship, the prosecution has failed to prove the cost of this CW1 in this case here. Thereafter, my lordship, it has failed to prove that this accused person has had a knowledge about the cost of this complaint and everything. Further, my lordship, the prosecution has totally failed to prove that, my lordship, this CW1 was in the possession of 2 acres of land in this case here. Hence, my lordship, the section 32VA does not, the basic ingredients of the section is not attracted by the whatever the materials collected by this investigating officer. Further, my lordship, the 504 and 506 is there in this case. Kindly see the section 504 in this case.
Yes.
The question is that, my lordship, whether the material evidence collected by this investigating officer prima facie satisfy the basic ingredients of the section 504 on the by what 504 says that, my lordship, the intentional insult with intent to provoke breach of the peace of the peace. Whoever intentionally insults and thereby gives provocation to any person intending or knowing it to be likely that such provocation will cause him to break the public peace or to commit any other offense. Kindly see the gist of the allegation report. ನಾನು ಏನು ಪ್ರೊವೋಕ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು CW ಅವನು ನಾನು ಪ್ರೊವೋಕ್ ಮಾಡಿದ ತಕ್ಷಣ ಅವನು ಇನ್ನೊಂದು ಅಫೆನ್ಸ್ ಕಮಿಟ್ ಮಾಡ್ಬಿಡ್ತಾನೆ, ಬ್ರೀಚ್ ಆಫ್ ಪೀಸ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾನೆ. ಈಗ ಕ್ವಶನ್ ಇದ್ದ ರಿಲಿಜಿಯಸ್ ಸೆಂಟಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ದೊಡ್ಡ ಭಾಷಣ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅದರ ಇದಾದಾಗ ಪೀಸ್ ಇದನ್ನ ಬ್ರೀಚ್ ಆಫ್ ಪೀಸ್ ಆಗುತ್ತೆ ಅನ್ನೋದಕ್ಕೆ ಒಂದಿದ್ರು ಇಂಟೆನ್ಷನ್ ಇನ್ಸಲ್ಟ್ ನನಗೇನೋ ಅವ್ನು ಇಲ್ದಿರೋದನ್ನ ಕೆಟ್ಟಾಗಿ ನಾನು ಬೈದಾಗ ಆಗತ್ತೆ ಅಂತ ಇದ್ರೊಳಗೆ ವಾಟ್ ಇದನ್ನ ನಾನು ಏನು ಇನ್ಸಲ್ಟ್ ಮಾಡಿದ್ದೀನಿ, ನಾನು ಏನು ಅವ್ನಿಗೆ ಪ್ರೊವೋಕ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಟು ಕಮಿಟ್ ಸಮ್ ಅದರ್ ಅಫೆನ್ಸ್ ಅಂತ ಹೇಳಿ. Absolutely, there is no material evidence in this case. My lordship, with respect to kindly see the 506 criminal intimidation. My lordship, the section 506 has to be read with section 501 in this case. Criminal intimidation in it has been stated in 503 nolage ಹೇಳ್ತಾ ಇದೆ. Whoever threatens another with any injury to his person, reputation or property, or to the person or reputation of any in whom that person is interested, with intent to cause all wrong to that person, or to cause that person to do any act which he is not legally bound to do, or to omit to do any act which that person is legally entitled to do, as the means of avoiding the execution of such threat, commits criminal intimidation. My lordship, kindly see Mari. For an argument sake, my lordship, it admits down possession ಇಂದ ಈ ತರ ಬಂದು ನಿಮಗೆ ಜೀವ ಬೆದರಿಕೆ ಆಗ್ತಾ ಸಾಯಿಸ್ಬಿಡ್ತೀವಿ ಅಂತ ಎದುರಿಸಿ. My lordship, mere expression of word would attract the ingredients of section 506 and question. My lordship, in order to attract section 506, my lordship, the intention of the accused has to be established to the prosecution in this case. Unless and until, my lordship, the prosecution fails to prove the intention on the part of this accused person, my lordship, the 506 cannot be invoked in this case. ಯಾಕಂತ ಹೇಳಿದ್ರೆ ರೆಗ್ಯುಲರ್ ಕೋರ್ಸ್ ಒಳಗೆ ಸುಮ್ಮನೆ ನೀನು ಸಾಯಿಸ್ಬಿಡ್ತೀನಿ ಅದು ಮಾಡ್ತೀನಿ ಹಂಗ ಅನ್ಕೊಂಡು ಹೋಯ್ತು ಅಂತ ಹೇಳಿದ್ರೆ 1000 ಕೇಸ್ 506 ಅಫೆನ್ಸ್ ಆಗ್ತಾ ಹೋಗ್ಬೇಕಾಗ್ತದೆ. ಮೇರ್ ಎಕ್ಸ್ಪ್ರೆಷನ್ ಆಫ್ ವರ್ಡ್ ಇಸ್ ನಾಟ್ ಸಫಿಷಿಯಂಟ್ ಟು ಅಟ್ರಾಕ್ಟ್ ದಿ ಸೆಕ್ಷನ್ 506 in this case. Intention should be there in this case. What the Supreme Court says in this case, kindly see the two judgments are there in this case with respect to the 504 and 506 in this. Under what circumstances, my lordship, the 504 ಹೆಂಗ್ ಅಟ್ರಾಕ್ಟ್ ಮಾಡಬೇಕು, 506 ಯಾವ ತರ ಅಟ್ರಾಕ್ಟ್ ಆಗಬೇಕು ಅಂತ ಹೇಳಿ. ಅಲ್ಲ ಪ್ರೊವೊಕೇಶನ್ ಯಾವ ಡಿಗ್ರಿನಲ್ಲಿ ಇರಬೇಕು ಅನ್ನೋದಕ್ಕೆ
ಕಾಪಿ ಕೊಡ್ಬೇಕು ಸರ್.
ಕೊಡ್ತೀನಿ. With respect to the section 504 of IPC, Ramesh Chandra Vaishya was the state of UP circuit. Can you see para number 22 in this? Para number 23. ಇದ್ರೊಳಗೆ ಒಂದು ಡ್ರೈನೇಜ್ ಇಶ್ಯೂ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಆಲ್ಟರ್ಕೇಶನ್ ಆಗುತ್ತೆ, ಜಗಳ ಆಗುತ್ತೆ, ಬೈದಾಡ್ತಾರೆ, ಇದೆಲ್ಲ ಮಾಡ್ತಾರೆ. ಇದ್ರೊಳಗೆ SC/ST ಪ್ರಾವಿಷನ್ಸ್ ಸೆಕ್ಷನ್ 3 ಇನ್ವಾಲ್ವ್ ಮಾಡ್ತಾರೆ, 324 ಮತ್ತೆ 504 ನೆಲ್ಲ ಇದು ಮಾಡ್ತಾರೆ. ಅದನ್ನ ಫಸ್ಟ್ ಹೈಕೋರ್ಟ್ ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡುತ್ತೆ, ಪಾಸ್ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ವೆಂಟ್ ಟು ದಿ ಅಪೀಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇನ್ ದಿಸ್. ಆಫ್ಟರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಬ್ಸರ್ವಿಂಗ್ ದಟ್ ಬೇಸಿಕ್ ಇಂಗ್ರೀಡಿಯಂಟ್ ಯಾವ offense ಅಟ್ರಾಕ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು it passed with the entire proceeding in this case. And you see what remains in section 504 IPC. Clear na idrolage ಇನ್ನೊಂದು ಹೈಕೋರ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ರೆಫರ್ ಮಾಡ್ತಾ ಇದೆ. Section 504 IPC comprises of the following ingredients. Intentional insult. The insult must be such as to give provocation to the person insulted. Provocation to the person insulted, and the accuser must intend or know that such provocation would cause another to break the public peace or to commit any other offense. The intentional insult must be such a degree that should provoke a person to break the public peace or to commit any other offense. The person who intentionally insults, intending or knowing it to be likely that it will give provocation to any other person, and such provocation will cause to break the public peace or to commit any other offense. In such a situation, the ingredients of section 504 are satisfied. One of the essential elements constituting the offense is that there should have been an act or conduct amounting to intentional insult, and the mere fact that the accused abused the complaint as such is not sufficient by itself to warrant a conviction under section 504 IPC. Based on the facts and circumstances, the deeply hesitation in holding that even though the appellant might have abused the complaint, but such abuse by itself and without anything more does not warrant subjecting the appellant to face a trial, particularly in the clear absence of the ingredient of intentional insult of such a degree that it could provoke a person to break a public peace or commit any other. Intentional insult. It should be in such a degree that my lordship, ಯಾರಿಗೆ ನಾ ಬೈತಾ ಇದ್ದೀನ ಆ ಪರ್ಸನ್ ನಾನು ಬೈಯೋದ್ರಿಂದ ಪ್ರವೋಕ್ ಆಗಿ ಅವ್ನಿಗೆ ಬೇರೆ ಅಫೆನ್ಸ್ಗಳು ಮಾಡೋದಕ್ಕೆ ನಾವು ಇದು ಮಾಡಂಗಿರ್ಬೇಕು. There is no such material available on record my lord to show that my lordship ನಾನು ಅಷ್ಟು ಆ ಡಿಗ್ರಿನಲ್ಲಿ ಇನ್ಸಲ್ಟ್ ಮಾಡಿದ್ದೆ, ಅವನಿಗೆ ಅವನು ಬೇರೆ ಅಫೆನ್ಸ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದ, ಅವನು ನಾನು ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಿ ಅಂತ ಹೇಳಿದ್ರು. There is no material. When you see with respect to the 506 in this case. Recent judgment 2020 final judgment. Naresh Aneja versus State of PT ನಲ್ಲಿ. When you see the case number, para number 13 in this case.
Para 13.
Examine the next charge for which the appellant stand accused. For an offence under section 503 to be established, it must be shown that threatening a person with any injury to his person, reputation or property. Second, to the person or reputation of anyone in whom that person is interested. Such threat must be intentional to cause alarm to that person or to cause that the person to do any act which he is not legally bound to do as the means of avoiding the such execution of such threat. Third one, to cause that person to omit to do any act which that person is legally entitled to do as the means of avoiding the execution of such threat. Punishment for this offence is prescribed in 503. 503 nodage criminal intimidation ಹೇಳ್ತಾರೆ, unless and until the criminal 503 ingredients of section 503 is not established by the 506 cannot be invoked at all in this case. Well, actually, what Supreme Court says in this case with respect to ಇದರೊಳಗೆ 3 bench ಇದ್ರೂ ರೆಕಾರ್ಡ್ ಅಫರ್ ಮಾಡ್ತಾ in the following sense ಯಾವ ತರ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ. A mere reading of the definition of criminal intimidation that there must be an act of threatening to another person, of causing an injury to the person, reputation or property of the person, or property of the person threatened, or to the person in whom the threatened person is interested, and the threat must be with the intent to cause alarm to the person threatened, and it must be to do any act which he is not legally bound to do or omit to do. Definition as it is the intention of the accused that has to be considered in deciding as to whether that he has stated what he has stated comes within the meaning of criminal intimidation in this case. The threat must be the threat must be with intention to cause alarm to the complaint, to cause that person to do or omit to do any work. Mere expression of any words without any intention to cause alarm would not be sufficient to bring in the application of this section. But material has to be placed on record to show that intention is to cause alarm to the complainant.
Yes.
Only my lordship, what material is there to show that my lordship ಈ ತರ ಇದೆ, ನನಗೆ intention ಇತ್ತು ಅವನಿಗೆ ಇದು ಮಾಡಬೇಕು ಅಂತ. ಮೇರ್ ಎಕ್ಸ್ಪ್ರೆಷನ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ರು.
Yes.
Absolutely, there is no material evidence in this case. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ in para number 13(3) ನಲ್ಲಿ what was from the judgment reporting that for an offense criminal intimation to be a prima facie established. Criminal intention, the intention should be clearly visible. And the same is to be established by evidence on record. And there should be some record in this case to show that there is an intention in this case. If the prosecution fails to show any intention, that's defined in section 506, my lordship, the section 506 cannot be invoked at all.
Yes.
Thus, my lordship, from the material evidence available on record and charge sheet, my lordship, absolutely there is no material, there is nothing on record to attract the basic ingredients of the alleged offences in this case.
Yes.
Possession has not been proved, cost has not been proved, basic ingredients of section 501, 504 is not proved, a knowledge of this accused person with respect to the cost of this complaint is not there, has not been proved. Nothing has been proved in this case. Moreover, in this case, admittedly there is a civil dispute. Non-civil judgment ನನ್ನ ಕೇಸ್ ಗೆದ್ದಿದ್ದೀನಿ, ನನ್ನ possession protect ಆಗಿದೆ, ನನ್ನ possession court full-fledged trial ಆದ್ಮೇಲೆ I clearly held that I am in the peaceful possession of the property and directed the defendant not to disturb my possession ಅಂತ ಹೇಳ್ಬಿಟ್ಟು court judgment ಕೊಟ್ಟಿದೆ ಆದ್ಮೇಲೆ. In spite of that, my lordship, the police is saying that my lordship, the complaint is residing in the 2 acres of land and he has to this ಇದ್ರೊಳಗೆ ಅವನು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದ ಅಂತ ಹೇಳಿದ್ರೆ, how come it in this case? Why he has not established all these facts in the civil suit in this case? Full-fledged trial ಆದ್ಮೇಲೆ ನನಗೆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರೋದು ಅದನ್ನು, ನೀನಪ್ಪ ಈ ಸ್ವಾಧೀನದಲ್ಲಿ ಇದೆಯಾ, ಇದನ್ನ ಹೋಗಿ ಎಂಜಾಯ್ ಮಾಡೋ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಷ್ಟು ಟೈಮ್ ಮಾಡಿದ್ದಾರೆ. ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ಈ ಕೇಸ್ಗಳು ಹಾಕೊಂಡು ಈಗ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಗೆ ಕ್ರಿಮಿನಲ್ ನೇಚರ್ ಇದನ್ನು ಕೊಟ್ಟು ಸುಮ್ಮನೆ ಸಿಂಪ್ಲಿ ದೇ ಆರ್ ಅರೈಸಿಂಗ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ಐ ಹ್ಯಾವ್ ಪರ್ಚೇಸ್ಡ್ ದಿಸ್ ಲ್ಯಾಂಡ್ ಫಾರ್ 8.75 lakhs rupees in this case. ಈ ತರ ಕೇಸ್ಗಳು ಇರೋದ್ರಿಂದ ಐ ಕುಡ್ ನಾಟ್ ಏಬಲ್ ಟು ಎಂಜಾಯ್ ದಿ ಪ್ರಾಪರ್ಟಿ, ಐ ಕುಡ್ ನಾಟ್ ಮೇಕ್ ಎನಿ ಡೆವಲಪ್ಮೆಂಟ್ಸ್ ಇನ್ ದ ಪ್ರಾಪರ್ಟಿ ಇನ್ ದಿಸ್ ಕೇಸ್.
Yes.
ಹೀಗಾಗಿ ಟ್ರಯಲ್ಗೆ ಹೋಗೋದ್ರಲ್ಲಿ ವೇಸ್ಟ್, ಇಟ್ಸ್ ಅನ್ ವೇಸ್ಟ್ ಆಫ್ ಜುಡಿಷಿಯಲ್ ಟೈಮ್ ಇನ್ ದಿಸ್ ಕೇಸ್. ಸೊ ಮೈ ಲಾರ್ಡ್ಶಿಪ್, ದಿ ಎಂಟೈರ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ has to be quashed against this petition.
Yes.
Not may I request your lordship to kindly take the judgment not which my learned friend gave. The decree, judgment and decree not in the civil suit.
ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಲ್ಲ.
Are ಇವಾಗ ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ. Judgment ಅಲ್ಲಿ lordship may kindly come to not ink page 58 para 42. Not though FIR not, this is why we not do, though FIR was initially not for 427, not as well as for 447, that is not trespass. Not though it is not charge sheeted, not I advise not the complainant to file a protest petition. Anyway, not your lordship can have a look at this. I'll bring to your lordship how even trespass is made out. Para 42, ink page 58.
Para 42.
Initially, when the suit was filed with the plaintiff and the accused, he has contended at para 7 that the cause of action arose for suit on 21/9/1998 when the plaintiff went to suit scheduled property to demand the possession. Kindly mark this word. They are not an actual possession even according to their own pleadings. This may not your lordship kindly mark. And kindly come to not page 59. In the middle of page, what is the finding of not the learned trial judge? Admittedly, the suit scheduled property is a vacant land. Middle of page, not. Admittedly, suit scheduled property is a vacant land and hence
the order of
amendment remained unchallenged. Admittedly, the suit scheduled property is a vacant land and hence there cannot be a physical possession of suit scheduled property. Only the person who is having title over the property is having constructive possession of vacant land. In the civil suit, the pleading is that the plaintiff is not in possession. The plaintiff's pleading, not my pleading. The finding is, since there is a registered sale deed, is in constructive possession. Now this judgment, what has now been called in question, what your lordship will find, the interim order passed by the honorable division bench of this honorable court, not. Nana court page number 88 alli ide.
ಇದರಲ್ಲೇ ಇದೆಯಾ ಅಥವಾ
ಇದರಲ್ಲಿ ಅವರು ಪಿಟಿಷನ್ ಅಲ್ಲಿ page 88
88. Annexure H2 ಅಂತಿದೆ ಇದು 88 ಅಲ್ಲಿ.
ಅಲ್ಲ, ನಮ್ಮ ಡಿವಿಷನ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಇದೆ ಸ್ವಾಮಿ. ಡಿವಿಷನ್ ಬೆಂಚ್ RF ಆರ್ಡರ್ ಇದೆ.
Annexure ಏನಂತ ಹೇಳಿದಾರೆ ನೋಡಿ ನಿಮ್ಮಲ್ಲೇ.
ನಾನು ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ ಏನು ಅನಕ್ಷರ ಕಾಣ್ತಾ ಇಲ್ಲ.
Okay. RFA 1061 of
1061 of 2020, your lordship will find the order dated 21 September 2020.
RFA 1061
Annexure L
of
anta.
2020.
Your lordship will find the second page of the order. Not the judgment of the trial court is on 10th August 2020. This order of the division bench is dated 21/9/2020. Lord, no, so on, so in the, I'm not after in the lastly, appeal is admitted for hearing. Notice on your respondents 1 to 5 is accepted. Issue notice to remaining respondents. Now kindly come to the next page, Manor. With consent of the learned counsel for parties heard on IA 1 and 2. Next page. After hearing the learned counsel for the parties, it is directed that the parties shall maintain status quo with regard to possession of the subject matter of this appeal as it exists today till the next date of hearing. It is further directed that the parties shall not alter the nature of the property in any manner.
Yes.
There is not an interim order. To the constructive possession of the accused. Trial court says they have only constructive possession, which has now been stayed by the division bench of this honorable court. Now, this is only to bring to your lordship kind notice that not only the offence of 504, 506, but also 427 and 447 also are made out. Though charge sheet is not filed for that purpose. In fact, my learned friend also read to your lordship the note in the charge sheet, bottom of the charge sheet. May I bring to your lordship kind notice the said note again. Nivedane. In fact, this note itself, what is contrary to law. May I read? ಸಾಕ್ಷಿ ನಂಬರ್ 8 ಮತ್ತು A1 ರಿಂದ A4 ರವರೆಗೆ ಆರೋಪಿಗಳು ಸ್ವತ್ತಿನ ಸಂಬಂಧದಿಂದ ಹಕ್ಕು ಬಾಧ್ಯತೆಗಳು ಸಾಧಿಸುತ್ತಿದ್ದು ಸ್ವತ್ತಿನ ವಿಚಾರದಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಪ್ರಕರಣ ಬಾಕಿ ಇರುವುದರಿಂದ ಪ್ರಕರಣದಲ್ಲಿ ಕಲಂ 447 ಮತ್ತು 427 ಐಪಿಸಾರದ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಲಭ್ಯವಾದ ಕಾರಣ ಹಾಗೂ ಆರೋಪಿಗಳು ಕಲಂ 1, 315, 310, 11 SC/ST ಆಕ್ಟ್ ಅಪರಾಧ ಎಸಗಿರುವ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಲಭ್ಯವಾದ ಕಾರಣ ಸದರಿ ಕಲಂಗಳನ್ನು ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯಲ್ಲಿ ಕೈ ಬಿಟ್ಟಿರುತ್ತದೆ. But this 447 and 427, all that the police say is that civil suit is pending between parties. But in the civil suit, the plaintiff themselves contend that they are not in possession. They went to demand possession. All that is required not to prove not a case of 427 or not 447. Not may I just bring to your lordship pay notice the definition of criminal trespass 441. This is just to indicate even the police have not performed their duty properly. 441.
Yes.
Criminal trespass. Whoever enters into or upon the property in possession of another with intent to so and so, so and so. All that it requires is I am in possession of the property. Whether legally, illegally, we would have cited KMF case thousands of times in an injunction suit. The nature of possession is not in question. It's only possession.
Yes.
Therefore, in my humble submission, this the admission by the plaintiff in the civil suit, the decree which says he is only in constructive possession, read with this 441 clearly indicates not only the offence of 504, 506, but also trespass is also made out. This is my first submission. Secondly, may I bring to your lordship kind notice the decree, the schedule in the suit that my learned friend produced. What is his claim and what is in dispute? But pink page number 69 of the judgment, my lord. 69, scheduled property, your lordship will find. Last but ಈ judgment, OS judgment ಕೊಟ್ಟು ಸ್ವಾಮಿ. ಈಗ ತಾನೇ ಕೊಟ್ಟರು ಅವರು. ತಾವು ಇವಾಗ ತಾನೇ ನೋಡಿದ ನೀನು ಮಾರ್ಕ್ ಮಾಡಿದ್ವಿ. I read to your lordship, not this possession part, page 58 ತಮ್ಮ ಓದ್ದೆ. I brought to your lordship can notice page 58 and 59. 69 ನೋಡಿ ಸ್ವಾಮಿ. I read to your lordship page 58 and 59 about possession.
ಅದೇನಾಗುತ್ತೆ ನಾವು ಆ ಕಡೆ ಇಟ್ಟ ಮೇಲೆ ಮತ್ತೆ ಇನ್ನೊಂದ್ಸಲ ತೆಗಿಬೇಕು.
ಹೇಳಿ. ಅಲ್ಲ ಅವ್ರು ಒಂದೇ ಪಾಯಿಂಟ್ ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾ. I'm sorry for causing trouble to the court. 69, not schedule, your lordship will find. Schedule.
Okay.
All that piece of our parcel property bearing survey number so and so. Measuring, your lordship may kindly mark the measurement. 2 acre 20 guntas. Ivrdu claim irodu. It is only 2 acre 20 guntas. Though may not, this issue is not cannot be gone into, not in this 482, since my learned friend has said, but I am answering his not queries. Now I'm not kindly have a look at the sale deed. My sale deed, which my learned friend not brought to your lordship's kind notice, but at page 93 and the comment. 93.
Petition ಅದು.
Our criminal petition alli.
93.
There is a sale deed dated 14th February 2008.
Yes.
This is in favor of the complainant, the owner of the complainant, Tulsiram, that your lordship tavu nodidri. Lahari so and so by Tulsiram anta. Adaralli your lordship may kindly come to the schedule. What I have purchased or my owner has purchased is 6 acres 24 guntas. So you don't have claim over all the 6 acres. You are in constructive possession, which is stayed by this honorable court. My physical possession is protected. This is not with reference to not claim over the property, which again cannot be gone into now. Then about the caste certificate. This is not about the possession. Not since this is a 482 petition, I am only bringing to your lordship kind note admitted documents.
Yes.
Question of fact cannot be gone into. Not the annexure and ಮಾಡಿದ್ದಾರೆ. Annexure H1 ಅಂತ your lordship may kindly say annexure H1. Not this annexure H1.
H1.
Literally, your lordship cannot noted there are 2 letters which are dated same by the same Tahsildar grade 2. Now the first letter your lordship has rightly noted annexure H1. Note there are 2 things to be noted in this annexure H1. First is the first paragraph shows that this Venkatachalam is resident of number 69/1, survey number 69/1, the property in dispute or property in question. That shows what is in possession of this 69/1. Then not para 2. ಈ ಬಗ್ಗೆ ಉಲ್ಲಕ 2 ಮತ್ತು 3ರಂತೆ ಸಂಬಂಧಪಟ್ಟ ಉಪ ತಹಸೀಲ್ದಾರ್ ಮತ್ತು ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರ ವರದಿ ಪಡೆಯಲಾಗಿದ್ದು, ಸದರಿಯವರು ವರದಿಯಂತೆ ಸದರಿಯವರು ನೀಡಿರುವ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ನಕಲು ತಮಿಳು ಭಾಷೆಯಲ್ಲಿದ್ದು ಕನ್ನಡಕ್ಕೆ ಭಾಷಾಂತರ ಮಾಡಲಾಗಿದ್ದು, ಅದರಂತೆ ಫಿರ್ಯಾದಿಯು ಆದಿ ದ್ರಾವಿಡ ಜಾತಿಗೆ ಸೇರಿರುವುದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. This again becomes a question. If he wants to dispute it, it is a trial court which they will have to go.
Yes.
Then, my lord, my learned friend not also brought to your lordship kind notice the election card. ನನ್ನ ಹತ್ರ ಇರೋದು page 54 ಇದೆ.
ನಾವು ಪತ್ತೆದಾರಿ ಕೆಲಸ
ಏನ್ ಮಾಡೋದು ಸ್ವಾಮಿ? ಅಲ್ಲ ಫೈಲ್ ಮಾಡುವಾಗ ಅದಾದ್ಮೇಲೆ ಏನಾಗುತ್ತೆ, ಒಂದ್ಸಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡುವಾಗ ಏನೋ ಮಾಡಿರ್ತಾರೆ, ಅದಂಗೆ ಬಿಟ್ಬಿಡ್ತಾರೆ ಅಷ್ಟೇ.
Yes, 54.
54 ಅಲ್ಲಿ not my learned friend brought to your lordship kind notice the election identity card issued in 2001-2005. Not this election identity card is never or not proof of possession of the property. Not even my election identity card is in Rajarajeshwari Nagar constituency. I have shifted myself not to Rajarajeshwari Nagar constituency. My address, my passport, Aadhaar card, remains everything, my lord, in Rajarajeshwari Nagar.
Yes.
This cannot prove my possession because Tahsildar's report, my lord, also the the spot inspection report of the revenue inspector would clearly establish. Even the spot Panchanama also not just behind this election card. Spot Panchanama would also establish not that the complainant is in possession. This is not with reference to the possession, then not judgments of the court, then not caste certificate. I'm not lastly coming to not averments in the complaint, not in page number 29.
Yes. Yes.
Not typed copy my learned friend has produced.
Yes.
ನಾನು ಸರ್ವೆ ನಂಬರ್ 69/1 ಹೊಸ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸೋರಲ್ಲಿ ಕಳೆದ 30 ವರ್ಷಗಳಿಂದ ನನ್ನ ಹೆಂಡತಿ ರಾಜಮ್ಮನ ಜೊತೆ ವಾಸ ಮಾಡುತ್ತಿರುತ್ತೇನೆ. ತುಳಸಿರಾಮ್ ಅವರು ಅವರ ಕುಟುಂಬದವರು ಈ ಮೇಲ್ಕಂಡ ಜಮೀನಿನ ಮಾಲೀಕರಾಗಿದ್ದು ನನ್ನನ್ನು ಜಮೀನನ್ನು ನೋಡಿಕೊಳ್ಳಲು ಕೆಲಸಕ್ಕೆ ಇಟ್ಟುಕೊಂಡಿದ್ದಾರೆ. Luckily my learned friend did not ask the employment certificate and the salary certificate. ದಿನಾಂಕ 13/9/20 ಬೆಳಗ್ಗೆ ಸುಮಾರು 7 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ರಮೇಶ್ A1, ಸಮೀವುಲ್ಲಾ A2, A3, not this A2, A3, ಸಮೀವುಲ್ಲಾ movie they have not approved this on bill court. ರಮೇಶ್ A1, ಕೇಶವ ರೆಡ್ಡಿ A4 ಮತ್ತು ಇತರರು ಸೇರಿಕೊಂಡು ಮೇಲ್ಕಂಡ ಜಮೀನಿಗೆ ಅಕ್ರಮವಾಗಿ ಪ್ರವೇಶಿಸಿ ಗಲಾಟೆ ಮಾಡಿದರು. ಆಗ ನಾನು ಅದನ್ನು ತಪ್ಪಿಸಲು ಹೋದಾಗ ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಯನ್ನು ರಸ್ತೆಗೆ ಎಳೆದುಕೊಂಡು ಬಂದು ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ನೀವು ಸೋನ್ಸೋ ಜಾತಿಗೆ ಸೇರಿದವರು ನಮ್ಮನ್ನು ತಡೆಯುತ್ತೀರಾ, ಸೋನ್ಸೋ ಮಕ್ಕಳ ಮತ್ತು ನಿಮ್ಮ ಹೆಂಡತಿಯನ್ನು ಸೋನ್ಸೋ ನನ್ನ ಮಕ್ಕಳ ಎಂದು ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಬಾಯಿಗೆ ಬಂದಂತೆ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಯನ್ನು ಬೀದಿಗೆ ತಳ್ಳಿದರು. ನಂತರ ನಮ್ಮನ್ನು ಹೊಡೆಯಲು ಪ್ರಯತ್ನಿಸಿ ನಿಮ್ಮನ್ನು ಸಾಯಿಸಿ ಬಿಡುತ್ತೇವೆ ಎಂದು ಹೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ನಮಗೆ ನಿಮ್ಮ ಮಾಲೀಕರಾದ ತುಳಸಿರಾಮರವರು ಮತ್ತು ಅವರ ಕುಟುಂಬದವರು ವಾಸವಾಗಿರಲು ಮನೆಯನ್ನು ಕಟ್ಟಿಕೊಟ್ಟಿದ್ದು ಅದರ ಒಂದು ಭಾಗವನ್ನು ಒಡೆದು ಹಾಕಿ ಅಲ್ಲದೆ ಮನೆಯ ಸಾಮಾನುಗಳು ಮತ್ತು ನನ್ನ ಹಣ ಮತ್ತು ಆಭರಣಗಳನ್ನು ಹೊರಗಡೆ ಬಿಸಾಡಿದ ಆದ್ದರಿಂದ ಸದರಿ ಮೇಲ್ಕಂಡವರ ಮೇಲೆ ಸೋನ್ಸೋ ವಿರುದ್ಧ ಕ್ರಮ ಜರುಗಿಸಲಾಗಿದೆ. Not spot inspection report. Not my learned friend also has produced the photograph. Clearly indicates, after the Mazar, annexure C1, Mazar. This photographs after typed copy of annexure C1 indicates another one the visible copy. This one I have a visible copy of this photograph. Now this photograph is at page number 9 of this visible copy. Police alla idare. ನಮ್ಮ ಸಾಮಾನೆಲ್ಲ ಹೊರಗಡೆ ಬಿಸಾಕಿದ್ದಾರೆ. ನಾಟ್ ಪೊಲೀಸ್ ಆರ್ ಡ್ರಾಯಿಂಗ್ ಮಜರ್. ಪೇಜ್ ನಂಬರ್ 9 ಅದಕ್ಕೆ ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಪ್ರೆಸೆನ್ಸ್ ಆಫ್ ಪೊಲೀಸ್. ದಿಸ್ ಇಸ್ ದಿ ವಿಸಿಬಲ್ ಕಾಪಿ ಆಫ್ ಮೆಲಾಡ್ ಇದು. ದೆನ್ ನಾಟ್ ಫರ್ದರ್ ಮುಂದೆ ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಡಿಗ್ ಮಾಡಿದ್ದೆಲ್ಲ ಹಾಕಿದೀವಿ. ಜೆಸಿಬಿ ತಂದು ಜೆಸಿಬಿ ಡಿಗ್ ಮಾಡಿದ್ದೆಲ್ಲ ಹಾಕಿದೀವಿ. These are all taken during spot measure, and the photograph which your learned friend has produced annexure C2, C3 would also indicate the household items having been thrown. Then in the page number not page number 2, but I have also produced the not samadhi, not page number 2 and 3 of the parents of my owner, your lordship of Tulsiram. Ondo, which is page number 3 and 4, which also establish possession of my owners of the property. Of course, these are all cannot be addressed here. Anyway, my learned friend since addressing then lastly about this 504 and 506.
Yes.
And criminal intimidation. 503. 506 will not would punish the offense of criminal intimidation. 503 is not the definition part.
Yes.
Not 503, whoever threatens another, ಇಲ್ಲಿ threaten to ಇದೆ, with injury to his person or reputation. ನಿಮ್ಮನ್ನ ಸಾಯಿಸ್ಬಿಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. With injury to his person ಕೂಡ ಇದೆ. Or to any person or reputation of anyone in whose that person is interested, with intent to cause alarm to that person, or to cause that person to do any act which is not legally bound, so and so. All that section 503 requires is, I insult some person, that causes alarm ಅಂದ್ರೆ ಭಯ ಆಗ್ಬೇಕಷ್ಟೇ. ಭಯ ಆಗ್ಬೇಕಷ್ಟೇ. ನೀನು ಹೊಡಿತೀನಿ ಬಡಿತೀನಿ ಅಂತ ಹೇಳಿ ನೀನು ಸಾಯಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು ಇಲ್ಲ, ಅದು ಭಯ ಆಗ್ಬೇಕು. How that intention can be gathered, but in a 482 petition, which will have to be tested only not during the trial. The averments, all that the words used by the accused are very much present in the first information. ನಾನು ಸಾಯಿಸ್ತೀನಿ ಅಂತ ಬೆದರಿಕೆ ಹಾಕಿದಾರು ಅಂತ ಹೇಳ್ತಾರೆ, which is not more than sufficient to attract definition of criminal intimidation under section 503. Then 504.
Yes.
Whoever intentionally insults, insult gantu ide, and thereby gives provocation to any person intending or, kindly mark not this word, knowing it. He may not have intention, it's a or, knowing it to be likely that such provocation will cause him to break the public peace or to commit any other offense shall be punished with imprisonment by the description. Not only his intention, his knowledge may not. ಒದಿತೀನಿ ನೋಡಿ ನಿನ್ಗೆ ಫೈಲ್ ಕಿತ್ಕೊಂಡ್ರೆ, but some people may keep quiet, some people may not, may react. ಕೆಲವು ಸಮಯ ಜೋರಾಗಿ ವಾಯ್ಸ್ ರೈಸ್ ಮಾಡದ ಅಕ್ಕಪಕ್ಕ ನಾವುಗಳೇ ಜಗಳ ಆಡ್ತಾ ಇರ್ತೇವೆ, ನೀನೇನ್ ಮಾಡ್ತೇನೆ ನಾನೇನ್ ಮಾಡ್ತೇನೆ. So it is always subjective, which will have to be again tested during trial.
Yes.
Then my lord, about section 3 to VA. As my learned friend rightly said, the section 3 subsection 2 of SC/ST Act do not create any new offense, unlike section 3(1). 3(1), your lordship will find section 3(1) R and S. I wanted to bring to your lordship by notice why the police have not charge sheeted us for this 3(1). They have charge sheeted the accused for this 3(1) R and S, which will have to be tested. 3(1) R intentionally insults or intimidates with intent to humiliate a member of scheduled caste or scheduled tribe any place within public view. Abuses any member of scheduled caste or scheduled tribe by caste name in any place within public view. Within public view may not there are any number of judgments. Even something happens within four corners, inside the compound also, is within public view.
Public view ಅನ್ನೋದನ್ನ ಪೊಲೀಸರು ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಅಂತ
that's what apex court has said.
ಇಂದ ಎಳ್ಕೊಂಡು ಬಂದು ಮೇನ್ ರೋಡಿಗೆ ತಗೊಂಡ್ ಬಂದು ಅಲ್ಲಿ ಪಬ್ಲಿಕ್ ರಸ್ತೆ ಬಂತ ಅಲ್ಲಿ ತಳ್ಳಿದ್ರು ಅಂತ ಅದಕ್ಕೆ ಅದನ್ನೇ ಬಂದಿರೋದು.
ಆಯ್ತು, ನಿಮ್ದಾಗಿದೆ ಇರಿ. ಎನಿವೆ this 3(1)
ಅಲ್ಲಲ್ಲ, ನಮ್ಮ ಪೊಲೀಸರು ಏನ್ ಮಾಡ್ತಾರಂದ್ರೆ ಅದು ಮನೆ ಮುಂದೆ ಆಗ್ತಾ ಇರುತ್ತೆ,
ಹೌದು,
ನಮ್ಮನ್ನ ಎಳ್ಕೊಂಡು ಬಂದು ಮೇನ್ ರೋಡಿಗೆ
ಅವಶ್ಯಕತೆ ಇಲ್ಲ,
ಅಲ್ಲಿ ಮಾಡಿದ್ರು ಅಂತ.
ಅದು ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ ಆಕ್ಚುಲಿ.
ನಿಮ್ಮ ಅಕೇಶನ್ ಬಂದಾಗ ಹೇಳ್ಬೇಕು ಪೊಲೀಸರು.
In fact, I have gone to, I have been going to the Karnataka State Police Academy in Mysore. I have been training DSPs, SPs on SC/ST Act as well as Prevention of Corruption Act.
ಈಗ ನೀವು ದೊಡ್ಡವರಿಗೆ ಟ್ರೈನಿಂಗ್ ಮಾಡಿದ್ರಿ, ಈ ಬರೀತಾರಲ್ಲ ಕುತ್ಕೊಂಡು ಅವ್ರಿಗೆ
ಅದೇನಾಗುತ್ತೆ, unfortunately under this act, under both the acts, It is ACPs and DYSPs who have to conduct investigation. ಅವರೇ ಮಾತ್ರ ಕಳ್ತಾರೆ, ಅಫಿಷಿಯಲಿ ಅವರೇ ಮಾತ್ರ ಬರ್ತಾರೆ. Actually, as your lordship knows, on ground, it is not the writers who do it.
ಯಾವಾಗ ನೋಡಿದ್ದೀನಿ ನಾನು, ನಮ್ಮನ್ನ ಎಳ್ಕೊಂಡು ಮೇನ್ ರೋಡಿಗೆ
ಅಲ್ಲಿ ಕರ್ಕೊಂಡ್ಬಂದು ಎಲ್ಲರೂ ಕಾಣುವಂಗೆ ನಮಗೆ ಬೈದ್ರು, ಎಲ್ಲರೂ ಕಾಣುವ ರೀತಿ ಬೈದ್ರು. That is actually not required. That's what apex court has said when I brought the judgments. This 325, here is 31R and S. I may file a protest petition there saying that this material are sufficient to take cognizance for 31R and S, which I will take. Then can I look at 325? All the 325 VSACs, 5A, commits any offense. 32.
Yes.
Whoever not being a member of scheduled caste or scheduled tribe, it is admitted that the accused do not belong to member of scheduled caste or scheduled tribe. Can I look at 325A? Commits any offense specified in schedule. Not section 506, not IPC, is an offense under schedule for the purpose of section 325A. The last provision of this schedule, last but one, 506.
ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ?
ಇದು ನನ್ನ ಬುಕ್ ಅಲ್ಲಿ ಪೇಜ್ 81 ಇದೆ, KLJ publication ಅಲ್ಲಿ. Immediately after
ಎಷ್ಟದು? ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಬರ್ತದೆ?
Serial number at serial last but one of this schedule.
Additional relief ಅಲ್ಲ ಒಂದು
ಅಲ್ಲ, ಅದು your lordships are seeing the ಇದು ಏನದು atrocities rules, that is not serial number 41. ಇದೆ ಆ serial number 41 ಯಾಕೆ ಅಂದ್ರೆ ಅದು ಇದು
for the purpose of
paying compensation. Exactly, ಅದರಲ್ಲೂ ಕೂಡ ಇದೆ serial number 40. ಇದರಲ್ಲಿ just after this rules ಅಲ್ಲ ಆಕ್ಟ್ ಆದ್ಮೇಲೆ ಬರುತ್ತೆ. Immediately after section 60 ಇದೆ, ಅದು ಬರುತ್ತೆ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ. Right to victims 15A, 15 capital A ಆದ್ಮೇಲೆ 20 up to 23 is the power to make rules. Section 23. I just ಅದರಲ್ಲಿ ತೋರಿಸ್ತೀನಿ ಕೊಡಿ, ಆ ಬುಕ್ ಅಲ್ಲಿ ತೋರಿಸ್ತೀನಿ.
ಓಕೆ ಶೆಡ್ಯೂಲ್ ಸೆಕ್ಷನ್ ಅದಕ್ಕೆ ಸೆಕ್ಷನ್ 3
ಇಲ್ಲಿದೆ
ಗೆ ಶೆಡ್ಯೂಲ್ ಅಂತ ಸೆಪರೇಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರು.
ಇಲ್ಲಿದೆ ಫ್ಲಾಗ್ ಹಾಕೊಡ್ತೀನಿ ಮೇಡಮ್.
ಸ್ಟಾರ್ಟಿಂಗ್ ಲೈನ್ ಶುರು ಆಗುತ್ತೆ.
ಸೆಕ್ಷನ್ 23 ಆದ್ಮೇಲೆ ಶುರು ಆಗುತ್ತೆ.
ಅಲ್ಲಿ your lordship will find the schedule, see section 3 to 5A.
Yes.
3 to 5A may not remarry, bring to your lordship kind notice 3 to 5A. Whoever not being a member of scheduled caste or scheduled tribe commits any offense specified in the schedule against a person or property, knowing that such person is a member of a scheduled caste or scheduled tribe, or such property belongs to such person, shall be punishable with such punishment as specified under the Indian Penal Code for such offense. And idile addition enu andre, and also shall be liable to fine. The IPC only prescribes not punishment, imprisonment. This 3 to 5A would also prescribe an additional thing, that is fine. Then not about the knowledge of the accused about the caste of the watchman. Admittedly, civil suit is pending since 2002. Even according to the averments made by the plaintiff and his family members in the suit, they came and demanded possession in 2002 itself. That means they are not in possession. They know that I am there. I am looking after the property. There is not the samadhi of the parents of my owner. And even otherwise, knowledge is again not a question of fact, which will have to be established during the course of trial. Not all the questions which my learned friend may not raised are all questions of fact. Admittedly, there is first information, there is statement of 4 eyewitnesses who have all supported the version not given by the first informant. His own version in the civil suit says he is not in possession. Decree says he is only in constructive possession. In fact, my lord, trespass is also attracted, my lord, for which I'll take the recourse available in law.
Yes.
So this, my lord, I will not trouble your lordship, not with this judgment. Not Kaptan Singh, my lord, may I just not pass on. Not serial number 1 and 2. Not just to indicate that not the 482 petition cannot be entertained to decide a question of fact. Number 1 and 2. Number 4 and 5, even illegal possession is protected. That is a basic principle, not in a settled possession under civil law. 4 and 5. Number 6, not about the public view. Not though charge sheet is not filed for 3-1 R and S, this is only to bring to your lordship kind notice. Even those offences are also made. These are all the basic judgment which every day in and day out not we trouble your lordships with.
Yes. Yes, reply.
With respect to the possession of this CWA to this 2 acres of land, when this suit was filed in the end, it was doing this case. When the suit was filed, my lordship,
Michael,
when the suit was filed, my lordship, we had not acquired any rights of this shaded exhibit agreement on this. The shaded was executed in the year 2008 in this case. During the pendency of the suit, my lordship, this sense of we executed the shaded in this case. My lordship, thereafter, my lordship, in the year 2012, he was included in this suit in this case. No, the question of what the parent number, what learner friend is relying on, parent number 42 of the judgment that I am not it, I went to demand the possession of the student property. ನಾನು ಹೋಗಿದ್ದು ಇವ್ರ ಹತ್ರ ಹೋಗಿದ್ದಲ್ಲ CWA ಅಂತಲ್ಲ ಯಾರ ಹತ್ರ ಹೋಗಿದ್ದು ಏನಕ್ಕೆ ಹೋಗಿದ್ದು ಅಂತ ಬಿಕಾಸ್ ಮೈ ಲಕ್ಷ ಅಡ್ಮಿಟೆಡ್ ಇಟ್ಸ್ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ಇನ್ ದಿಸ್ ಕೇಸ್ ಇದ್ರೊಳಗೆ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ಸ್ಟೇಟ್ ಅದರೊಳಗೆ ಔಟ್ಸೈಡ್ 62 2008 ಸೈಡ್ ಇದ್ರೊಳಗೆ ಇನ್ ದಿ ಶೆಡ್ಯೂಲ್ ದೇ ಸೇಸ್ ದಟ್ ಮೈ ಲಕ್ಷ ದೇರ್ ಇಸ್ 6 acres 34 gunters of land ಅಂತ ಹೇಳಿ ಮೈ ಲಕ್ಷ ಆ ಎಕ್ಸ್ಟೆಂಡ್ ದೇರ್ ಇಸ್ ಅ ಲಾರ್ಜ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ land in the survey number in this case 6 acres 34 gunters ಏನಿದೆಯಲ್ಲ ಅದನ್ನ ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿಸ್ 2 acres 20 gunters of land. In the remaining portion of the possession letter, I am not disputing that in this case. Naniga our land bad adrolage. What my saying is that my lordship, I am the owner of 2 acres 20 gunters of land. My possession has been protected. My possession and title has been protected by the judgment of the trial court or protected. It clearly says that my lordship, the court has restrained different number in the CWA from interfering into my peaceful possession of the land. Non-possession independent, it means what my lordship, I am in the possession of the property and he is in the possession of the property, so you don't go and disturb his possession. When I am in the possession, my lordship, the question of possession of the CW does not arise in this case. Moreover, in this case, Your Honor, when you see the way in which this complaint has been drafted in this case, of a layman, ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಇದ್ರೊಳಗೆ ಬೀದ ಅದನ್ನು ತಪ್ಪಿಸಲು ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿಯನ್ನು ರಸ್ತೆಗೆ ಎಳೆದುಕೊಂಡು ಒಂದು ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಅಂದ್ರೆ ಜಾಸ್ತಿ ಅಂದ್ರೆ ಬೈ ಹೆಂಗ್ ಬರೀತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ the ingredients of the complaint should attract the provisions of section idನ್ನ attract ಆಗುತ್ತೆ. When you see the omnibus allegation in this case, moreover in this case there are totally 4 accused persons are there in this case. ಏನ್ ಹೇಳ್ತಾರೆ ಅದರೊಳಗೆ ಎಲ್ಲರೂ ಸೇರಿ ಜಾಸ್ತಿ ಯಾರು ಬೈದಿದ್ರೊಳಗೆ ಔಟ್ ಆಫ್ ದಿಸ್ 4 accused persons ಯಾಕೆಂದ್ರೆ ಸ್ಕೂಲಲ್ಲಿ ಪ್ರೇಯರ್ ಹೇಳ್ತಾರಲ್ಲ ಎಲ್ಲ ಒಂದಿದ್ದಾರೆ ಆಡ ಹೇಳ್ತಾರಲ್ಲ ಎಲ್ಲರೂ ಈ ಏನಿಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ರೆ 4 ಜನನು ಒಟ್ಟೊಟ್ಟಿಗೆ ಬೈತಾ ಹೋಗ್ತಾ ಇವರಿಗೆ 4 ಜನನು ಒಟ್ಟೊಟ್ಟಿಗೆ ಜೀವ ಬೆದರಿಕೆ ಹಾಕಿದ್ರ ಏನು ಮಾಡೋದು
ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದೆ ಅಲ್ಲ ದಿಸ್ ಆರ್ ಆಲ್ ಕ್ವೆಶ್ಚನ್ಸ್ ಫಾರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ 482 ಅಲ್ಲ
ಯಾಕೆಂದ್ರೆ ಇದೆಲ್ಲ ಈಗ ಅದರೊಳಗೆ ನಾನೇ ಪ್ರೂವ್ ಮಾಡೋ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕ್ವೆಶ್ಚನ್ ರೈಸ್ ಆಗೋದಿಲ್ಲ ಬಿಕಾಸ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಇನ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಆಲ್ ದಿಸ್ ಅಲಿಗೇಷನ್ ಹ್ಯಾಸ್ ಬೀನ್ ಡ್ರಾಪ್ಡ್ ಔಟ್ ಹಂಗಾಗಿ ನನಗೆ ಪ್ರೂವ್ ಮಾಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅದರೊಳಗೆ ಹ್ಯಾವ್ ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ಈಗ ಅವರು ಅದನ್ನ ಎಸ್ಟಾಬ್ಲಿಷ್ ಯಾ ಕಂಪ್ಲೇಂಟ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಮಾಡಿದಾನೆ ಇದ್ಯಾವುದು ಈ ತರ ಬೈದಿದ್ದು ಯಾಕೆ ಸಿ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಐ ವಿಟ್ನೆಸ್ ಇನ್ ದಿಸ್ ಕೇಸ್ ಜಾತಿ ಬಗ್ಗೆ ಬೈದಿದ ಬಗ್ಗೆ ಎಲ್ಲೂ ಹೇಳೋದೇ ಇಲ್ಲ ಅದರೊಳಗೆ ಹಂಗಾಗಿ 3(2)V ಏನ ಯಾಕೆ ಇನ್ವಾಲ್ವ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿದ್ರೆ ಅಂದ್ರೆ ಅಕ್ಯೂಸ್ಡ್ ಪರ್ಸನ್ಸ್ ಗೆ ನಾಲೆಡ್ಜ್ ಇತ್ತು ಅವರು ಶೆಡ್ಯೂಲ್ ಕಾಸ್ಟ್ ಗೆ ಬಿಲಾಂಗ್ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಎಲ್ಲ ಆಯ್ತು ವಕೀಲ್ರೆ 482 ನಲ್ಲಿ ಇದನ್ನೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ ಅಂತ ಪ್ರಶ್ನೆ
ವಿ ಕಾಂಟ್ ರಿಪೀಟ್ ಅಲ್ಲ ಅವರು ಅರ್ಧ ಗಂಟೆ ಮಾಡಿದ್ರೆ 5 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸಿದೀನಿ ಆಲ್ ಕ್ವೆಶ್ಚನ್ಸ್ ಆರ್ ಫ್ಯಾಕ್ಟ್
ಎಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ ಒಳಗೆ ಎಲ್ಲ ಫ್ಯಾಕ್ಟ್ಸ್ ಅಂತ ಕೆಲವೊಂದು ಫ್ಯಾಕ್ಟ್ಸ್ ಅಡ್ಮಿಟೆಡ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಇಟ್ ನೀಡ್ ನಾಟ್
ಅದಕ್ಕೆ ನಾನು ಶುರು ಮಾಡಿದಾಗಲೇ ಕೇಳೋಳಿದ್ದೆ ನಾನು ನೀವು ಅಕ್ವಿಟಲ್ ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ರು
ಅಷ್ಟೇ
ನಾನು ಸುಮ್ಮನೆ ಐ ಡಿಡ್ ನಾಟ್ ವಾಂಟ್ ಟು ಇಂಟರ್ಫಿಯರ್
because my lordship the acquittal is also it's a post trial in this case after saying that my lordship whether the immediate transcribing
ನೋಡೋಣ
discharge time ಅಲ್ಲಿ whether the prosecution has made out a prima facie accused person by attracting all the ingredients of original
ನಾನು I'll go through the file
ಸೈನ್ ಮಾಡ್ಕೊಡಿ.
Arguments of both sides. Sign ಮಾಡಿ. ಒಂದು ನಡುವೆ ಒಂದು ಡೇಟ್ ಕೊಡಪ್ಪ to hear further. List on so and so for further hearing ಅಂತ ಹಾಕಿ ಆಮೇಲೆ ಒಂದು ಆರ್ಡರ್ ಸರ್.
Please.
Yes. 11.
Please.
ಅಲ್ಲಿಂದ ಮತ್ತೆ.
Please.
Yes. ಬೇರೆ ಬೇರೆ ಡೇಟ್ಸ್ ಕೊಡಿ. ಇದು ಇವಾಗ ಸಾಕಾಗಿದೆ. ಇದಾಗಿದ್ದು ಯಾವುದು 38? ಓಕೆ.
40 ರಾಜಾರಾಮ್ ಸುರಿಂಬಳಿ 40
ಹಿಂದೆ ಆರ್ಡರ್ ಶೀಟ್. The matter could not be reached, hence on so and so date ಕೊಡಿ.
22nd 22/7.
22/7. As a last chance interim order extended to the next date.
41 ವರದರಾಜ್ ರಂಗನಾಥ್ ರಾವ್
Respondent from this case.
ಹೇಳಪ್ಪ ಡೇಟ್ ಹೇಳಪ್ಪ. ಇದ್ರಲ್ಲಿ ಆಗಲ್ಲ ವಕೀಲರು. ಈಗ 4:15 ಆಯ್ತು. ಇವಾಗ ಯಾವಾಗ ಕೇಳೋಣ? ಕರೆಕ್ಟ್. ಒಂದು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕೇಳೋಣ. ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಹೇಳಿ. ಸಣ್ಣ ಡೇಟ್ ಕೊಡಿ.
7th 7ನೇ ತಾರೀಕು.
ಯಾವ ಅಕ್ಯೂಸ್ ಇವರು?
Same, all the petitioners.
No, there.
Only dispute between the first petitioner and the advocate.
ಹೇಳಪ್ಪ ಡೇಟ್ ಹೇಳಪ್ಪ.
7/7.
Matter could not be reached. List on 7/7. Interim order ಇದೆ ನೋಡಿ.
ಇಲ್ಲ ಇಲ್ಲ ಸ್ಟೇ
ಇಲ್ಲಲ್ಲ. ಓಕೆ ನೆಕ್ಸ್ಟ್.
42 ಗಣೇಶ್ ಕುಮಾರ್.
Petitioner.
ಅದು ಇದನ್ನೇ ಹಾಕೊಳ್ಳಿ. ಇದು ಇವ್ರದ್ದೇನಾ?
ಈ ಕೇಸಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 5 4 6 7 8 9 ಎಲ್ಲ ಪಾಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. The petitioners before this court are accused number 2 3 and 4. Principal offenders all have been.
His contention is amount defrauded is repaid. Law may not has changed now from the day on which proceedings were quashed for not the borrowers, not till for the public servant, which I'll place on record. Maybe next week you'll watch me kindly.
Matter could not be reached. List
11/7.
Please.
Interim order may kindly be extended.
ಇದ್ರೆ interim order extend.
43 ವೆಂಕಟೇಶ್ ಸೋಮರೆಡ್ಡಿ.
About 4988 proceedings, matters been settled between the parties. So any date will be fixed, so the parties will be kept present.
Learned counsel for petition submits that this matter arises out of section 498 IPC and the parties have settled and it would be reported. List on
11/7.
Yes.
Interim order.
Interim order extended to the next date.
44 Pallavar.
Could not be reached date.
17/7.
17/7. Interim order extended to the next date.
45 Balakrishna MR.
No representation. List after 4 weeks. Yes. Interim order extended.
ಇಲ್ಲ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಬೇಡ. Interim order ಬರಲ್ಲ.
46 ಮುನಿರಾಜ ಎಂ. ಡೇಟ್ ಕೊಡ್ತಾ ಇದೀವಿ. ಯಾವ ಡೇಟ್ ಬೇಕು? ಯಾವ ಡೇಟ್ ಬೇಕು? ನೆಕ್ಸ್ಟ್
Matter could not be reached. ಕೊಡಿ ಒಂದು ಡೇಟ್.
16/7. 16/7.
7. Interim order extended till the next date.
47 ರೇಷ್ಮಾ.
No representation. List
ನಿಮ್ದ?
List after 4 weeks. Interim order ಇದೆ ನೋಡು.
Interim order ಇದೆ.
Interim order extended till the next date.
48
I'm
ರಾಜಶ್ರೀ.
appearing for the respondent, my lords. ಇದರಲ್ಲಿ vacating of interim order application ಆಗಿದೆ 4ನೇ ತಾರೀಕು ಆದ್ರೆ ಸ್ವಾಮಿ, this Friday.
Matter could not be reached. Our presence note ಮಾಡ್ಕೊಳ್ಳಿ. List ಕೊಡಪ್ಪ.
4th ಜಾಸ್ತಿ ಇದೆ. 4th ಬೇಕು.
3rd.
ವಕೀಲ್ರೆ ಎಲ್ಲಾನು ಫುಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನಾವು ಕೊಡೋ ಡೇಟ್ ಅಲ್ಲಿ ಮಾಡಿ ಅಷ್ಟೇ.
7/7 my lords, ಅದು ಡಿಲೇ ಆಗೋಗಿದೆ ಲಾರ್ಡ್ ವೆಕೇಟಿಂಗ್ ಹಾಕಿನೇ ಇಟ್ಸ್ ಬೀನ್ ಸಮ್.
ನೀವು ಈ ಸಾಯಂಕಾಲವರೆಗೂ ವೇಟ್ ಮಾಡಿ ಹೋಗೋದಾದ್ರೆ 7/7ಗೂ ಹಾಕ್ತೀನಿ ತಗೊಳ್ಳಿ. ಆಗ್ಬೋದಾ?
10/7 10/7
10/7
All right my lords.
Yes.
My lords, I want to make a mention in this case, my lords. Adralli one of the accused has expired. Adradu in 10496 writ petition alli petitioner number 1 Suresh Subba Pujari
ಇದರಲ್ಲಿ
has passed away on 4th of June.
ನನಗೆ ಇವರ ಪೆಟಿಷನರ್ ನಂಬರ್ ಹೇಳಿ ಅವ್ರದ್ದು.
Petitioner number 1 in 10496 of 23.
One is no more. Stop. ಇನ್ನು ಅವ್ರದ್ದು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಿ?
They are not producing anything.
Okay, ನೀವು ಹೇಳ್ತಿರೋದು ಸಬ್ಮಿಟ್
4ನೇ ತಾರೀಕು.
Okay, ಒಂದು ಕೆಲಸ ಮಾಡಿ. Learned counsel for respond number 2 submits that petitioner number 1 who is accused number
1 my lords.
1 is no more ಅಂತ ಹೇಳಿ. Yes, ಅಷ್ಟೇ submission. Yes. 10/7. ಮಾಡಿದೀರಾ?
They have not.
ಒಂದ್ ಕೆಲಸ ಮಾಡಮ್ಮ, ನೀವು ಹಿಂದಿನ ದಿವಸದ ಆರ್ಡರ್ ಶೀಟ್ ತೆಗೆದು ನೋಡಿ, ಅದ್ರಲ್ಲಿ ಆಲ್ರೆಡಿ ಸಬ್ಮಿಷನ್ ಇದ್ರೆ ಮತ್ತೆ ನೋಟ್ ಮಾಡೋದು ಬೇಡ. ಅವ್ರಿಗೆ ಯಾಕೆ ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು? ಅವ್ರು ಎಲ್ಲಾರ್ಸ್ ಅಂತ ಅಂತೀರಿ?
ಎಲ್ಲಾರ್ಸ್ ಆಲ್ರೆಡಿ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ನಾ ಹೇಳೋದು
ಅಲ್ಲ ಇದು ಅಕ್ಯೂಸ್ಡ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಕರೆಕ್ಟ್. ಅದೇ
ಸ್ಟೆಪ್ಸ್ ತರ್ಲಿಕ್ಕೆ ಉಂಟಾ ಅಂತ
ಏನಿಲ್ಲ,
ನಾನು
ಅಬೇಟ್ ಆಗಿದೆ ಅವ್ರ ಅಗೇನ್ಸ್ಟ್.
ಅದನ್ನ ಅಲ್ಲಿ ಬರೆಯೋದಷ್ಟೇ ಅವರು ಹಿ ಇಸ್ ನೋ ಮೋರ್ ಅಂತ ಹೇಳಿ. ನೆಕ್ಸ್ಟ್
49
ಎಂಟ್ರಿ ಮಾಡೋರ್ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಮ್ಮ.
ಅರ್ಚನಾ ಮೂರ್ತಿ
my lords.
ಪಾಟೀಲ್
ಯಾವ್ದ್ರಲ್ಲಿ? ಓಕೆ ಆಯ್ತು
My lordship.
ಇರಮ್ಮ 49 ಇದ್ದೀರಾ ನೀವು? ಇಲ್ಲಲ್ಲ, ಸ್ವಲ್ಪ ಹೊತ್ತು ವೇಟ್ ಮಾಡಿ. ಇದು ಹೇಳಪ್ಪ ಡೇಟ್. ಮ್ಯಾಟರ್ ಕುಡ್ ನಾಟ್ ಬಿ ರೀಚ್ಡ್ ಲಿಸ್ಟ್ ಆನ್
21st 21/7
21/7. ಇದರಲ್ಲಿ ಅರ್ಚನಾ ಮೂರ್ತಿ ಅವರು ಇದಾರೋ ಭಾಸ್ಕರ್ ಎನ್ ಅವ್ರು ಇದಾರೆ? ಭಾಸ್ಕರ್ ಎನ್ ಅವ್ರ ಹೆಸರು ತೆಗಿಬೋದಾ ಅಥವಾ ಒಂದೇ ಆಫೀಸರ್? ಆಯ್ತು ಬಿಡಿ, ಬೇಡ, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಹೇಳ್ರಂತೆ. ನೆಕ್ಸ್ಟ್ ಕರೀಪ.
ಕುಮಾರ್ ಎಂ.ಎನ್.
My lord,
14% is there.
myself respondent, my lord.
ಫಾರ್ಮ್ ನಂಬರ್ ಸಿ ಇಶ್ಯೂ ಆಗಿದೆಯಾ?
Yes ma'am.
Learned counsel for petitioner and respond number 2 is party. Learned counsel for petition present ಮಾಡಿ. Respondent number 2 who is party in person present through EC ಅಂತ ಮಾಡಿ. Learned SCGP for Arun present.
Yes. Entry order to continue my lord.
Matter could not be reached list on
22nd 22/7
My lord, 24 my lord, 22nd ನಮ್ಮ ಮದರ್ದು ಹುಷಾರಿಲ್ಲ, ಒಂಚೂರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇತ್ತು my lord, please.
24/7
Obliged my lord.
Entry order extended till the
In all the matters madam.
Yes.
Obliged.
ಇದೆಯಲ್ಲ entry order?
Yes it is there subsisting madam.
ಇದೆ ಮೇಡಮ್. 51
I appear for petitioner.
ಅನಿರುದ್ಧ್.
Previous state my lords had directed to keep the parties present. Parties are present. NI Act matter. ಇದರಲ್ಲಿ
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಪ್ಪ,
ಪ್ಲೀಸ್ ಅದು ಅವತ್ತು ಒಂದ್ ದಿವಸ my lords ನಾನು ಬರಕ್ ಆಗ್ಲಿಲ್ಲ ಅವತ್ತಿನ ದಿವಸ. So therefore the interim order was not extended. It's only a
ನಿಮಿಷ, ನನಗೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು. ನೀವು ಹೇಳಿದ್ದೆಲ್ಲ ಗಾಸ್ಪೆಲ್ ಟ್ರೂತ್ ಅಂತ ಆಗೋದಾದ್ರೆ ನಾವು ನೋಡ್ಬೇಕಾಗಿಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್. ವಿ ನೀಡ್ ಟು ಲುಕ್ ಇನ್ ಟು ದಿ ಆರ್ಡರ್ ಶೀಟ್. ಏನ್ ಪಾರ್ಟಿಗಳಿಗೆ ಯಾಕೆ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪ್ರೆಸೆಂಟ್ ದಿ ಪಾರ್ಟೀಸ್ ಫಾರ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಹೇಳಿದ್ವಿ. ಓಕೆ. Learned counsel for petition submit that there is likelihood of settlement and request that direction may be given to the parties to present before the court. ಆಯ್ತು, ಇದಾರೆ. ಇವಾಗ ಮುಂದೆ ಏನಾಗಬೇಕು?
lords, the case is my lords of a check bounce. Petitioner is my lords the lady who is she is just a not an active partner my lords, so formality ಗೋಸ್ಕರ ಮಾಡಿದ್ದು. ಅವ್ರ ಮೇಲೆ ಕೂಡ proceedings initiate ಮಾಡಿದ್ದಾರೆ. The husband is the true signatory on the check. On the merits my lords, I have a good case. I'm just saying my lords, since the opposite side is not here, I don't want to press anything. Interim order may be extended, a date may be fixed, I'll argue.
ಇವ್ರು ಯಾರ್ಯಾರು ಇದಾರೆ ನೋಡಿ, ಪಾರ್ಟಿಗಳು ಯಾರು ಇದಾರೆ ನೋಡಿ.
Lords, the complainant is present before the court. Accused number 1 is present before the court.
Okay. Whether accused number 1 is a
he is not a party.
Okay.
I have not preferred.
Respondent number respondent present.
Idare swami.
The husband of petitioner present.
Please my lords.
ಅದಕ್ಕೆ ಇವರು ಈ ನಿಮ್ಮ ಹೆಂಡತಿರ ಹೆಸರಲ್ಲೆಲ್ಲ ಬಿಸ್ನೆಸ್ ನಡೆಸ್ತಾ ಇರ್ತಾರೆ, ಹೌದಾ?
ಹೌದು.
ಈ ಹೆಂಡತಿ ಕನ್ವಿಕ್ಷನ್ ಆದ್ರೆ ಗಂಡನೇ ಹೋಗ್ಲಿ ಒಳಗಡೆ, ಹಂಗೊಂದ್ ಕಾನೂನು ಮಾಡ್ಬಿಡಿ. ಹಸ್ಬೆಂಡ್ ಆಫ್ ಪೆಟಿಷನರ್ ಪ್ರೆಸೆಂಟ್. ಈಗ ಸೆಟಲ್ಮೆಂಟ್ ಏನಾಯ್ತು?
8 lakhs is the amount which is due. ಅವ್ರು 18 ಕೇಳ್ತಾರೆ ಇಂಟ್ರೆಸ್ಟ್ ಸೇರಿ. ಇಂಟ್ರೆಸ್ಟ್ ಎನ್ನೇ ಆಕ್ಟಲ್ಲಿ ಬರ್ಲಿಕ್ಕೆ
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಆಸ್ ಆಫ್ ನೌ ಮ್ಯಾಟರ್ ಇಸ್ ಅವ್ರು 8 ಲಕ್ಷಕ್ಕೆ ಒಪ್ಕೊಂಡ್ರೆ ನಮ್ಗೇನಿಲ್ಲ, ವಿ ವಿಲ್ ಗಿವ್ ಇಟ್ ಇನ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ಸ್. 8 ಲಕ್ಷಕ್ಕೆ ಅವ್ರು ಒಪ್ಕೊಳ್ತಾರೆ ಅಂತ. He is not the party also. I just want to bring it to court's
Counsel
notice.
for petition present and submits that matter is not settled. List on ಕೊಡಪ್ಪ ಒಂದು date ಕೊಡಿ.
22nd 22/7.
The interim order may be extended, my lords, because she is not the
ಇಲ್ರಿ ಅದ್ರ ಹಿಂದಿನ ಡೇಟ್ ಅಲ್ಲೂ ಆಗಿಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್.
that is why my lords
ಎರಡು ಹಿಯರಿಂಗ್ ಡೇಟ್ ಇಂದನೂ ಆಗಿಲ್ಲ.
ಅವತ್ತು ಒಂದ್ ದಿವಸ my lords
ಅದ್ರ ಹಿಂದಿನ ಡೇಟ್ ಅಲ್ಲೂ ಆಗಿಲ್ಲ.
I was
ಅದ್ರ ಹಿಂದಿನ ಡೇಟ್ ಅಲ್ಲೂ ಆಗಿಲ್ಲ.
ಅಲ್ಲ my lords, it was before Justice Nawaz. On that day
ಪ್ರಸನ್ನ ಸಾಹೇಬರ ಮುಂದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಯ್ತಲ್ಲ, ಅದಾದ್ಮೇಲೆ ಯಾವತ್ತೂ ಆಗಿಲ್ಲ.
my lords, my lords, it has to extend. My lords, I cannot be held accountable for the interim order not being extended.
ನಾನೇನ್ ಮಾಡ್ಲಿ ಅದಕ್ಕೆ? ನೀವು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೋಬೇಕು.
But I apologize, my lords. The interim order may kindly be extended.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಮುಂದಿನ ಸಲ. ಯಾವ ಡೇಟ್ ಕೊಟ್ವಿ?
22nd.
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್?
51.
51.
For no fault, my lord, she has to suffer.
ನಾನೇನ್ ಮಾಡ್ಲಿ ವಕೀಲ್ರೆ? ನೀವು ಅದನ್ನ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಕೋಬೇಕು. Has to be get extended. ನಮ್ ಜವಾಬ್ದಾರಿ ಅಲ್ಲದು.
Very well.
ಹೌದು. ನಾನೇನಾದ್ರೂ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾದ್ರೂ ಬೈ ಮಿಸ್ಟೇಕ್ ಇದಾಗಿದ್ರೆ ಮಾಡ್ತಿದ್ದೆ ನಾನು. ಎಲ್ಲಿಂದ 5-6 ಹಿಯರಿಂಗ್ ಡೇಟ್ಸ್
on that date of hearing itself, my lords, the opposite side also said.
ಯಾವ ಡೇಟ್ ಅಪ್ಪಿದ? 22/7. Yes.
24
obliged.
ಮಂಜುನಾಥ್ ಪ್ರಸಾದ್
54 ರೈಟ್
Officer, complaint.
24.
Office objection complaint. Certified copy.
Non-compliance of ಎರಡು ಮಾಡಿದಾರ? ಎಷ್ಟಿದೆ ಟೋಟಲ್? 3 ಇದೆಯಾ? Learned counsel for petition submits that he has complied with the office objection at serial number 1
Proceedings, we are furnished for proceedings.
And prays for short accommodation to produce the certified copy, na? Certified copy of the up-to-date proceedings. First off, as a last chance, list this matter on.
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕ್ಬೇಕು. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕ್ಬೇಕು.
ಹೀಗೆ ಮಾಡಿ. as a last chance, 2 weeks time granted to comply with the office objection, remaining office objections, failing which necessary orders will be passed for dismissal of the petition. ಇನ್ನೆರಡು ವಾರ ಸಿಕ್ಕಿದೆ ನಿಮಗೆ, ಅದನ್ನ ಮಾಡ್ಕೊಳ್ಳಿ. ಓಕೆ.
My lordship, may I make a submission? Serial number 47 ಅಲ್ಲಿ respondent number 2, my lordship. ನಾನೇ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ 47 ಅಲ್ಲಿ ನಾನೇ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದೆ.
ಇದೆ ಒಂದ್ ನಿಮಿಷ 47. ಏನಾಗಿದೆ ಇದು?
My lordship, ಅದು ಅಜ್ಜನ್ ಆಗಿರ್ಬೇಕು.
ನೀವು ಯಾರಿಗೆ
respondent number 2, my lordship.
Okay.
May I request for Wednesday?
ಒಂದು ಡೇಟ್ ಕೊಟ್ಬಿಡಪ್ಪ ಇದ್ರಲ್ಲೇ.
ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇತ್ತು my lordship, ಹಾಗಾಗಿ.
ಇರಿ ನಾವು ನೋಡಿ ಕೊಡ್ತಿಲ್ಲ.
Please my lordship. ಆಯ್ತು.
ಹಿಂಗೆ ಡೇಟ್ ಹೋಗ್ತಾ ಇರುತ್ತೆ ಅಷ್ಟೇ.
Wednesday ಇಲ್ಲ Thursday?
ಒಂದು ಡೇಟ್ ಹೇಳಪ್ಪ.
14th ಇದೆ.
14th ಬೇಡ my lordship. ಪೂಜೆ ಇದೆ ಮನೆ.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಒಂದು ಕೊಡು.
Next 15th, 16th.
8th, 9th, 10th is also good. 8th, 9th, 10th.
10th.
Please.
10/7.
Much obliged.
Yes. ಆಯ್ತಾ?
Sir, serial 15. 50 serial number.